Chapter X. Of the people, whether aliens, denizens, or natives. Having the 8 preceding chapters treated of persons as they stand in the public relations of magistrates, I now proceed to consider such persons as fall under the denomination of the people. And herein all the inferior and subordinate magistrates treated of in the last chapter are included. The first and most obvious division of the people is into aliens and natural-born subjects. Natural-born subjects are such as are born within the dominions of the Crown of England, that is, within the allegiance, or, as it is generally called, the allegiance of the Queen, and aliens such as are born out of it. Allegiance is the tie or ligamen, which binds the subject to the sovereign, in return for that protection which the sovereign affords the subject. The thing itself, or substantial part of it, is founded in reason and the nature of government. The name and the form are derived to us from our Gothic ancestors. Under the feudal system, every owner of lands held them in subjection to some superior or lord, from whom or whose ancestors the tenant or vassal had received them, and there was a mutual trust or confidence subsisting between the lord and vassal, that the lord should protect the vassal in the enjoyment of the territory he had granted him, and, on the other hand, that the vassal should be faithful to the lord, and defend him against all his enemies. This obligation on the part of the vassal was called his fidelitas or fealty, and an oath of fealty was required, by the feudal law, to be taken by all tenants to their landlord, which is couched in almost the same terms as our ancient oath of allegiance, except that in the usual oath of fealty there was frequently a saving or exception of the faith, due to a superior lord by name, under whom the landlord himself was perhaps only a tenant or vassal. But when the acknowledgment was made to the absolute superior himself, who, aliens, denizens, and natives, was vassal to no man, it was no longer called the oath of fealty, but the oath of allegiance, and therein the tenant swore to bear faith to his sovereign lord, in opposition to all men, without any saving or exception. Contra omnes homines fideliatum fecit. Land held by this exalted species of fealty was called feudum ligum, a liege fee, the vassals homines ligii, or liege men, and the sovereign their dominus ligius, or liege lord. And when sovereign princes did homage to each other for lands held under their respective sovereignties, a distinction was always made between simple homage, which was only an acknowledgment of tenure, and liege homage, which included the fealty before mentioned, and the services consequent upon it. Thus when our Edward Roman III in 1329 did homage to Philip VI of France for his ducal dominions on that continent, it was warmly disputed of what species the homage was to be, whether liege or simple homage. But with us, in England, it becoming a settled principle of tenure, that all lands in the kingdom are holden of the sovereign as lord paramount, no oath but that of fealty could ever be taken to inferior lords, and the oath of allegiance was necessarily confined to the person of the sovereign alone. By an easy analogy, the term of allegiance was soon brought to signify all other engagements which are due from subjects to their prince, as well as those duties which were simply and merely territorial. And the oath of allegiance, as administered for upwards of 600 years, contained a promise to be true and faithful to the king and his heirs, and truth and faith to bear of life and limb and tear and honor, and not to know or hear of any ill or damage intended him, without defending him therefrom. Upon which Sir Matthew Hale makes this remark, that it was short and plain, not entangled with long or intricate clauses or declarations, and yet is comprehensive of the whole duty from the subject to his sovereign. But, at the Bevolution, the terms of this oath being thought perhaps to favor too much the notion of non-resistance, another form was introduced by the Convention Parliament, which is more general and indeterminate than the former, the subject only promising that he will be faithful and bear true allegiance to the king, without mentioning his heirs or specifying in the least wherein that allegiance consists. The oath of supremacy was principally calculated as a renunciation of the Pope's pretended authority, and the oath of abjuration 1 W. and M. Sin. 1c. 8. Allegiance 335 Tian, introduced in the reign of King William, very amply supplied the loose and general texture of the oath of allegiance. For these three oaths ***1 was substituted by the Statute 21 and 22 Vict. c. 48, recognizing the right of the sovereign, abjuring any obedience or allegiance to any other person, and declaring that no foreign prince, prelate, or potentate had or ought to have any jurisdiction or authority, ecclesiastical or spiritual, within the realm. This form has now been abolished, and the oath of allegiance is simply to be faithful and bear true allegiance to the Queen, her heirs and successors according to law. The oath of allegiance may be tendered by two justices of the peace to any person whom they shall suspect of disaffection, and to all persons above the age of 12 years whether natives, denizens, or aliens, either in the court leet of the manor, or in the sheriff's turn, which is the court leet of the county. Modem legislation has permitted affirmations to be made by persons who object to take an oath, has swept away a great many useless oaths, and has relieved the Queen's subjects generally from the penalties and disabilities consequent on their neglect to take the prescribed oaths. Peers and members of Parliament, however, remain liable to a pecuniary penalty if they vote in Parliament without doing so. But, besides these express engagements, the law also holds that there is an implied, original, and virtual allegiance owing from every subject to his sovereign, antecedently to any express promise, and although the subject never swore any faith or allegiance in form. For as the sovereign, by the very descent of the crown, is fully invested with all the rights and bound to all the duties of sovereignty, before his coronation, so the subject is bound to his prince by an intrinsic allegiance, before the superinduction of those outward bonds of oath, homage, and fealty, which were only instituted to remind the subject of this his previous duty, and for the better securing its performance. The formal profession, therefore, or oath of subjection, is nothing more than a declaration in words of what was before implied in law. Which occasion Sir Edward Coke very justly to observe, 13 Will. Roman 3. c. 6. 31 and 32 Vict. O. 72. As modified by 1 An. 1 c. 22, 1 Geo. I. c. 13, 6 Geo. Roman 3. c. 53. 6 An. c. 7, 1 Geo. I. Sin. 2 c. 13, 6 2 Ins. 121, 1 Hull. PO. 64. GTO. Roman 3. c. 53. 7 and 8 Vic. c. 102. 9 and 10 Vic. c. Anot Gir form of oath which might 59, 34 and 35 Vict. c. 48. Be taken by Ilaman Catholics was allowed 15 and id Vict. c. 43. Salamonit v. to be substituted by 30 and 31 Vict. c. 75. Miller 8x. All subjects are equally bounden to their allegiance, as if they had taken the oath, because it is written by the finger of the law in their hearts, and the taking of the corporal oath is but an outward declaration of the same. The sanction of an oath, it is true, in case of violation of duty, makes the guilt still more accumulated, by superadding perjury to treason, but it does not increase the civil obligation to loyalty, it only strengthens the social tie by uniting it with that of religion. Allegiance, both expressed and implied, is however distinguished by the law into two sorts or species, the one natural, the other local, the former being also perpetual, the latter temporary. Natural allegiance is such as is due from all men born within the sovereign's dominions immediately upon their birth, for immediately upon their birth they are under the protection of the crown. At a time too, when, during their infancy, they are incapable of protecting themselves. Natural allegiance is therefore a debt of gratitude, which, by our common law, cannot be forfeited, cancelled, or altered by any change of time, place, or circumstance, nor by anything but the united concurrence of the legislature. An Englishman who removes to France or to China owes the same allegiance to the crown of England there is at home, and 20 years hence as well as now. For it is a principle of universal law that the natural-born subject of one prince cannot by any act of his own, no, not by swearing allegiance to another, put off or discharge his natural allegiance to the former, for this natural allegiance was intrinsic and primitive, and antecedent to the other, and cannot be divested without the concurrent act of that prince to whom it was first due. The legislature has, however, thought fit to modify materially this rule of law. Any person, who by reason of having been born within the dominions of the crown is a natural-born subject, but who also at the time of his birth became, under the law of any foreign state, a subject of that state, may, if of full age, make a declaration of alienage and cease to be a British subject. The son of a British subject, who is prima facie a subject of the realm, wherever born, may also in the same way renounce his nationality. There is obviously some reason for enabling persons owing a double allegiance, so to speak, to make choice of one. The law, however, goes much further. For any 2p. WMS 124. M. Donald, Foster, C. L. 184. 1 Hell. P. C. 68. Case of Ennius. 33 Vict. C. 14. Local allegiance. 337 British subject who chooses to be naturalized in a foreign state is now deemed an alien. But this kind of statutory alien may be readmitted to British nationality in the same way that an alien is naturalized by certificate from the Secretary of State. A married woman is deemed a subject of the state of which her husband is a subject, but if a natural-born subject, she also is deemed only a statutory alien, and may, at any time during widowhood, be readmitted to her British nationality. Local allegiance is such as is due from an alien, or stranger-born, for so long time as he continues within the Queen's dominion and protection, and it ceases the instant such stranger transfers himself from this kingdom to another. Local allegiance is therefore temporary only, and that for this reason, evidently founded upon the nature of government, that allegiance is a debt due from the subject, upon an implied contract with the prince, that so long as the one affords protection, so long the other will demean himself faithfully. As therefore the prince is always under a constant tie to protect his natural-born subjects at all times and in all countries, for this reason their allegiance due to him is equally universal and permanent. But, on the other hand, as the prince affords his protection to an alien only during his residence in this realm, the allegiance of an alien is confined, in point of time, to the duration of such his residence, and, in point of locality, to the dominions of the crown. From which consideration Sir Matthew Hale deduces this consequence, that, though there be an usurper, yet it is treason for any subject, while the usurper is in full JWS cession of the sovereignty, to practice anything against his crowei and dignity. Wherefore, although the true prince regain the sovereignty, yet such attempts against the usurper, unless in defense or aid of the rightful king, have been afterwards punished with death, because of the breach of that temporary allegiance which was due to him as king de facto. And upon this footing, after Edward Roman IV recovered the crown, which had been long detained from his house by the line of Lancaster, treasons committed against Henry VI were capitally punished, though Henry had been declared an usurper by Parliament. This oath of allegiance, or father the allegiance itself, is held to be applicable not only to the political capacity of the sovereign, or regal office, but to his natural person and blood royal. Vol. I. C. 338 aliens, denizens, and natives. And for the misapplication of their allegiance, viz. To the regal capacity or crown exclusive of the person of the king, were the Spencers banished in the reign of Edward Roman II. And from hence arose that principle of personal attachment and affectionate loyalty which induced our forefathers, and if occasion required would doubtless induce their sons, to hazard all that was dear to them, life, fortune, and family, in defense and support of their liege lord and sovereign. This allegiance then, both express and implied, is the duty of all the Queen's subjects, under the distinctions here laid down, of local and temporary, or universal and perpetual. Their rights are also distinguishable by the same criterions of time and locality, natural-born subjects having a great variety of rights, which they acquire by being born within the Queen's allegiance and can never forfeit by any distance of place or time, but only by their own misbehavior, the explanation of which rights is the principal subject of the 2 first books of these commentaries. The same is also in some degree the case of aliens, though their rights are more circumscribed, being acquired only by residence here, and lost whenever they remove. I shall, However, here endeavor to chalk out some of the principal lines whereby they are distinguished from natives, descending to farther particulars when they come in course. An alien born may now buy. The Statute 33 Vict. c. 14. Take, acquire, hold, and dispose of lands or other estates * in all respects as a natural-born subject. At common law, confirmed by the same statute, he can acquire a property in goods, money, and other personal estate, or may hire a house for his habitation. For personal estate is of a transitory and movable nature. This indulgence was considered necessary for the advancement of trade. And for this reason, apparently, an alien was authorized by the Statute 7 and 8 Vict. c. 66 s. 4 now. At common law an alien might his own natural liege lord, besides that purchase, but could not bold, for that thereby the nation might in time be subgrown was at once entitled to subject to foreign influence, and feel many lauds. If it was argued an alien could other inconveniences. Wherefore by the acquire a permanent property in lands, civil law such contracts were also made he must owe an allegiance, equally pervoid. But the prince had no such admeanant with that property, to the king vantage of forfeiture thereby as with us of England, which would probably be in England, inconsistent with that which he owed to. Disabilities and bites of aliens. 339 superseded in effect to take and hold lands or houses for the purpose of carrying on any business or manufacture, for any term not exceeding 21 years, as fully and effectually as if he were a natural-born subject. For aliens might always trade as freely as other people. And an alien might bring an action concerning personal property, and might make a will, and dispose of his personal estate. When I mention these rights of an alien, I must be understood of alien friends only, or such whose countries are in peace with ours. For alien enemies have no rights, no privileges unless by the special favor of the crown or express legislative enactment. During the time of war, when I say that an alien is one who is balm out of the sovereign's dominions or allegiance, this also must be understood with some restrictions. The common law indeed stood absolutely so, with only a very few exceptions, so that a particular Act of Parliament became necessary after the Restoration, for the naturalization of children of His Majesty's English subjects born in foreign countries during the late troubles. And this maxim of the law proceeded upon a general principle that every man owes natural allegiance where he is born, and cannot owe two such allegiances or serve two masters at once. Yet the children of ambassadors born abroad were always held to be natural-born subjects, for as the father, though in a foreign country, owes not even a local allegiance to the prince to whom he is sent, so, with regard to the son also he was held, by a kind of postliminium, to be born under the King of England's allegiance, represented by his father, the ambassador. To encourage also foreign commerce, it was enacted by Statute 25 Edw. Roman 3. Sin. 2. That all children born abroad, provided hoth their parents were at the time of the birth in allegiance to the king, and the mother had passed the seges by her husband's consent, might inherit as if born in England, and accordingly it has been so adjudged in behalf of merchants. But by several more modern statutes * these restrictions where aliens were formerly subject to lutwa. 34. Formerly in France the certain higher duties at the custom king, at the death of an alien, was an house. There were also some statutes of title to all he was worth by the droit Henryii prohibiting alien artificers Tattleine or jus albonatus, unless he had to work for themselves in this kingdom, a peculiar exemption, but it is generally held that they were *stat. 29 Car. Roman 2. c. 6, virtually repealed by the Statute 5 Aliz. Pro. Car. 601, Mar. 91, Cheng. Sen. 3c. 7, 7n, c. 5, 4 Geo. Roman 2. c. 21, and 340 aliens, denizens, and natives. Still further taken off, so that all children, born out of the king's allegiance, whose fathers or grandfathers by the father's side were natural-born subjects, are now deemed to be natural-born subjects themselves to all intents and purposes, unless their said ancestors were attainted, or banished beyond sea, for high treason, or were at the birth of such children in the service of a prince at enmity with Great Britain. The children of aliens, born here in England, are, generally speaking, natural-born subjects and entitled to all the privileges of such. In which the Constitution of France differs from ours, for there, by their jussul hinitus, if a child be born of foreign parents, it is an alien. A denizen is an alien born, but who has obtained ex domation legis letters patent to make him an English subject. He occupied formerly a kind of a middle state between an alien and natural-born subject, and partook of both of them. He might take lands by purchase or devise, which an alien could not until the law was altered. But a denizen could not take by inheritance. For his parent, through whom he must have claimed, being an alien, had no inheritable blood, and therefore could convey none to the son. And upon a like defect of hereditary blood, the issue of a denizen, born hef or denization, could not inherit to him, but his issue balm after might. No denizen could or can, for the right of the crown to grant letters of denization is still preserved, be of the Privy Council, or either House of Parliament, or have any office of trust, civil or military, or be capable of any grant of lands and sea. From the crown. Naturalization, properly so called, cannot be performed but by act of Parliament, for by this an alien is put in exactly the same state as if he had been born in the king's ligeance, except only that he is incapable, as well as a denizen, of being a member of the Privy Council or Parliament, and of holding offices. 13 Geo. Roman 3. c. 21. Sleeden v. Patrick, who marries a British subject, is de facto 1 Macqueen Rep. 535. Naturalize the children born abroad of a mother. Jenk. Sen. 3. Cites Treasure Franfois, who is a natural-born subject, were made 312. But the child may, within one capable of taking any real or personal year after attaining 21, elect a state by devise, purchase, or succession, France for his country. Code Civil 1. I. By statute, but this act is now superti. 1 S. 9. Seated by the enactment already quoted. 7 Rep. Calvin's case 25. From 33 Vict. c. 14. An alien woman stat. 12 Will. Roman 3. c. The Jews. 341 grants and c. And consequently, no bill for naturalization can be received in either House of Parliament without such disabling clause in it, nor without a clause disabling the person from obtaining any immunity in trade thereby in any foreign country, unless he shall have resided in Britain for 7 years next after the commencement of the session in which he was naturalized. Neither formerly could any person be naturalized or restored in blood, unless he had received the sacrament of the Lord's Supper within 1 month before the bringing in of the bill, and unless he also took the oaths of allegiance and supremacy in the presence of the Parliament. But these provisions were usually dispensed with by special acts of Parliament, previous to bills of naturalization of any foreign princes or princesses, and they have recently been indirectly but substantially repealed. These are the principal distinctions between aliens, denizens, and natives, distinctions which it has been frequently endeavored since the commencement of the last century to lay almost totally aside, by one general naturalization act for all foreign Protestants. An attempt which was once carried into execution by the Statute 7 N. c. 5, but this after 3 years. Experience of it was repealed by the Statute 10 N. c. 5 except one clause, which was just now mentioned, for naturalizing the children of English parents born abroad. The legislature has now, however, authorized the Home Secretary to grant to alien friends, who have either been resident in this country, or in the service of the Crown for 5 years, a certificate of naturalization, which confers on the grantee, on his taking an oath of allegiance and fidelity, all the political and other rights, powers, and privileges of a natural-born British subject. Formerly, every foreign seaman, who in time of war served 2 years on board an English ship by virtue of the King's proclamation, was ipso facto naturalized. All foreign Protestants and Jews, upon their residing 7 years in any of the American colonies, without being absent above 2 months at a time, and all foreign Protestants serving 2 years in a military capacity there, or being 3 years employed in the whale fishery, without afterwards absenting equals stat. 12 will. Roman 3, c. 2, stat. 7 jack, I c. 2. Stiv. 1 dio. IBT. 2c. 4, 7 and 8 vic. By the statute 7 and 8 vict. c. 66c. GG 8, 2, 8, 1. Flat. HGO. Roman 3, c. 84. Sla. 13 gu. Roman 2. c. 3, 33 vict. c. Aliens, denizens and natives, themselves from the king's dominions for more than 1 year and none of them falling within the incapacities declared by statute 4 Geo. Roman 2. c. 21, were, upon taking the oaths of allegiance and abjuration, or, in some cases, an affirmation to the same effect, naturalized to all intents and purposes as if they had been born in this kingdom, except as to sitting in Parliament, or in the Privy Council, and holding offices or grants of lands and sea-da from the Crown, within the kingdoms of Great Britain or Ireland. They therefore were admissible to all other privileges which Protestants or Jews born in this kingdom are entitled to. What those privileges are, with respect to Jews registered in particular, was the subject of very high debates about the time of the famous Jew Bill, which enabled all Jews to prefer bills of naturalization in Parliament, without receiving the sacrament, as ordained by Statute 7 Jac. This act lived only a few months, being then, in deference to popular clamor, repealed so that all Jews remained excluded from Parliament, by reason of their inability to take the oath of abjuration and from civic office because they could not partake of the sacraments of the Church. When on the repeal of the Corporation and Test Acts by the Statute 9 Geo Roman 4. c. 17, a declaration was substituted in all cases in which the sacrament was then required to be taken, it was thought that all disabilities on the ground of religious belief had been removed. But as the Act required the declaration to be made, in the same terms in which only the oath of abjuration could then be taken, namely, on the true faith of a Christian, Jews remained excluded as before from the enjoyment of the two most important rights of their fellow subjects. One of these grievances was got rid of by the Statute 8 and 9 Vict. c. 52, which first provided a special form of declaration to be taken by Jews elected to municipal offices. The Statute 23 and 24 Vict. c. 63 grudgingly removed the other disability under which they labored, by permitting the House of Commons to receive the oath of a Jew, returned to serve in Parliament, without its concluding sentence. Stat. 13 Geo. Roman 2. c. 7, 26 Geo. Roman 2. c. s. G. Tat. 27 Geo. Roman 2. c. 1, 44, 22 Geo. Roman 2. c. 45, 2 Geo. Roman 3. c. 25. As provided by the Statutes 3 Jac. 13 Geo. Roman 3. c. 25. c. 4, 7 Jac. IC. 6 S. 2, 30 Car. Roman 2. Sen. 2. A pretty accurate account of the c. 1, 13 and 14 will. Roman 3. c. 6, 1 and sin. Jews till their banishment in 8 Edwa. 1 c. 22, 6 and c. 7, 1 Geo. I sent. 2 c. may be found in Prince Demur and 13, 6 Geo. Roman 3. c. 53. In Malloy, de jure maritimo, b. 3 c. 6, 6 Tio. Roman 3. c. 53, 9 Geo. Roman 4. c. 17, F stat. 26 Geo. Roman 2. c. 26. Salomons v. Miller 8x. 778. 343. Chapter Roman 11. Of the clergy. The people, whether aliens, denizens, or natural-born subjects, are divisible into two kinds: the clergy and the laity. The clergy, comprehending all persons in holy orders and in ecclesiastical offices, will be the subject of the following chapter. This venerable body of men, being separate and set apart from the rest of the people, in order to attend the more closely to the service of Almighty God, have thereupon large privileges allowed them by our municipal laws, and had formerly much greater, which were abridged at the time of the Reformation on account of the ill use which had been made of them. For, the laws having exempted them from almost every personal duty, they attempted a total exemption from every secular tie. But it is observed by Sir Edward Coke, that, as the overflowing of waters doth many times make the river to lose its proper channel, so in times past ecclesiastical persons, seeking to extend their liberties beyond their true bounds, either lost or enjoyed not those which of right belonged to them. The personal exemptions do indeed for the most part continue. A clergyman cannot be compelled to serve on a jury, nor to appear at a court leet or view of frank pledge, which almost every other person is obliged to do. But if a layman is summoned on a jury, and before the trial takes orders, he shall notwithstanding appear and be sworn . Neither can he be chosen to any temporal office, as bailiff, reeve, constable, or the like, in regard of his own continual attendance on the sacred function. During his attendance on divine service he is privileged from arrest in civil suits registered *, the infraction of this privilege being in 2 inst. 4. Finch, L. 88. 52 Hen. High. C. 10. Stat. 50 Edwa. Roman 3. C. 5. 1 Kick. Roman 2. 4 Loon. 190. The Juries Act, 870. C. Clergy. Indictable misdemeanor. But as they have their privileges, so also they have their disabilities, on account of their spiritual avocations. Clergymen are incapable of sitting in the House of Commons * or of being councillors or aldermen in boroughs. By statute 21 Hen. Roman 8. C. 13, they were not, in general, allowed to take any lands or tenements to farm, upon pain of LOZ per month, and total avoidance of the lease, nor upon like pain to keep any tan house or brew house, nor to engage in any manner of trade, nor sell any merchandise, under forfeiture of the treble value, which prohibition was consonant to the canon law. And although that statute has been repealed, yet new provisions equally stringent prohibit trading by spiritual persons, with certain exceptions. Thus no spiritual person is permitted to farm more than 80 acres, without the consent of the ordinary, nor to be a partner in any trade or dealing for profit, unless it be carried on by the other partners. In such cases of partnership no spiritual person can be a director or managing partner, but he may carry on the business of a schoolmaster, or be a director or partner in any benefit or insurance society. He may buy or sell to the extent incidental to his occupation of land, but cannot do so in person or at a public market. In the frame and constitution of ecclesiastical polity there are divers ranks and degrees, which I shall consider in their respective order, merely as they are taken notice of by the secular laws of England, without intermeddling with the canons and constitutions by which the clergy have bound themselves. And under each division I shall consider 1. The method of their appointment, 2. Their rights and duties, and 3. The manner wherein their character or office may cease. I. An archbishop or bishop is elected by the chapter of his cathedral church, by virtue of a license from the crown. Election was, in very early times, the usual mode of elevation to the episcopal chair throughout all Christendom, and this was promiscuously performed by the laity as well as the clergy. 24 and 25 Vic. C. 100 A. 36. In cases 5 and 6 will. Roman 4. C. 76 S. 28. A felony, a clerk in orders. Formerly. 57 Dio. Roman 3. C. 99. Had the benefit of his clergy, without 1 and 2 Vict. CC. 10 and 106 and 4 and being branded in the hand, and might. 5 Vict. C. 14. Likewise have it more than once, in proclaret populum. Pom. 25, both of which particulars he was dis to roll, kep. 102, Mat. Par. A.D. 1095. Distinguished from a layman. The archbishops and bishops. 345 Length it becoming tumultuous, the emperors and other sovereigns of the respective kingdoms of Europe took the appointment in some degree into their own hands, by reserving to themselves the right of confirming these elections and of granting investiture of the temporalities, which now began almost universally to be annexed to the spiritual dignity, without which confirmation and investiture the elected bishop could neither be consecrated nor receive any secular profits. This right was acknowledged in the Emperor Charlemagne, A.D. 773, by Hadrianite and the Council of Lateran, and universally exercised by other Christian princes. But the policy of the Court of Combe at the same time began by degrees to exclude the laity from any share in these elections, and to confine them wholly to the clergy, which at length was completely effected, the mere form of election appearing to the people to be a thing of little consequence, while the crown was in possession of an absolute negative, which was almost equivalent to a direct right of nomination. Hence the right of appointing to bishoprics is said to have been in the crown of England * as well as other kingdoms in Europe, even in the Saxon times, because the rights of confirmation and investiture were in effect, though not in form, a right of complete donation. But when, by length of time, the custom of making elections by the clergy only was fully established, the popes began to accept to the usual method of granting these investitures, which was per annulum et helum, by the princes delivering to the prelate a ring, and pastoral staffi or crozier, asserting that this was an encroachment on the church's authority, and an attempt by these symbols to confer a spiritual jurisdiction. And Gregory Roman VII, towards the close of the 11th century, published a bull of excommunication against all princes who should dare to confer investitures, and all prelates who should venture to receive them. This was a bold step towards effecting the plan then adopted by the Roman See, of rendering the clergy entirely independent of the civil authority, and long and eager were the contests occasioned by this papal claim. But at length, when the Emperor Henry V agreed to remove all suspicion of encroachment on the spiritual character, by conferring investitures for the future per sceptrum and not per annulum et haculum, and asterisk decret. 1. Diet 63, c. 22. Selken Chan. Aug. L1, section 39. Pom. 28, Decret 2 Caus. 16. 7c. Clergy. When the kings of England and France consented also to alter the form in their kingdoms, and receive only homage from the bishops for their temporalities, instead of investing them by the ring and crozier, the court of Eom found it prudent to suspend for a while its other pretensions. This concession was obtained from Henry I, in England, by means of that obstinate and arrogant prelate, Archbishop Anselm. But King John, about a century afterwards, in order to obtain the protection of the Pope against his discontented barons, was also prevailed upon to give up, by a charter, to all the monasteries and cathedrals in the kingdom, the free right of electing their prelates, whether abbots or bishops, reserving only to the crown the custody of the temporalities during the vacancy, the form of granting a license to elect, which is the original of our Conde de Lier, on refusal whereof the electors might proceed without it, and the right of approbation afterwards, which was not to be denied without a reasonable and lawful cause. This grant was expressly recognized and confirmed in John's Magna Charta, and was again established by Statute 25 Edwa. Roman 3. Sin. 6 S. 3. But by Statute 25 Hen. Roman 8. C. 20 The ancient right of nomination was, in effect, restored to the crown, it being enacted that, at every future avoidance of a bishopric, the king may send the dean and chapter his usual license to proceed to election, which is always to be accompanied with a letter missive from the king, containing the name of the person whom he would have them elect. And if the dean and chapter delay their election above 12 days, the nomination shall devolve to the king, who may by letters patent appoint such person as he pleases. This election or nomination, if it be of a bishop, must be signified by the king's letters patent to the archbishop of the province, if it be of an archbishop, to the other archbishop and 2 bishops, or to 4 bishops, requiring them to confirm, invest and consecrate the person so elected, which they are bound to perform immediately, without any application to the See of Culm. After which the bishop-elect shall sue to the king for his temporalities, shall make oath to the king and none other, and shall take restitution of his secular possessions out of the king's hands only. And if such M. Paris, A.D. 1107. Revived by 1 and 2 p. and M.C. 8 and 1 p.m. Paris, A.D. 1214. 1 Rem. Fodged. Aliz. C. 1. C as to the bishoprics 1198. Alleged to be donative 12 Rep. 7 and T. Repealed by 1 Edwa. VI. C. 2. But hard. Co. Lit. 134 N. Archbishops and bishops. 347 Dean and chapter do not elect in the manner by this act appointed, or if SNCH archbishop or bishop do refuse to confirm, invest and consecrate such bishop-elect, they shall incur all the penalties of a premunire. J. An archbishop is the chief of the clergy in a whole province, and has asterisk by his visitation the inspection of the bishops of that province, as well as of the inferior clergy. The archbishop has also his own diocese, wherein he exercises episcopal jurisdiction, as in his province he exercises archiepiscopal. X\s archbishop he, upon receipt of the sovereign's writ, calls the bishops and clergy of his province to meet in convocation, but without this writ he cannot assemble them. To him all appeals are made from inferior jurisdictions within his province, and as an appeal lies from the bishops in person to him in person, so it also lies from the consistory courts of each diocese to his archiepiscopal court. During the vacancy of any see in his province, he is guardian of the spiritualities thereof, as the crown is of the temporalities, and he executes all ecclesiastical jurisdiction therein. If an archiepiscopal see be vacant, the dean and chapter are the spiritual guardians, ever since the awful BCE of Prior of Canterbury was abolished at the Reformation. The archbishop is entitled to present by lapse to all the ecclesiastical livings in the disposal of his diocesan bishops, if not filled within 6 months. And the archbishop has a customary prerogative, when a bishop is consecrated by him, to name a clerk or chaplain of his own to be provided for by such suffragan bishop, in lieu of which it is usual for the bishop to make over by deed to the archbishop, his executors and assigns, the next presentation of such dignity or benefice in the bishop's disposal, within that see as the archbishop himself shall choose, which is therefore called his option. Which options are only binding on the bishop himself who grants them, and not on his successors. The prerogative itself seems to be derived from the legatine power formerly annexed to the Metropolitan of Canterbury. And we may add that the papal claim itzique, like most others of that encroaching see, was probably set up in imitation of the imperial prerogative called primas or pri mari expresses, whereby the emperor exercised a right of naming to the Queen v. the Archbishop of Cannes 4 Ains 822, 323. Turberry 11q. B. 483. The case of Dr. 2 Roll. Aber. 223. Hampton, by Richard Jebb, S. Lawn. Cowles Torpor. Tit. Option. Don. 1849. Sherlock of Options. The first prebend that became vacant after his accession in every church of the empire. A right that was also exercised by the Crown of England in the reign of Edward I. F. and which probably gave rise to the royal cordies which were mentioned in a former chapter. It is likewise the privilege, by custom, of the Archbishop of Canterbury to crown the kings and queens of this kingdom, and he has also by the statute 25 Hen. Ei. C. 21. The power of granting dispensations in any case not contrary to the Holy Scriptures and the law of God, where the Pope used formerly to grant them, which is the foundation of his granting special licenses to marry at any place or time to hold 2 livings. And the like. and on this also is founded the right he exercises of conferring degrees, in prejudice of the two universities. The power and authority of a bishop, besides the administration of certain holy ordinances peculiar to that sacred order, consist principally in inspecting the manners of the people and clergy, and punishing them in order to reformation, by ecclesiastical censures. And in the case of the clergy, by suspension and deposition. To this purpose he has several courts under him, and may visit at pleasure every part of his diocese, his chancellor being appointed to hold his courts for him, and to assist him in matters of ecclesiastical law. Dufresne, v. 806. Jurisdiction in matrimonial suits to the Brev. 11 Edwa. I. 3 Prin. 1264. Court for divorce, the power of both wife or geo. Roman 4. C. 76 S. 20. Courts being now exercised by the High *1 and 2 Vict. C. 106 S. 6. 13 and 14 Court of Justice. Vict. C. 98. Over his clergy, however, the jurists see the Bishop of Chester's case. Diction of the bishop remains unimpaired. Oxon. 1721. These are generally called teli mode of proceeding against clerical Lambeth decrees. Offenders being now regulated in most all ecclesiastical suits, w lither of a cases by the statute 3 and 4 Vict. C. 86. Spiritual or temporal nature, wherefore under this statute the bishop, when a merely cognizable in the court's Christian, clerk and holy orders is charged with any but their jurisdiction has been gradually offence against the laws ecclesiastical, or reduced to the cognizance of a few there exists any scandal or evil report pecuniary causes, and to certain formal concerning may issue a commission, proceedings in which the clergy and if he thinks fit, beg, v. Bishop of Chithair officers alone are interested. This Chester, 2L and L, 209. To 5 persons arose, in the first instance, from the entire of whom one must be the vicar general, disuse of the censures of the church, or an archdeacon or rural dean of the most salute enanx in the case of the lady, diocese, directing them to make inquiry but more recently from the transfer of as to the grounds of the charge or report. The cognizance of causes testamentary of this commission notice must be given to the court of probate, and of it to the person charged, for, unless he, the archbishops and bishops. 349 It is also the business of a bishop to institute, and to direct induction to all ecclesiastical livings in his diocese. To execute makes a special application to have the proceedings followed out in private. It is the duty of the commissioners to hold a public inquiry, and to examine witnesses, in either case, as well on behalf of the complainant as of the defendant. The commissioners have then to decide, if necessary by a majority, whether there be or be not sufficient JRT and W/E ground for adopting further proceedings, and to transmit their report to the bishop. And if they report that there is sufficient prima facie ground for instituting proceedings, the bishop, with the consent of the defendant, may then at once give such judgment as in the circumstances is proper, not exceeding, however, that which might be pronounced in due course of law. If the defendant does not consent to the report of the commissioners being acted upon, and the bishop or complainant thinks fit to proceed, articles are drawn up to which the defendant must make answer before the bishop, who may, pending the proceedings, inhibit him from performing the services of the church. If the defendant admits the truth of the articles, the bishop, or his commissary officially appointed, may at once pass sentence. If he does not appear, or if appearing he does not make unqualified admission of the truth of the articles, the bishop proceeds, with the assistance of 3 assessors nominated by him, to hear and determine the cause, and give judgment according to the ecclesiastical law. But either in the first instance, or after the report of the commissioners and before the filing of the articles, the bishop may, if he thinks fit, send the case to Teli Court of Appeal of the province to be there determined, and in all cases where he is the patron of any preferment held by the alleged offender, the archbishop of the province acts in his stead ex partes denizen, 4e and b. 292. From Teli judgment pronounced by the bishop in appetite lies to the archbishop in the court of the province, and from that court to Teli queen and council, in the same way as if the cause has been therein heard and determined in the first instance. This is now the only method of prosecuting beneficed clerks, as no criminal suit or proceeding for any offence against the laws ecclesiastical, can be instituted in any ecclesiastical court otherwise than as prescribable by the statute I have referred to. Civil rights are not, it AUDIOBOOK, in any way interfere with, nor does the act affect any authority over their clergy, which the archbishops or bishops may exercise without process. Dean of your VT case 2Q, B. 1. Where the complaint relates to certain details in the performance of divine service, proceedings may be taken under the Public Worship Regulation Act 1875, which enables the archdeacon, or a churchwarden, or any 3 parishioners, or in the case of cathedral or collegiate churches, any 3 inhabitants, to make a representation to the bishop that an alteration or an addition to telio fabric, ornaments, or furniture of telio church has been made without ouarity, or that the incumbent has within 12 months used or permitted any unlawful ornament, or neglects to use any prescribed ornament or vesture, or that the incumbent has within 12 months failed to observe the rubrics of the Book of Common Prayer, or made an unlawful addition to, alteration of, or omission from the prescribed services, rites, or ceremonies of the churchly. On receipt of this representation, the bishop, unless he shall be of opinion that proceedings ought not to be taken upon it, must send a copy to the person complained of, and require him and the complainant to state in writing whether or not they are willing to submit to the directions of himself on the matter of the representation without appeal. If both parties are willing to do so, the bishop is bound to hear the complaint and give. 350. The clergy. Writs of sequestration of the profits of benefices issued by the High Court of Justice and to license in the first instance and, if necessary, withdraw, subject to appeal to the archbishop, the license and regulate the stipends of curates. Archbishoprics and bishoprics may become void by death, deprivation for any very gross and notorious crime, and also by resignations. All resignations must be made to some superior. Therefore a bishop ought to resign to his metropolitan, but may to the crown. The archbishop can resign to none but the sovereign himself. Roman 2. A dean and chapter are the council of the bishop, to assist him with their advice in affairs of religion, and also in the temporal concerns of his see. When the rest of the clergy were settled in the several parishes of each diocese, as has formerly been mentioned, these were reserved for the celebration of divine service in the bishop's own cathedral, and the chief of them, who presided over the rest, obtained the name of dienis or dean, being probably at first appointed to superintend 10 canons or prebendaries. All ancient deans were elected by the chapter, by conge de cellare from the crown, and letters missive of recommendation, in the same manner as bishops, but are now appointed directly by the sovereign by letters patent. In those chapters that were a final judgment thereon, which, however, decision by monition and inhibition, does not decide any question of law, so which, if it remain in force for 3 that it may not be raised by other parties, years makes the benefice void. If the parties do not desire to submit degrees 1 and 2 vict. C. 106 S. 98. The matter to the final decision of the resignation of an archbishop or bishop, either in this way or by agreeing bishop in a province, is now provided for upon a special case for the opinion of the by 32 and 3.3 vict. C. 111. Court of the province Tli complaint is anciently, in the case of the incat transmitted to the archbishop to be passity of a bishop from infirmity or heard in the court of the province, the absence, his duties were committed to person complained of being required to a suffragan bishop, 1 Bern, Eccles, make answer to the representation for L. 246. The appointment of a J bishop otherwise he is deemed to admit the coadjutor, in such circumstances is now truth and the relevancy of the charge provided for by 32 and 33 vict. C. 111. This therein contain. The hearing of the act was originally for 2 years. It was complaint is in open court. The evidence continued by 35 and 36 vict. C. 40. Being given viva, voce, and upon oath. Free rep. 75. Co. Lit. 103. 300. The court having for this purpose all the S3 and 4 yict. C. 113 S. 24. This necessary powers to compel the attendant prescribes the qualifications for ants of witnesses and the production of the office, and provides for the appoint books and documents, and to enforce its ment of minor and honorary canons. archdeacons, worlddeans, etc. 351 founded by Henry Roman VIII. Out of the spoils of the dissolved monasteries, the deanery has always been donative, and the installation merely by the royal letters patent. The chapter, consisting of canons or prebendaries, are sometimes appointed by the crow percent vien, sometimes by the bishop, and sometimes elected by each other. The dean and chapter are, as was before observed, the nominal electors of a bishop. The bishop is their ordinary and immediate superior, and has, generally speaking, the power of visiting them and correcting their excesses and enormities. They had also a check on the bishop at common law, for till the statute 32 hen. Roman 8. c. 28, his grant or lease would not have bound his successors unless confirmed by the dean and chapter. Deaneries and prebends may become void, like a bishopric, by death, by deprivation, or by resignation to either the crown or the bishop. Also I may here mention once for all, that if a dean, prebendary, or other spiritual person be made a bishop of the Church of England, all the preferments of which he was before possessed are void, and the crown may present to them in right of the prerogative royal, but they are not void by the election, but only by the consecration. Roman 3. An archdeacon has an ecclesiastical jurisdiction, immediately subordinate to the bishop, throughout the whole of his diocese, or in some particular part of it. He is usually appointed by the bishop himself, and has a kind of episcopal authority, originally derived from the bishop, but now independent and distinct from his. He therefore visits the clergy, and has his separate court for punishment of offenders by spiritual censures and for hearing all other causes of ecclesiastical cognizance. Roman 4. The rural deans are very ancient officers of the Church, but almost grown out of use, though their deaneries still subsist as an ecclesiastical division of the diocese, or archdeaconry. They seem to have been deputies of the bishop, planted all round his diocese, the better to inspect the conduct of the parochial clergy, to inquire into and report dilapidations, and to examine the candidates for confirmation, and armed, in minuter matters, with an inferior degree of judicial and coercive authority. Gibbs, Code 1, 173. Wool. Roman 4. c. 77a, 19. Red. V. College of Eton 8L, NBL, 106. Kennet Parr, Antic. 633. I1 Burn, Eckel, Law, 68, 69, 6 and 7. Gibbs. Con. 1972, Wavmafan IFT. The clergy. The next, and indeed the most numerous, order of men in the system of ecclesiastical polity are the parsons and vicars of churches. In treating of whom I shall first mark out the distinction between them, shall next observe the method by which one may become a parson or vicar, shall then briefly touch upon their rights and duties, and shall, lastly, show how one may cease to be either. A parson, persona ecclesiae, is one that has full possession of all the rights of a parochial church. He is called parson, persona, because by his person the church, which is an invisible body, is represented, and he is in himself a body corporate, in order to protect and defend the rights of the church, which he personates. By a perpetual succession. Trade he is sometimes called the rector or governor of the church. But the appellation of parson, however it may be depreciated by familiar, clownish, and indiscriminate use, is the most legal, most beneficial, and most honorable title that a parish priest can enjoy, because such a one, Sir Edward Coke observes, and he only, is sed vicem sen personam ecclesiae gerer. A parson has, during his life, the freehold in himself of the parsonage house, the glebe, the tithes, and other dues. But these are sometimes appropriated, that is to say, the benefice is perpetually annexed to some spiritual corporation, either sole or aggregate, being the patron of the living, which the law esteems equally capable of providing for the service of the church as any single private clergyman. This contrivance seems to have sprung from the policy of the monastic orders, who have never been deficient in subtile inventions for the increase of their own power and emoluments. At the first establishment of parochial clergy, the tithes of the parish were distributed in a fourfold division, one for the use of the bishop, another for maintaining the fabric of the church, a third for the poor, and a fourth to provide for the incumbent. When the sees of the bishops became otherwise amply endowed, they were prohibited from demanding their usual share of these tithes, and the division was into 3 parts only. And hence it was inferred by the monasteries that a small part was sufficient for the officiating priest, and that the remainder might well be applied to the use of their own fraternities, the endowment of which was construed to be a work of the most exalted piety, subject to the burden of repairing the lit. Parsons and vicars. 353 Church, and providing for its constant supply. And therefore they begged and bought, for masses and abbots, and sometimes even for money, all the advocens within their reach, and then appropriated the benefices to the use of their own corporation. But in order to complete such appropriation effectually, the license of the crown and consent of the bishop must first be obtained. Because both the king and the bishop may some time or other have an interest, by lapse, in the presentation to the benefice, which can never happen if it be appropriated to the use of a corporation, which never dies. And also because the law reposes a confidence in them, that they will not consent to anything that shall be to the prejudice of the church. The consent of the patron also is necessarily implied, because, as was before observed, the appropriation can be originally made to none, but to such spiritual corporation, as is also the patron of the church, the whole being indeed nothing else but an allowance for the patrons to retain the tithes and glebe in their own hands without presenting any clerk, they themselves undertaking to provide for the service of the church. When the appropriation is thus made, the appropriators and their successors are perpetual parsons of the church, and must sue and be sued, in all matters concerning the rights of the church, by the name of parsons. This appropriation may be severed, and the church become disappropriate, 2 ways. As first, if the patron or appropriator presents a clerk who is instituted and inducted to the parsonage. For the incumbent so instituted and inducted is to all intents and purposes complete parson, and the appropriation, being once severed, can never be reunited again, unless by a repetition of the same solemnities. And, when the clerk so presented is distinct from the vicar, the rectory thus vested in him becomes what is called a sinecure, because he has no cure of souls, having a vicar under him to whom that cure is committed. Also, if the corporation which has the appropriation is dissolved, the parsonage becomes disappropriate at common law, because the perpetuity of person is gone, which is necessary to support the appropriation. In this manner, and subject to these conditions, may appropriations be made at this day, and thus were most, if not all, of the appropriations at present existing originally made, being plowed. 496-500. Sinecures may also be created. Hob. 307. By other neoih. 2 bum. Ekel. La. Co. Lit. 46. 347. Vol. I. 2a. The clergy. Annexed bishoprics, prebends, religious houses, nay, even to nunneries and certain military orders, all of which were spiritual corporations. At the dissolution of the monasteries in the reign of Henry Roman VIII, the appropriations of the several parsonages, which belonged to those respective religious houses, amounting to more than 1/3 of all the parishes in England, would have been by the rules of the common law disappropriated, had not a clause in those statutes intervened, to give them to the king in as ample a manner as the abbots and see. Formerly held the same at the time of their dissolution. This, though perhaps scarcely defensible, was not without example, for the same was done in former reigns, when the alien priories, that is such as were filled by foreigners only, were dissolved and given to the crown. And from these 2 roots have sprung all the lay of propriations or secular parsonages which we now see in the kingdom, they having been afterwards granted out from time to time by the crown. These appropriating corporations, or religious houses, were wont to depute one of their own body to perform divine service, and administer the sacraments, in those parishes of which the society was thus the parson. This officiating minister was in reality no more than a curate, deputy, or vicegerent of the appropriator and, therefore, called vicarius or vicar. His stipend was the discretion of the appropriator, who was however bound of common right to find somebody qui illi de temporali his episiopo de spiritualibus, debit responder, but this was done in so scandalous a manner, and the parishes suffered so much by the neglect of the appropriators, that the legislature was forced to interpose. and, accordingly, it is enacted by Statute 15 Ike. Roman 2. c. 6. That in all appropriations of churches, the diocesan bishop shall ordain, in proportion to the value of the church, a competent sum to be distributed among the poor parishioners annually, and that the vicarage shall be sufficiently endowed. It seems the parishes were frequently sufferers, not only by the want of divine service, but also by withholding those alms for which, among other purposes, the payment of tithes was originally imposed. And therefore in this act a pension is directed to be distributed among the poor parochians, as well as a sufficient stipend to the cell. Review of Tithe. c. 9. Spolm. Apology 35. 2 Anst. 584. Cell. Tithe. c. Vicar. But he, being liable to be removed at the pleasure of the appropriator, was not likely to insist too rigidly on the legal sufficiency of the stipend, and, therefore, by statute 4 Hen. Roman 4. c. 12, it is ordained that the vicar shall be a secular person, not a member of any religious house, that he shall be vicar perpetual, not removable at the caprice of the monastery, and that he shall be canonically instituted and inducted, and be sufficiently endowed, at the discretion of the ordinary, for these 3 express purposes: to do divine service, to inform the people, and to keep hospitality. Trade. The endowments in consequence of these statutes have usually been by a portion of the glebe or land belonging to the parsonage, and a particular share of the tithes which the appropriators found it most troublesome to collect, and which are therefore generally called privy or small tithes, the greater, or predial, tithes being still reserved to their own use. But one and the same rule was not observed in the endowment of all vicarages. Hence some are more liberally, and some more scantily, endowed, and hence the tithes of many things, as wood in particular, were formerly in some parishes rectorial, and in some vicarial rights. The distinction, therefore, of a parson and vicar is this: the parson has for the most part the whole right to all the ecclesiastical dues in his parish, but a vicar has generally an appropriator over him, entitled to the best part of his profits, to whom he is in effect perpetual curate, with a standing salary. Though in some places the vicarage has been considerably augmented by a large share of the great tithes, which augmentations were greatly assisted by the Statute 29 Car. Roman 2. c. 8. Enacted in favor of poor vicars and curates, which rendered such temporary augmentations, when made by the appropriators, perpetual. The method of becoming a parson or vicar is much the same. To both there are 4 requisites necessary. Holy orders. Pre. From this act we may date the clergy, in contradistinction to the perorigin of the present vicarages. For bucleal clergy, who pcr phonatal their miniae for ro this time the vicar was nothing try in the world, in Cephilo, and who more than a temporary curate, and from thence were called secular clergy, when the herch was appropriated to a Christian monastery, he was generally one of their tli nature of the original endowed body, that is, one of the regular MCNT is now of little moment. The tithes clergy, for the monks who lived sc Canoff nearly the whole kingdom, having due and regulars of their respective houses been commuted into rent charges, or b chaotic 8 were denominated regular. The clergy, santation, institution, and induction. The method of conferring the holy orders of deacon and priest, according to the liturgy and canons, is foreign to the purpose of these commentaries, any farther than as they are necessary requisites to make a complete parson or vicar. By common law, a deacon, of any age, might be instituted and inducted to a parsonage or vicarage, but it was ordained by Statute 13 Eliz. c. 12. That no person under 23 years of age, and in deacon's order, should be presented to any benefice with cure, and if he were not ordained priest within 1 year after his induction, he should be *J9 so facto deprived. And by Statute 13 and 14 Car. Roman 2. c. 4. No person is capable to be admitted to any benefice, unless he has been first ordained a priest, and then he is, in the language of the law, a clerk in orders. The canons of 1603, and the rubrics in the preface to the form of ordination, which respectively prescribe that no person shall be admitted a deacon before 23, or a priest before 24 years of age, are enforced by the Statute 44 Geo. Roman 3. c. 43 S. 1. Which makes the admission of persons as priests or deacons within the above ages respectively void in law, and declares any person so admitted incapable of holding any benefice or other ecclesiastical dignity whatever. And if a person obtains orders or a license to preach, by money or corrupt practices, which seems to be the true, though not the common, notion of simony, the person giving such orders forfeits 40, and the person receiving LOZ and is incapable of any ecclesiastical preferment for 7 years afterwards. Any clerk may be presented to a parsonage or vicarage. That is, the patron to whom the advocin of the church belongs may offer his clerk to the bishop of the diocese to be instituted. Of advocins, or the right of presentation, being a species of private property, we shall find a more convenient place to treat in the second part of these commentaries. But when a clerk is presented, the right of granting a faculty to the age of 24 years, and be admitted to deacon's orders sooner, minister here means one capable of all, an example of which occurred in the ministration, which is a priest only, case of George Whitfield, is limited to Rog. Ec. Law, ordination. The Archbishops of Canterbury and R. Stat. 31 Eliz. C. 6. Magi. 44 Geo. Roman 3. C. 43. For priests. A layman may also be presented. Orders there can be no dispensation, but he must take priest's orders before jibs. 146. For by 13 Eliz. C. 12 none his admission. 1 burn. 103. Shall be admitted minister being under. The bishop may refuse him upon many accounts. As 1. If the patron is excommunicated and remains in contempt 40 days. Or 2. If the clerk be unfit: which unfitness is of several kinds. First, with regard to his person, as if he be a bastard ***, an outlaw, an excommunicate, an alien, underage, or the like. Next, with regard to his faith or morals, as for any particular heresy or vice that is malum in se. But if the bishop alleges only in generals, as that he is schismaicum inveteratus, or objects a fault that is malum prohibitum merely, as haunting taverns, playing at unlawful games, or the like, it is not good cause of refusal. Or, hisly, the clerk may be unfit to discharge the pastoral office for want of learning. In any of which cases the bishop may refuse the clerk, in case the refusal is for heresy, schism, inability of learning, or other matter of ecclesiastical cognizance. There the bishop must give notice to the patron of such his cause of refusal, who, being usually a layman, is not supposed to have knowledge of it, else he cannot present by lapse. But if the cause be temporal, there he is not bound to give notice. Registered. If an action at law be brought by the patron against the bishop for refusing his clerk, the bishop must assign the cause. If the cause be of a temporal nature and the fact admitted, as, for instance, outlawry, the judges of the courts must determine its validity, or whether it be sufficient cause of refusal. But if the fact be denied, it must be determined by a jury. If the cause be of a spiritual nature, as heresy particularly alleged, the fact, if denied, shall also be determined by a jury. And if the fact be admitted or found, the court upon consultation and advice of learned divines shall decide its sufficiency. If the cause be want of learning, the bishop need not specify in what points the clerk is deficient, but only allege that he is deficient: or the statute 9 edwa. Roman 2. Sin. 1 c. 13 is express that the examination of the fitness of a person presented to a benefice belongs to the ecclesiastical judge. But because it would be nugatory in this case to demand the reason of refusal from the ordinary, if the two roll. Aber. 855. Demerit but his own. Ch. Piston. Glen. 1. 1.sc. 20. 2 roll. Aber. 356. 2 inst. 632. Stat. Though this be classed in the books. 3 Rick. Roman 2. E. 3. 7 Rick. Roman 2. C. 12. Amonk. Teli causes of refusal, yet such is 5 Rep. 58. The liberality of the present times, that 2 ins. C. 32. No one need epen and fly at his pre. 2 ins. 032. Sentiment would impeded by the N5 Rep. 58, 3 Lev. 313. Continence of his pirates or by any patron were bound to abide by his determination, who has already pronounced his clerk unfit. Therefore, if the bishop returns the clerk to be minus suffi ens in literaturd, the court shall write to the metropolitan to re-examine him, and certify his qualifications, which certificate of the archbishop is final. Asterisk if the bishop has no objections, but admits the patron's presentation, the clerk so admitted is next to be instituted by him, which is a kind of investiture of the spiritual part of the benefice. For by institution the care of the souls of the parish is committed to the charge of the clerk, when the ordinary is also the patron, and confers the living. The presentation and institution are one and the same act, and are called a collation to a benefice. By institution or collation the church is full, so that there can be no fresh presentation till another vacancy, at least in the case of a common patron. But the church is not full against the crown till induction. Nay, even if a clerk is instituted upon the crown's presentation, the crown may revoke it before induction, and present another clerk. J upon institution. Also, the clerk may enter on the parsonage house and glebe, and take the tithes, but he cannot grant or let them or bring in action for them till induction. Induction is performed by a mandate from the bishop to the archdeacon, who usually issues out a precept to other clergymen to perform it for him. It is done by giving the clerk corporal possession of the church, as by holding the ring of the door, tolling a bell, or the like, and is a form required by law with intent to give all the parishioners due notice, and sufficient certainty of their new minister to whom their tithes are to be paid. This, therefore, is the investiture of the temporal part of the benefice, as institution is of the spiritual. And when a clerk 2 Inst. 632. They were appointed to remedy, ease, a vicar on being instituted formerly peacially, as, if any profits were to arise, took, if required by the bishop, an oath fiam putting in a curate, and living at a of perpetual residence. For the maxim of distance from the parish, the appropriate law is vicarius non libet vicarium. Tor W. Leo was the real parson, had anand, as the non-residents of the approdatodly the elder title to them, but prietors was the cause of the perpetual. The oath of perpetual residence can no establishment of vicarages, the law longer be required, other provisions judged if very improper for them to defeat having been made for obtaining the end of their constitution, and by same result. 1 and 2 Vict. C. 10J. Absence to create the very mischief which asterisk J. Co. Lit. 344. Right to institution. 359 is thus presented, instituted, and inducted into a rectory. He is then, and not before, in full and complete possession, and is called in law persona impersonata, or parson impersoni. The rights of a parson or vicar, in his tithes and ecclesiastical dues, fall more properly under the second book of these commentaries, and as to his duties, they are principally of ecclesiastical cognizance, those only excepted which are laid upon him by statute. And those are indeed so numerous that it is impracticable to recite them here with a tolerable conciseness or accuracy. Some of them we may remark as they arise in the progress of our inquiries, but for the rest I must refer myself to such authors as have compiled treatises expressly upon this subject. I shall only just mention the article of residence, upon the supposition of which the law styles every parochial minister an incumbent. By statute 21 Henry Roman A. C. 13 persons wilfully absenting themselves from their benefices for 1 month together, or 2 months and the yever, incurred a penalty of 51 to the king and 5/ to any person that sued for the same, except chaplains to the king or others therein mentioned, during their attendance in the household of such as retained them, and also except all heads of houses, magistrates and professors in the universities, and all students under 40 years of age reciting their bond fide for study. Asterisk this statute was immortally repealed by the Act 57 Geo. Roman 3. C. 99. Other provisions and penalties were imposed, and both were afterwards wholly repealed by Tli Statute 1 and 2 Vict. C. 106, amending and consolidating the laws relating to pluralities and residence. That statute enacts that if any spiritual person holding any benefice fails to keep residence on his benefice as directed by the Act, except with license or dispensation as allowed therein, he shall, when such absence exceeds 3 monthlies and does not exceed 6 months, forfeit 1/3 part of the annual value of the benefice so neglected, and when such absence exceeds 6 months and does not exceed 8 males, 1/2 part of such annual value, and when such absence exceeds 8 months, 2/3 of such annual value, and when such absence shall have been for the whole year, 3/4 parts. Co. Lit. 300. Clergyman's Law, published under the Thes bar very numerous, but name of Dr. What own, but compiled by their fow which can be relied on Mr. Place, a barrister. With certainty. Among those Archbishop Stat. 25 hen. Roman 8. C. 16. 33 hen. Gibson's Codex, Dr. Bums Ecclesiaculi Roman 8. C. 28. Call late and the earlier editions of the Stat. 28 Han. Viewey. C. 13. The clergy of the annual value. Excedence, moreover, may be enforced by monition and sequestration of the living. Legal residence is not only in the parish, but also in the parsonage house if there be one, for it has been resolved that the statute of Henry Roman 8 intended residence not only for serving the cure and for hospitality, but also for maintaining the house, that the successor also might keep hospitality there, and if there were no parsonage house, it was held that the incumbent was bound to hire one in the same or some neighboring parish to answer the purposes of residence. For the more effectual promotion of which important duty among the parochial clergy, provisions are made by the statute *1 and 2 Vict. C. 186, in lieu of former provisions for the same object. For raising money upon ecclesiastical benefices to be paid off by annually decreasing installments, and to be expended in rebuilding or repairing the houses belonging to such benefices. We have seen that there is but one way whereby one may become a parson or vicar. There are many ways by which one may cease to be so. 1. By death. 2. By cession in taking another benefice. 4. By statute 21 hen. Roman 8. C. 13. If any one having a benefice of 8z per annum, or upwards, according to the valuation in the king's books, accepted any other, the first was adjudged void, unless he obtained a dispensation, which no one was entitled to have but the chaplains of the king, and others therein mentioned, the brethren and sons of lords and knights and doctors and bachelors of divinity and law, admitted high the universities of this realm. And now, by the statute 1 and 2 Vict. C. 116, as amended by the statute 13 and 14 Vict. C. 98, 2 benefices cannot in general be held by the same person, unless they be within 3 miles of each other, and the annual value of one does not exceed LOZ. Nor if the population of one such benefice exceeds 3,000, and of the other 500 persons according to the last census. Exceptions exist in favor of persons holding certain cathedral preferments, but in all cases a license or dispensation must be obtained to hold any 2 benefices together, and the acceptance of preferment contrary to the statute vacates the former preferment. And a vacancy thus made, for want of a dispensation, is called cession. Free. By consecration. For, as was mentioned before, when a clerk is promoted. 6 Cap. 21. See also 1 and 5 Viet. C. 39, 13 and 14 PCIO. Car. 456. Viet. C. Parsons and vicubs cease to be such. 361 to a bishopric. All his other preferments are void the instant that he is consecrated. Their asterisk was formerly a method, by the favor of the crown, of holding such living in commendam. Comptende or ecclesia commendata is a living commended by the crown to the care of a clerk to hold till a proper pastor is provided for it. This might be temporary for 1, 2, or 3 years, or perpetual, being a kind of dispensation to avoid the vacancy of the living, and is called a commender retener. There was also a commender recipor, which is to take a benefice de novo, in the bishop's own gift, or the gift of some other patron consenting to the same, and this was the same to him as institution and induction are to another clerk. But now, by the statute 6 and 7 will. Roman 4. c. 77-8. 18. No ecclesiastical dignity, office, or benefice can be held in commonendum by any bishop. 4. By resignation. But this is of no avail, till accepted by the ordinary, and to whose hands the resignation must be made. 5. By deprivation, either, first, by sentence declaratory in the ecclesiastical court, or as the court of the province. For fit and sufficient causes allowed by the common law, such as conviction of treason or felony, or conviction of other infamous crime in the king's courts, for heresy, infidelity, gross immorality, and the like, or, secondly, in pursuance of divers penal statutes, which declare the benefice void for some nonfeasance or neglect, or else some malfeasance or crime, as, for simony, farming or trading after 2 previous convictions for those offences. For maintaining any doctrine in derogation of the royal supremacy, or of the 39 Articles, or of the Book of Common Prayer, for neglecting after institution to read the liturgy and JV articles in the church, or make the declarations required by law * for using any other form of prayer than the liturgy of the Church of England, * for allowing the benefice to remain under sequestration for non-residents for a year, or for incurring 2 such sequestrations in the space of 2 years, * in all which and similar cases the benefice is ipso facto void, without any formal sentence of deprivation. But in most of them, 6 months' notice must be given to the patron before the rite of Hob. 144. Days in 1 year from a benefice belong. Krill. Jack. 197. Ig to a popish patron, to W. Leakley he had 1 and 2 Vic. c. 106-8, 31. Been presented by Sither of Teli Univer. The Clerical Subscription Act, 865. Cities it became void. 1 W. and M. c. 2. 1 and 2 Vict. c. 106-8, 58. Formerly, this statute was repealed by 32 and 33 if an incumbent absented himself 60 Vict. c. Presentation lapses. 6. By renunciation of his orders. Under the Clerical Disabilities Act, 1870, which permits a priest or deacon to execute and enroll in chancery a deed relinquishing all the rights, privileges, advantages, and exemptions of his orders, whereby he is discharged and freed from all disqualifications, restraints, and prohibitions to which he would otherwise by law, by which is to be understood, it is apprehended, our municipal law, be subject. Besides parsons and vicars, properly so called, there are numerous ministers of the Church who have many of the rights, and are subject to most of the disabilities of the beneficed clergy. These are the incumbents of districts, constituted parishes, by special acts of Parliament, or formed from time to time under the authority and by virtue of the powers conferred on the church-building commissioners, who were first appointed by the Statute 58 Geo. Roman 3. c. 45. By that and many subsequent acts, provision was made for building new churches in populous districts, for dividing existing parishes, and for assigning new ecclesiastical districts and determining the nature of their endowment and in whom the patronage of the living should be vested. In this way, not only have new districts been carved out of existing parishes, and themselves constituted as original parishes, but churches and chapels have in some cases been constituted the parish church, and the original parish church become a district church or chapel of ease. The incumbents in all these districts are now designated vicars, and as holy orders, presentation, institution, and induction are essential for the purpose of becoming a minister of these district incumbencies. Much if not all that has been said on these subjects applies equally to them. Especially are these vicars and their curates in like manner subject to the visitation and correction of the bishop. Vi. A curate is the lowest degree in the Church, being in the same state that a vicar was formerly, an officiating temporary minister instead of the proper incumbent. The 2 perpetual curacies, where all the tithes are appropriated, and no vicarage endowed, which were for some particular reasons exempted from the statute of Hen. Roman 4 are now styled vicarages. Curates, properly so called. 44 Geo. Roman 3. Exclamation, I6, 6I and H2 Vic. C. 117. 1 Burn Eckel. J.A. 427. Curates. (363) are the objects of some particular statutes, which ordain that such as serve a church during its vacancy shall be paid such stipend as the ordinary thinks reasonable, out of the profits of the vacancy, or, if that be not sufficient, by the successor within 14 days after he takes possession. The bishop may also, when a non-resident incumbent neglect to do so, or when the duty is inadequately performed, appoint a curate, and fix his stipend. And in large benefices having a considerable expiation, or more than one church, when the incumbent, after being so required, fails to provide a curate, the bishop may make the requisite appointment. The bishop has also exclusive authority to decide on the claims of curates to their stige. 8, and to grant and withdraw their licenses, his decision in the latter case being subject to the review of the metropolitan. Thus much of the clergy, properly so called. There are also certain inferior ecclesiastical officers of whom the common law takes notice, and that, principally, to assist the ecclesiastical jurisdiction, where it is deficient in powers. On which officers I shall make a few cursory remarks. Roman 7. Churchwardens are the guardians or keepers of the church, and representatives of the body of the parish. They are sometimes appointed by the minister, sometimes by the jarish, sometimes by both together as custom directs. They are taken, in favor of the church, to be for some purposes a kind of corporation at the common law. That is, they are enabled by that name to have a property in goods and chattels, and to bring actions for them, for the use and profit of the parish. Yet they may not waste the church goods, but may be removed by the parish, and then called to account by action at the common law. But there is no method of calling them to account, but by first removing them, for none can legally do it, but those who are put in their place. As to the churchyard, and they have no sort of interest therein, but if any damage is done thereto, the parson only or vicar shall have the action. As to lands, however, given for the benefit of the parish, the statute 59 Geo. Roman 3. C. 12 empowers the 28 hen. Roman 8. C. 11. Docum v. C**. As to the duties of certain lecturers, man 9 W. N. M. 777. And preachers, see the stat. 7 and 8 Vic. 1 and 2 Vict. C. 106. E. 59. 1 and 2 Vic. C. 106. Daniel v. Morian. Rogers Ewell. Law, lit. Church 16q. v. 198. Icardens. Churchwardens and overseers to hold such lands in the nature of a body corporate, and to hold also all other buildings, lands, and hereditaments belonging to the parish. Their office also is, if they have funds, to repair the church, and make rates and levies for that purpose, of which, however, payment cannot be enforced. They are empowered to keep all persons orderly while in church, to which end it has been held that a churchwarden may justify the pulling off a man's hat, without being guilty of either an assault or trespass. And formerly, they were to levy a shilling forfeiture on all such as did not repair to church on Sundays and holidays. There are also a multitude of other petty parochial powers committed to their charge by divers acts of Parliament. Roman 8. Parish clerks and sextons are also regarded by the common law as persons who have freeholds in their offices, and therefore though they may be punished, yet they cannot be deprived by ecclesiastical censures. The parish clerk was formerly very frequently in holy orders, and some are so to this day. He is generally appointed by the incumbent, but by custom may be chosen by the inhabitants, and if such custom appears, the Queen's Bench division will grant a mandamus to the archdeacon to swear him in, for the establishment of the custom turns it into a temporal or civil right. Trade. He may be removed by the archdeacon or ordinary for misconduct. Churchwardens without funds are at the end of his ironarcha, and doctor, not personally liable for fees or repairs. Burn tit. Churchwardens, Visiveli Pertwee, 5 Lockep. 2. B. 573. Tations. A declaration was, by the 831 and 32 Vict. C. 109. This statute stat. 5 and 6 will. Roman 4. C. 62 S. 9. Substa permits a body of trustees to be constituted for their oaths of office. Tutored for certain ecclesiastical purposes. Stephenson v. Bain 2L. and BL. 744. Who become a corporation and may to roll. Aber. 234. Hold real and personal property. As to parish clerks and orders, c. Stat. 1 is. c. 2 repealed by the 7 and 8 Vict. c. 59. 9 and 10 Vict. c. 59. Crow. Car. 589. C. Lambard of Churchwardens. 7 and 8 Vict. C. 59 S. 5. 365. Chapter Roman 12. Of the civil state. The lay part of the community, or such of the people as are not comprehended under the denomination of clergy, may be divided into 3 distinct states: the civil, the military, and the maritime. That part of the nation which falls under our first and most comprehensive division, the civil state, includes all orders of men, from the highest nobleman to the meanest peasant, that are not included under either our former division of clergy, or under one of the 2 latter, the military and maritime states. And it may sometimes include individuals of the other 3 orders, since a nobleman, a knight, a gentleman, or a peasant may become either a divine, a soldier, or a seaman. The civil state consists of the nobility and the commonalty. Of the nobility, the peerage of Great Britain or Lords Tenantry, as forming, together with the bishops, one of the supreme branches of the legislature, I have before sufficiently spoken. We are here to consider them according to their several degrees or titles of honor. All degrees of nobility and honor are derived from the sovereign as their fountain, and he may institute what new titles he pleases. Hence it is that all degrees of nobility are not of equal antiquity. Those now in use are dukes, marquesses, earls, viscounts, and barons. 1. A duke, though he be with us, in respect of his title of nobility, inferior in point of antiquity to many others, yet is superior to all of them in rank, his being the first title of dignity after the royal family. Among the Saxons the Latin name of dukes deces is very frequent, and signified, as among the Romans, the commanders or leaders of their armies, whom in their own language they called heretoga, and in the laws of Henry I, we, the civil state, lend them called heretocii. But after the Norman conquest, which changed the military polity of the nation, the kings themselves continuing for many generations dukes of Normandy, they would not honor any subjects with the title of duke till the time of Edward Roman III, who, claiming to be king of France and thereby losing the ducal and the royal dignity, in the 11th year of his reign created his son, Edward the Black Prince, Duke of Cornwall, and many of the royal family especially, were afterwards raised to the like honor. However, in the reign of Queen Elizabeth A.D. 1572, the whole order became utterly extinct, but it was revived about 50 years afterwards by her successor, who was remarkably prodigal of honors in the person of George Villiers, Duke of Buckingham. 2. A marquess, marshal, is the next degree of nobility. His office formerly was, for dignity and duty were never separated by our ancestors to guard the frontiers and limits of the kingdom, which were called the marches from the Teutonic word march, a limit. Such as, in particular, were the marches of Wales and Scotland, while each continued to be an enemy's country. The persons who had command there were called lords marchers or marquesses, whose authority was abolished by Statute 27 Hen. Roman 8. c. 27. Though the title had long before been made a mere ensign of honor, Gobert Vere, Earl of Oxford, being created Marquess of Dublin by Richard Roman II, in the 8th year of his reign. 3. An earl is a title of nobility so ancient that its origin cannot clearly be traced out. Thus much seems tolerably certain, that among the Saxons they are called ealdormen, quasi-elderman, signifying the same as senior or senator among the Romans, and also seherman, because they had each of them the civil government of a several division or shire. On the eruption of the Danes, they changed the name to earls, which signified the same in their language. In Latin they are called comites, a title first used in the empire, from being the king's attendants. Associae. Nomen sumserunt reges in nim tales sibi associant. After the Norman conquest they were for some time called counts or counties, from the French, but they did not long retain that name themselves, though their shires are from thence called counties to this day. The name of earls or comites is now become a mere title. Earls, viscounts, and barons. 367 They having nothing to do with the government of the country, which, as has been more than once observed, is now entirely devolved on the sheriff, the earl's deputy, or viscomes. In writs and commissions and other formal instruments, the king, when he mentions any peer of the degree of an earl, usually styles him trusty and well-beloved coim, an appellation as ancient as the reign of Henry Roman IV, who being either by his wife, his mother, or his sisters actually related or allied to every earl then in the kingdom, artfully and constantly acknowledged the connection in all his letters and other public acts. From whence the usage has descended to his successors, though their reason has long ago failed. 4. The name of viscomes or viscount was afterwards made use of as an arbitrary title of honor, without any shadow of office pertaining to it, by Henry VI when, in the 18th year of his reign, he created John Beaumont a peer, by the name of Viscount Beaumont, which was the first instance of the kind. 5. A barons is the most general and universal title of nobility, for originally every one of the peers of subexterior rank had also a barony annexed to his other titles. But it has sometimes happened that, when an ancient baron has been raised to a new degree of peerage, in the course of a few generations the two titles have descended differently, one perhaps to the male descendants, the other to the heirs general, whereby the earldom or other superior title has subsisted without a barony. And there are also modem instances, where earls and viscounts have been created without annexing a barony to their other honors, so that now the rule does not hold universally that all peers are barons. The origin and antiquity of baronies have occasioned great inquiries among our English antiquaries. The most probable opinion seems to be that they were the same with our present lords of manors, to which the name of court baron, which is the lord's court and incident to every manor, gives some countenance. It may be collected from King John's Magna Charta that originally all lords of manors, or barons, that held of the king and capi, had seats in the great council or parliament, till about the reign of that prince the conflux of them became so large and troublesome that the king was obliged to divide them, and summon only the greater barons in person, leaving the small ones to be summoned by the sheriff, and, as it is said, to sit by representation in another. 368 The civil state house, which gave rise to the separation of the two houses of parliament. By degrees the title came to be confined to the greater barons, or lords of parliament only, and there were no other barons among the peerage, but such as were summoned by writ, in respect of the tenure of their lands or baronies, till Richard Roman II first made it a mere title of honor, by conferring it on divers persons by his letters patent. Having made this short inquiry into the origin of our several degrees of nobility, I shall next consider the manner in which they may be created. The right of peerage seems to have been originally territorial, that is, annexed to lands, honors, castles, manors, and the like, the proprietors and possessors of which were, in right of those estates, allowed to be peers of the realm, and were summoned to Parliament to do suit and service to their sovereign, and, when the land was alienated, the dignity passed with it as a pendant. Thus the bishops still sit in the House of Lords in right of succession to certain ancient baronies annexed, or supposed to be annexed, to their episcopal lands. And thus, in 11 Hen, VI, the possession of the castle of Arundel was adjudged to confer an earldom by tenure on its possessor . But afterwards, when alienations grew to be frequent, the dignity of peerage was confined to the lineage of the party ennobled, and instead of territorial, became personal. Actual proof of a tenure by barony became no longer necessary to constitute a lord of parliament, but the record of the writ of summons to him or his ancestors was admitted as a sufficient evidence of the tenure. Peers are now created either by writ or by patent, for those who claim by prescription must suppose either a writ or patent made to their ancestors, though by length of time it is lost. The creation by a writ, or the Queen's letter, is a summons to attend the House of Peers, by the style and title of that barony which the sovereign is pleased to confer. That by patent is a royal grant to a subject of any dignity and degree of peerage. The creation by writ is the more ancient way, but a man is not ennobled thereby, unless he actually takes his seat in the House of Lords. And some are of opinion that there must be at least Vilb. Hist of Exch. C. Free. Barony by tenure cannot now exist. 1 ins. 9. Seld. Jan. Aug. 2. Section D6. Berkeley Case Dom. Pra. 1861. Equals cell. Tit. Of Han. V. 2 vo. 9. Section. The incidence of nobility. 369 2 writs of summons, and a sitting in 2 distinct parliaments to evidence a hereditary barony. Asterisk, and therefore the most usual, because the surest way is to grant the dignity by patent, which inures to a man and his heirs according to the limitations thereof, though he never himself makes use of it. Although it is not unusual to call up the eldest son of a peer to the House of Lords by writ of summons, in the name of his father's barony, because in that case there is no danger of his children's losing the nobility in case he never takes his seat, for they will succeed to their grandfather. Asterisk, an original creation by writ has been long obsolete. Creation by writ has, asterisk, however, one advantage over that by patent, for a person created by a writ holds the dignity to him and his heirs, without any words to that purport in the writ, but in letters patent there must be words to direct the inheritance, else the dignity inures only to the grantee for life. For a man or woman may be created noble for their own lives, and the dignity not descend to their heirs at all, or descend only to some particular heirs, as where a peerage is limited to a man, and the heirs male of his body by Elizabeth his present lady, and not to such heirs by any former or future wife. Asterisk, the grant of a peerage for life merely does not, however, make the grantee a Lord of Parliament. Registered, let us next take a view of a few of the principal incidents attending the nobility, exclusive of their capacity as members of Parliament, and as hereditary councillors of the Crown, both of which we have before considered. And first we must observe, that in cases asterisk of treason and felony a nobleman shall be tried by his peers. The great are always obnoxious to popular envy. Were they to be judged by the people, they might be in danger from the prejudice of their judges, and would moreover be deprived of the privilege of the meanest subjects, that of being tried by their equals, which is secured to all the realm by Magna Charta, c. 29. It is said that this does not extend to bishops, who, though they are lords of Parliament, and sit there by virtue of their baronies which they hold jure ecclesiae, yet are not ennobled in blood, and consequently not peers with the nobility. As to peeresses, there was no precedent for their trial when accused of treason or felony till after Eleanor Duchess of Whitelock, of Parry. Ch. 114. Why you hate at you peerage sees, well the mate, 95, 56. Vol. I. The civil state. Gloucester, wife to the Lord Protector, was accused of treason and found guilty of witchcraft in an ecclesiastical synod through the intrigues of Cardinal Beaufort. This very extraordinary trial gave occasion to a special statute, 20 Hen. Vi. c. 9, which declares the law to be, that peeresses, either in their own right or by marriage, shall be tried before the same judicature as other peers of the realm. If a woman, noble in her own right, marries a commoner, she still remains noble and shall be tried by her peers. But if she be only noble by marriage, then by a second marriage with a commoner, she loses her dignity, for as by marriage it is gained, by marriage it is also lost. Yet if a duchess dowager marries a baron, she continues a duchess still, for all the nobility are pairs, and therefore it is no degradation. A peer or peeress, either in her own right or by marriage, cannot be arrested in civil cases, and they have also many peculiar privileges annexed to their peerage in the course of judicial proceedings. A peer sitting in judgment gives not his verdict upon oath, like an ordinary German, but upon his honor. But when he is examined as a witness either in civil or criminal cases, he must be sworn, for the respect which the law shows to the honor of a peer does not extend so far as to overturn a settled maxim, that in judicio non creditor nisi jurates. The honor of peers is, however, so highly tendered by the law, that it is much more penal to spread false reports of them and certain other great officers of the realm, than of other men. Scandal against them being called by the peculiar name of scandalum magnavum, and subjected to peculiar punishments by divers ancient statutes. A peer cannot lose his nobility, but by death or attainder. Though there was an instance in the reign of Edward IV of the degradation of George Neville, Duke of Bedford, by Act of Parliament, on account of his poverty, which rendered him unable to support his dignity. But this is a singular instance, which serves at the same time, by having happened, to show the power. The preamble to the act is remark, and causeth oftentimes great extortion able, forasmuch as oftentimes it is embracery and maintenance to be had, seen that when any lord is called to the great trouble of all such commentaries, high estate, and hath not convenient, where such estate shall happen to be, livelihood to support the same dignity, therefore and see, it induceth great poverty and indigence. The dignity of knighthood. 371 of Parliament, and, by having happened but once, to show how tender the Parliament has been in exerting so high a power. It has been said indeed, that if a baron wastes his estate, so that he is not able to support the degree, the aesific may degrade him, but it is expressly held by later authorities, that a peer cannot be degraded, but by act oi Parliament. The commonalty, like the nobility, are divided into several degrees, and as the lords, though different in rank, yet all of them are peers in respect of their nobility, so the commoners, though some are greatly superior to others, yet all are in law peers in respect of their want of nobility. The first name of dignity, next beneath the peer, was anciently that of videmes, vicetamini, or velvaors, who are mentioned by our ancient lodgers as viri magnet dignitates, and Sir Edward Coke speaks highly of them. Yet they are now quite out of use, and our legal antiquaries are not agreed upon even their origin or ancient office. Now, therefore, the first personal dignity, after the nobility, is a Knight of the Order of St. George, or of the Garter, first instituted d by Edward Roman III, A.D. * 1348. Next, but not till after certain official dignities, as Privy Councillors, the Chancellors of the Exchequer and Duchy of Lancaster, the Chief Justice of the Queen's Bench, the Master of the Rolls, and the other English judges, follows a Knight Hanneret, who indeed by statutes 5 Ric. Roman 2. Sin. 2c. 4 and 14 Ric. Roman 2. c. 11, is ranked next after barons, and his precedence before the younger sons of viscounts was confirmed to him by order of King James I in the 10th year of his reign. But in order to entitle himself to this rank, he must have been created by the king in person, in the field, under the royal banners, in time of open war. Else he ranks after baronets, who are the next order, which title is a dignity of inheritance created by letters patent, and usually descendable to the issue male. It was first instituted by King James I AD 1611, in order to raise a competent sum for the reduction of the province of Ulster in Ireland, for which reason all baronets have the arms of Ulster superadded to their family coat. Next follow Knights of the Bath, an order instituted by King Henry Roman IV, and revived equals so. Tit. Of Hon. v. 2c. 5, section 14. Sir H. Nicolaus Orders of Knighthood. Archsologian, Ball. Roman 31. By King George I. In 1725. They are so called from the ceremony, formerly but not now observed, of bathing the knight before their creation. The last of these inferior nobility are knights bachelors, the most ancient though the lowest order of knighthood amongst us, for we have an instance of King Alfred's conferring this order on his son Athelstan. The custom of the ancient Germans was to give their young men a shield and a lance in the great council. This was equivalent to the toga virilis of the Romans. Before this they were not permitted to bear arms, but were accounted as part of the father's household. After it, as part of the community. Hence some derive the usage of knighting, which has prevailed all over the Western world since its reduction by colonies from those northern heroes. Knights are called in Latin equites orati from the gilt spurs they wore, and equites because they always served on horseback. For it is observable that almost all nations call their knights by some appellation derived from a horse. They are also called in our law milites, because they formed a part of the royal army, in virtue of their feudal tenures, one condition of which was, that every one who held a knight's fee immediately under the crown, which in Edward Roman II's time amounted to 20 z. per annum, was obliged to be knighted and attend the king in his wars or pay a fine for his non-compliance. The exertion of this prerogative as an expedient to raise money in the reign of Charles I gave great offense, though warranted by law, and the recent example of Queen Elizabeth, but it was by the Statute 16 Car. C. 16, abolished, and this kind of knighthood has, since that time, fallen into great disregard. These are all the names of dignity in this kingdom, esquires and gentlemen being only names of worship. But before these last the heralds rank all colonels, serjeants at law, and doctors in the 3 learned professions. K** as to this order of knighthood, C.J. Stat. de Millet, 1 Edwa. Roman II. London Gazettes 25 May, 1847, and the Rules of Precedence in England 16 August, 1850. May be reduced to the following table. It does not appear that the English in which those marked asterisk are entitled to word knight has any reference to a horse. The rank here allotted them, by Stat. 31 for knight or Seenicht in the Saxon, sig hen. Roman 8, c. 10, marked F, by Stat. 1 knifeis pure service or attendant. CW, and M, C. 22, marked, by letters cell. Tit, of Han. B. 2c. 5, section 33. Patent, 9, 10, and 14 Jack. I which see in Christian, cell. Tit, of Han. Roman 2. 5, 46, and Roman 2. 11. Table of Precedence. 373 esquires and gentlemen are confounded together by Sir Edward Coke, who observes that every esquire is a gentleman. 3. Mark J. By ancient usage and established custom, for which see Camden's Britain. Tit Ordinate. Mills's Catalogue of Honour, edit. 1610, and Chamberlain's Present State of England, p. 3 ch. Roman 2L Table of Precedence. C** the sovereign's children and grandchildren. * brethren. * uncles. * nephews. * Archbishop of Canterbury. * Lord Chancellor or Qasr, if a baron. * Archbishop of York. * Lord Treasurer. * Lord President of the Council. * Lord Privy Seal. * Lord Great Chamberlain. But C1 Dio. I. C. 3. Lord High Constable. Lord Marshal. XRD Admiral. Lord Steward of the Household. Lord Chamberlain of the Household. Dukes. Marquises. Ex-dukes. Eldest Saub. Earls. Ex-marquises. Eldest sons. Ex-dukes. Younger sons. Viscounts. Ex-earls' eldest sons. Ex-maniuses. Younger sons. Secretary of State, if a bishop. Bishop of London. Durham. Winchester. Bishops. Secretary of Stato, if a boron. Barons, TSJK Jaker of the House of Commons. Lords Commissioners of the Great Seal. Ex-Jesuits' eldest sons. Ex-earls. Younger sons. Ex-barons' eldest sons. Roman 2 Knights of the Garter. Roman 2 Privy Sea Chancellors. Roman 2 Chancellor of the Exchequer. Roman 2 Chancellor of the Duchy. 11 Chief Justice Queen's Bench Division. 11 Master of the Rolls. Roman 2 Chief Justice Common Pleas Division. Roman 2 Chief Baron Exchequer Division. Lords Justices of the Court of Appeal, Vice-Chancellors, Roman II Judges of High Court, Roman II Knights Banneret Royal, Roman II Viscounts Jougersons, Roman II Barons Jougersons, Roman II Becut Net 8, H Knights Bannerets, X Knights of the Bath, Queen's Counsel, X Knights Bachelors, Roman II Baronet and Eldest Sons, Roman II Knights Eldest Sons, 11 Baronets, Younger Sons, Roman II Knights, Younger Sous, Ex-Colonels, Ex-Doctors, Ex-Esquires, Ex-Gentlemen, Ex-Yeomen, Ex-Tradesmen, Ex-Artificers, Ex-Laborers. N.B. Married women and widows are entitled to the same rank among each other as their husbands would respectively have borne between themselves, except such rank is merely professional or official, and unmarried women to the same nuic as their eldest brothers would bear among men during the lives of their fathers. It is said that before the c. enquagged, by a constitution of Pope Gregory, the two archbishops were equal in dignity, and in the number of ishoi s subject to titular authority, and that William the Conqueror thought it prudent to give precedence and superiority to the Archbishop of Canterbury, but Teleoma's Archbishop of York was unwilling to acknowledge his inferiority to I. Frank Archbishop of Canterbury, and appealed to the JMPC, who referred the matter to the King and Barras, and in a council held at Windsor Castle they decided in favour of the Archbishop of Canterbury. But the Archbishop of Vorklong afterwards refused to acquiesce in this decision. Foy Bishop Godwin relates a curious and ludicrous struggle which took place in the reign of Henry Roman II above 100 years afterwards, between Coger Archbishop of York and Richard Archbishop of Canterbury for the Cly and on the right hand of the Poy C8 legate. Perhaps to this decision, and their former equality, we may refer the present distinction between Telim, viz. That the Archbishop of Canterbury is primate of all England, and Archbishop of York is primate of England. CHRFs is Mr. Sergeant Manning Servants ad legem, p. 26.1. Sir William Blackstone places sergeants immediately a JLCR colonels. The civil state and a gentleman is defined to be one qui arma gerit, who bears coat armor, the grant of which adds gentility to a man's family, in like manner as civil nobility, among the Iamens was founded in the jus imaginum, or having the image of one ancestor at least, who had borne some curule office. It is indeed a matter somewhat unsettled, what constitutes the distinction, or who is a real esquire, for it is not an estate, however large, that confers this rank upon its owner. Camden, who is himself a herald, distinguishes them the most accurately, and he reckons up 4 sorts of them. 1. The eldest sons of knights, and their eldest sons in perpetual succession. 2. The eldest sons of younger sons of peers, and their eldest sons in like perpetual succession. Both which species of esquires Sir Henry Spelman entitles armigery natalitiae. 3. Esquires created by the king's letters patent or other investiture, and their eldest sons. 4. Esquires by virtue of their offices, as justices of the peace, and others who bear any office of trust under the crown. To these may be added barristers at law, and the esquires of Knights of the Bath, each of whom constitutes 3 at his installation, and all 4 noblemen. For not only these, but the eldest sons of peers of Great Britain, though frequently titular lords, are only esquires in the law, and are so named in all legal proceedings. As for gentlemen, says Sir Thomas Smith, they may be made good cheap in this kingdom, for whosoever studieth the laws of the realm, who studieth in the universities, who professeth the liberal sciences, and, to be short, who can live idly, and without manual labour, and will bear the port, charge, and countenance of a gentleman, he shall be called master, and shall be taken for a gentleman. A yeoman is he that hath free land of 40 shillings by the year, who is anciently thereby qualified to serve on juries, vote for knights of the shire, and do any other act, where the law requires one that is prohis that legalis homo. The rest of the commonalty are tradesmen, artificers, and labourers, who, as well as all others, were required by the statute 1 hen. VC 5 to be styled by the name and addition of their estate, degree, or mystery, and the place to which they belonged or where they had been conversant in all original writs. Bexfie, Bra-esque, 1 Wills, 244. Common Law. Of England B. 1 C. 20. Names op worship. 375 of actions personal, appeals and indictments, upon which process of outlawry might be awarded, in order as it should seem, to prevent any clandestine or mistaken outlawry, by reducing to a specific certainty the person who is the object of its process. But no indictment, information, writ or pleading is now vitiated by the omission of such addition. 376. Chapter Roman 13. Of the military and maritime states. The military state includes the whole of the soldiery, or such persons as are peculiarly appointed among the rest of the people for the safeguard and defense of the realm. In a land of liberty it is extremely dangerous to make a distinct order of the profession of arms. In absolute monarchies this is necessary for the safety of the prince, and arises from the main principle of their constitution, which is that of governing by fear, but in free states, the profession of a soldier, taken singly and merely as a profession, is justly an object of jealousy. In these no man should take up arms, but with a view to defend his country and its laws. He puts not off the citizen when he enters the camp, but it is because he is a citizen, and would wish to continue so, that he makes himself for a while a soldier. The laws, therefore, and constitutions of these kingdoms know no such state as that of a perpetual standing soldier, bred up to no other profession than that of war, and it was not till the reign of Henry Roman VII, that the kings of England had so much as a guard about their persons. In the time of our Saxon Enctors, as appears from Edward the Confessor's laws, the military force of this kingdom was in the hands of the dukes or heretogs, who were constituted through every province and county in the kingdom, being taken out of the principal nobility, and such as were most remarkable for being sapiens stratals et animosi. Their duty was to lead and regulate the English armies with a very unlimited power. Prout eis visum fuerit, ad honorem coronis et utilitatem regni. And because of this great power they were elected by the people the yeomen of the guard, established first 50, and seems never to have expired hen. Roman 7. In 1-485, are to be considered seated 200. Halem, con. His. More as the king's domestic servants fall. Roman 2. Ch. Roman 9. Then as soldiers. Their number was at. Saxon and Norman military forces. 377 in their full assembly, or faux ugnote, in the same manner as sheriffs were elected. Following still that old fundamental maxim of the Saxon constitution, that where any awful beaser was entrusted with such power, as if abused might tend to the oppression of the people, that power was delegated to him by a vote of the people themselves. So too, among the ancient Germans, the ancestors of our Saxon forefathers, they had their dukes as well as kings, with an independent power over the military, as the kings had over the civil state. The dukes were elective, the kings hereditary, for so only can be consistently understood the passage of Tacitus. Reges ex nihilitate, duces ex virtutis uniunt. In constituting their kings, the family or blood royal was regarded, in choosing their dukes or leaders, warlike merit. Just as Caesar relates of their ancestors in his time, that whenever they went to war, by way either of attack or defense, they elected leaders to command them. This large share of power, thus conferred by the people, though intended to preserve the liberty of the subject, was perhaps unreasonably detrimental to the prerogative of the crown, and accordingly we find a very ill use made of it by Edric, Duke of Mercia, in the reign of King Edmund Ironside, who, by his awful see of duke or heretog, was entitled to a large command in the king's army, and by his repeated treacheries at last transferred the crown to Canute the Dane. It seems universally agreed by all historians that King Alfred first settled a national militia in this kingdom, and by his prudent discipline made all the subjects of his dominion soldiers. But we are unfortunately left in the dark as to the particulars of this is so celebrated regulation. Upon the Norman conquest the feudal law was introduced here in all its rigor, the whole of which is built on a military plan. I shall now enter into the particulars of that constitution, which belongs more properly to the next part of our commentaries, but shall only observe that in consequence thereof all *LL. Edward the Confessor. 1 Thorpe, Death of Edward the Confessor, though p. 456. See also Bede, Ecclesiastical, a stranger to the royal blood, to Mount. History 1, 5 c. 10. For a short space, the Telierno of Teliais. De Bell. Gaul. 1, 6 c. 22. Kingdom, in prejudice of Edgar Atheling, *. Sir W. Blackstone says the Duke's the rightful heir. Harold was elected seemed to have been left in possession of King on the death of the Confessor. His too large and independent a power, command of the forces may have con which enabled Duke Harold, on the trip to that result. Military and maritime states. The lands in the kingdom were divided into what were called knights. Fees in number above 60,000, and for every knight's fee a knight or soldier, miles, was bound to attend the king in his wars for 40 days in a year, in which space of time, before war was reduced to a science, the campaign was generally finished and a kingdom either conquered or victorious. By this means the king had, without any expense, an army of 60,000 men always ready at his command. And, accordingly, we find one among the laws of William the Conqueror, which in the king's name commands and firmly enjoins the personal attendance of all knights and others. Quod hahinta. Tenit si semper in armes et equis ut disset et oportet, et quam semper sint prompti et parity ad servitum suum integrum nobis. Explendum et perigendum cum opposed fuerit, secundum quod debent de fides et tenamentis suis de jure nobis facere. This personal service and process of time degenerated into pecuniary commutations or aids, and at last even the military tenures of the feudal system were abolished at the castration, by Statute 12 Car. Roman 2, c. 24. In the meantime, we are not to imagine that the kingdom was left wholly without defense in case of domestic insurrections, or the prospect of foreign invasions. Besides those who by their military tenures were bound to perform 40 days' service in the field, first the Assize of Arms, enacted 27 Hen. Roman 2 and afterwards the Statute of Winchester, under Edward I obliged every man, according to his estate and degree, to provide a determinate quantity of such arms as were then in use, in order to keep the peace. And constables were appointed in all hundreds by the latter statute to see that such arms were provided. These weapons were changed by the Statute 4 and 5 ph. and m.c. 2 into others of more modern service, but both this and the former provisions were repealed in the reign of James I. While these continued in force, it was usual from time to time for our princes to issue commissions of array, and send into every county officers in whom they could confide to muster and array, or set in military order, the inhabitants of every district, and the form of the commission of array was settled in Parliament in the 5 Hen. Roman 4 so as to prevent the insertion therein of any new penal clauses, but it was also provided that no man should be compelled to Rushworth, Part 3, 379 go out of the kingdom at any rate, nor out of his shire, but in cases of urgent necessity. Nor should provide soldiers unless by consent of Parliament. About the reign of King Henry Roman 8 or his children, lieutenants began to be introduced as standing representatives of the crown, to keep the counties in military order, for we find them mentioned as known officers in the Statute 4 and 5 ph. and m.c. 3, though they had not then been long in use, for Camden speaks of them in a time of Queen Elizabeth, as extraordinary magistrates constituted only in times of difficulty and danger, but the introduction of these commissions of lieutenancy, which contained in substance the same powers as the old commissions of array, caused the latter to fall into disuse. In this state things continued, till the repeal of the Statutes of Armour in the reign of King James I. After W. Litch, when King Charles I had, during his northern expeditions, issued commissions of lieutenancy and exerted some military powers which, having been long exercised, were thought to belong to the crown, it became a question in the Long Parliament, how far the power of the militia did inherently reside in the king, being now unsubjected by any statute, and founded only upon immemorial usage. This question, long agitated with great heat and resentment on both sides, became at length the immediate cause of the fatal rupture between the king and his parliament, the two houses not only denying this prerogative of the crown, the legality of which perhaps might be somewhat doubtful, but also seizing into their own hands the entire jx were. Of the militia, of the illegality of which step there could never be any doubt at all. Soon after the restoration of Charles Roman II, when the military tenures were abolished, it was thought proper to ascertain the power of the militia, to recognize the sole right of the crown to govern and command them, and to put the whole into a more regular method of military subordination and the order infirmed by the forehand. Ly. c. 13. See Hell in its first institution to have been Islam, Con. Hist. Vol. ILCH. Roman 9. Much civil and judicial as military. The 15 Rim. 75. First commissions styled the Lord du Brit. 103, edit. 1594. This great tenants, though king's justices as well as office, was first created in though third-year lieutenants, and they were to inquire of Edward vi in consequence of though all treasons. A.C. Stripos Eccles. Mem. Many disturbances in several countries too. 178. Coleridge. By though followers of the old religion. 13 Car. Ilsen. L.C. G. 13 and 14 Car. Against the new establishment. It seems Roman 2. C. 3. 15 Car. Roman 2. C. 4. Military and maritime states, which the militia now stands by law, is principally built upon the statutes which were then enacted. They have no doubt been repealed, but many of their provisions are reenacted, with the addition of some new regulations, by the present militia laws. The general scheme of which is to discipline a certain number of the inhabitants of every county, chosen by ballot if necessary, and to serve for a period not exceeding 6 years, the person so chosen or drawn being compelled to serve or procure a substitute. For the last half-century the militia force, whenever called out, has been sufficiently supplied with volunteers, without having recourse to the compulsory process of the ballot, the right to put in force which has been from time to time suspended by special acts of Parliament. The militia regiments were formerly officered by the Lord Lieutenant, the Deputy Lieutenants, and other principal landholders, under a commission from the Crown, a certain qualification in real property being required for each rank. The property qualification of officers below the rank of captain was abolished by the Statute 15 and 16 Vict. C. 50, and personal estate was at the same time made a sufficient qualification for deputy lieutenants, captains, and officers of higher rank. No property qualification is now required, and all officers are appointed directly by the Crown, the first commission of sub-lieutenant only being given to persons recommended by the Lord Lieutenant. Trademark the militia are not to be drawn out and embodied save in case of imminent national danger or great emergency, the cause being first communicated to Parliament if it be then sitting, or declared in council and notified by a proclamation if Parliament be not sitting. They are not compellable to march out of their counties, unless in case of invasion or actual rebellion within the realm, or any of its dominions or territories, nor in any case compellable to march out of the kingdom. And, therefore, during the war with Russia an Act of Parliament was necessary to enable the Queen to accept the services of the militia out of the realm. Asterisk. They are to be exercised at stated times, and their discipline in general is liberal and easy, but when drawn out into actual J 26 and 27 Vict. C. 125. C. 69 S. 9. 42 Geo. Roman 3. C. 90, 38 and 39 Vic. C. 18 and 19 Vict. C. 1. Tilly May now 69. Volunteered to servo in Malta, Gibraltar. 32 Vic. C. 13. The Channel Islands and the Isle of Sea now the Statute 38 and 39 Vict. Men. Regular troops. 381 service, they are subject to the rigor of the Mutiny Act, noticed hereafter, and the Articles of War framed under its authority, as necessary to keep them in order. This is the constitutional security which our laws have provided for the public peace, and for protecting the realm against foreign or domestic violence, and their services may, accordingly, be continued, if they think fit to join the reserve forces of militia, so as to be able to serve with the army in case of invasion or imminent danger. Degrees when the nation was engaged in war, more veteran troops and more regular discipline were esteemed to be necessary than could be expected from a mere militia, and therefore at such times more rigorous methods were put in use for the raising of armies, and the due regulation and discipline of the soldiery, which are to be looked upon only as temporary excrescences bred out of the distemper of the state, and not as any part of the permanent and perpetual laws of the kingdom. For martial law, which is built upon no settled principles, but is entirely arbitrary in its decisions, is, as Sir Matthew Hale observes, in truth and reality no law, but something indulged rather than allowed as a law. The necessity of order and discipline in an army is the only thing which can give it countenance, and therefore it ought not to be permitted in time of peace, when the courts are open for all persons to receive justice according to the laws of the land. Wherefore Thomas Earl of Lancaster being condemned at Pontefract, 15 Edwa. Roman 2 by martial law, his attainder was reversed 1 Edwa. Roman 3 because it was done in time of peace. And it is laid doth by Sir Edward Coke that if a lieutenant, or other that hath commission of martial authority, doth in time of peace hang or otherwise execute any man by colour of martial law, this is murder. For it is against Magna Charta, the petition of right. Moreover enacts, that no soldier shall be quartered on the subject without his own consent, and that no commission shall issue to proceed within this land according to martial law. And whereas, after the Restoration, Charles Roman II kept up about 5,000 regular troops, by his own authority, for guards and garrisons, which James Roman II by degrees increased to no less than 30,000, all paid from his own civil list, it was made one of the articles of the Bill of Rights ** that the raising or keeping of 30 and 31 vict. c. 111. P3 car. IC. 1. 31 car. Roman 2. c. 1. His. c. LCE. 2. 1 Stat 1. WR&M. The military and maritime states. Standing army within the kingdom in time of peace, unless it bow with the consent of Parliament, is against law. But as the fashion of keeping standing armies, which was first introduced by Charles Roman 7 in France, AD 445, has long universally prevailed over Europe, though some of its potentates, being unable themselves to maintain them, are obliged to have recourse to richer powers, and receive subsidiary pensions for that purpose, it has also for many years past been annually judged necessary by our legislature for the safety of the kingdom, the defense of the possessions of the Crown of Great Britain, and the preservation of the balance of power in Europe, to maintain even in time of peace a standing body of troops, under the command of the Crown, who are however ipso facto disbanded at the expiration of every year, unless continued by Parliament. To prevent the executive power from being able to oppress, says Baron Montesquieu, it is requisite that the armies with which it is entrusted should consist of the people, and have the same spirit with the people, as was the case at Culm till Marius new modelled the legions by enlisting the rabble of Italy, and laid the foundation of all the military tyranny that ensued. Nothing then, according to these principles, ought to be more guarded against in a free state, than making the military power, when such a one is necessary to be kept on foot, a body too distinct from the people. Like ours, it should wholly be composed of natural subjects *. It ought only to be enlisted for a short and limited time. The soldiers also should live intermixed with the people. No separate camp, no barracks, no inland fortresses should be allowed. And perhaps it might be still better, if, by dismissing a stated number, and enlisting others at every renewal of their term, a circulation could be kept up between the army and the people, and the citizen and the soldier be more intimately connected together. To keep this body of troops in order, an annual Act of Parliament likewise passes, for punishing mutiny and desertion, and for the better payment of the army and their quarters. This. Robertson, Oha. V. I. 94. Foreigners, during the continuance of the SP. L. 11-6, war with Russia. The Crown was authorized by 18 and the King retains the power of the 19 vict. C2, passed only after consider sword, but the Parliament retains that of able debate and opposition to enlist the purse, so that they must both agree. Annual Mutiny Act 383 statute commences with the important recital that the raising or keeping a standing army within the United Kingdom of Great Britain and Ireland in time of peace, unless it be with the consent of Parliament, is against law. But that it is adjudged necessary by the Sovereign and Parliament, that a body of forces should be continued for the safety of the kingdom, and the defence of the possessions of the Crown. The statute next limits the number of forces, and after further reciting that no man can be prejudged of life or limb or subjected in time of peace to any kind of punishment within this realm by martial law, or in any other manner than by judgment of his peers, and according to the known and established laws of this realm. Yet, nevertheless, it being requisite, for the retaining all the before-mentioned forces in their duty, that an exact discipline be observed, and that soldiers who shall mutiny or stir up sedition or shall desert Her Majesty's service or be guilty of crimes and offences to the prejudice of good order and military discipline be brought to more exemplary and speedy punishment than the usual forms of the law will allow. It proceeds to confer power on the sovereign to make articles of war for the better government of the forces, with a limitation that no person shall by such articles of war be subject to suffer any punishment extending to life or limb, or be kept in penal servitude, except for crimes which are expressly made punishable in this way by the statute itself. After enumerating the persons subject to its enactments, the statute proceeds to authorize the holding of general, garrison, district and regimental courts-martial, to specify the respective powers of each, and to prescribe the mode in which they are to be constituted and held, the procedure on trials, the examination of witnesses on oath, and the preservation of the sentences of the court. The jurisdiction generally is to try and punish offences against the articles of war, and the provisions of the statute itself, by which, among other things, it is enacted, that if any officer or soldier shall excite or join any mutiny, or, knowing it, shall not give notice to the commanding officer, or shall desert her to draw the sword, or else leave it in the old recital that this was necessary for be cabbard, which is the beat place for it. The preservation of the balance of power Whitlock, mem. in Europe has at last been abandoned. See, for instance, 38 Vict. C. 7. The 384 The military and maritime states Majesty's service or sleep upon his post or leave it before he is relieved, or hold correspondence with a rebel or enemy, or strike or use violence to his superior officer or shall disobey his lawful commands. Such offender shall suffer such punishment as a court-martial shall inflict, though it extend to death itself. The statute provides for the trial by court-martial of any officer or soldier who embezzles, steals, or willfully misapplies money, provisions, ammunition, or other stores, and for the punishment of any such offense by penal servitude, fine, imprisonment, or reduction to the ranks. No court-martial can, in time of peace, sentence any soldier to corporal punishment, but, while in actual service, corporal punishment not exceeding 50 lashes may be inflicted for mutiny, insubordination, desertion, drunkenness, disgraceful conduct, or breach of the articles of war. In certain cases, forfeiture of pay may be imposed as part of the sentence. Minute regulations are made by the statute as to the enlistment and attesting of recruits, for the billeting of troops and the supply of carriages, and for the apprehending and detaining of deserters by summary proceedings before justices, the enactments of the Petition of Right being suspended in that respect. The object of the Mutiny Act, therefore, is to create a court invested with authority to try those who are a part of the army, in all their different descriptions of officers and soldiers, and the object of the trial is limited to breaches of military duty. Even by that extensive power granted by the legislature to the Crown to make articles of war, these articles are to be for the better government of the forces, and can extend no further than they are thought necessary to the regularity and discipline of the army. To these courts, all persons who are or shall be commissioned or in pay as an officer, or who are or shall be listed or in pay as a non-commissioned officer or soldier, are amenable in respect of all matters specified in the Articles of War, the offences against which can only be tried by courts-martial, the courts of common law having no power to interfere to protect the soldier, so long as these tribunals do not exceed their jurisdiction. Asterisk. However expedient the most strict regulations may be in time of actual war, yet in times of profound peace a little relaxation of military rigor would not, one should hope, be productive of. See the judgment of Lord Loughborough in Grant v. Good to Hen. Mutiny Act 385 much inconvenience. And, upon this principle, though, by the statutes 18 Henry vi. c. 19 and 2 and 3 Edwa. vi. c. 2, which remained in force till recently, though not attended to, desertion in time of war was made a capital felony, and triable by a jury and before justices at the common law, yet, by our present military laws, a much lighter punishment is inflicted for desertion in time of peace. So, by the Roman law also desertion in time of war was punished with death, but more mildly in time of tranquility. But our Mutiny Act makes no such distinction. For any of the faults above mentioned are equally at all times punishable with death itself, if a court-martial shall think proper. This discretionary power of the court-martial is indeed to be guided by the directions of the Crown, which, with regard to military offences, has almost an absolute legislative power. Her Majesty, says the Act, may make articles of war for the better government of Her Majesty's forces, which shall be judicially taken notice of by all judges and in all courts whatsoever, a vast and most important trust, an unlimited power to create crimes, and annex to them any punishments not extending to life or limb. These are indeed forbidden to be inflicted except for crimes declared to be so punishable by this Act, which crimes we have just enumerated, and among which we may observe that any disobedience to lawful commands is one. Perhaps in some future revision of this Act, which is in many respects hastily penned, it may be thought worthy the wisdom of Parliament to ascertain the limits of military subjection, and to enact express articles of war for the government of the army, as * has been done * more than once. For the government of the navy, especially as, by our present constitution, those who serve their country and receive pay as militia are annually subjected to the same arbitrary rule during their time of exercise. One of the greatest advantages of our English law is that not only the crimes themselves which it punishes, but also the penalties which it inflicts, are ascertained and notorious. Nothing is left to arbitrary discretion. The sovereign by his judges dispenses what the law has previously ordained, but is not himself the legislator. How much therefore it is to be regretted that a set of men, whose bravery has so often preserved the liberties of their Stat. Law. Rev. Act 1863. ff. 49 10 28. The military and maritime states country should be reduced to a state of servitude in the midst of a nation of freemen. For as Sir Edward Coke informs us, it is one of the genuine marks of servitude to have the law, which is our rule of action, either concealed or precarious. Misera est servitus. Euhegis est vagum ad incognitum. Nor is this state of servitude quite consistent with the maxims of sound policy observed by other free nations. For the greater the general liberty is which any state enjoys, the more cautious has it usually been in introducing slavery in any particular order or profession. These men, as Baron Montesquieu observes, seeing the liberty which others possess, and which they themselves are excluded from, are apt, like eunuchs in the eastern seraglios, to live in a state of perpetual envy and hatred towards the rest of the community, and indulge a malignant pleasure in contributing to destroy those privileges to which they can never be admitted. Hence have many free states, by departing from this rule, been endangered by the revolt of their slaves. While in absolute and despotic governments, wherein no real liberty exists, and consequently no invidious comparisons can be formed, such incidents are extremely rare. Two precautions are therefore advised to be observed in all prudent and free governments. 1. To prevent the introduction of slavery at all. Or 2. If it be already introduced, not to entrust Helio slaves with arms, who will then find themselves an overmatch for the freemen. Much less ought the soldiery to be an exception to the people in general, and the only state of servitude in the nation. The time of service in the army is now limited to 12 years *, but the enlistment may be for a part of the time in the army, and the residue in the reserve forces, established under the Statute 30 and 31 Vict. C. 110, and to which several of the provisions of the Mutiny Act apply. But, as soldiers by the Mutiny Act are thus put in a worse condition than any other subjects, so, by the humanity of our standing laws, they are in some cases put in a much better. By Statute 43 Olis. C. 3, a weekly allowance was granted, to be raised in every county for the relief of soldiers sick, hurt, and maimed. And although this particular statute has been repealed, such soldiers are by various acts now entitled to pensions. Nor must the Royal Hospital at S.B. L. 1512, 33 and 34 Vict. Maritime State 387 Chelsea, for such as are worn out either duty, be forgotten. * by the Annual Mutiny Act, soldiers cannot be taken on any process or execution, except for indictable offences or for debts amounting to 30z. Exclusive of costs fn. Any soldiers in actual military service may make nuncupative wills, and dispose of their goods, wages, and other personal chattels, without those forms, solemnities, and expenses, which the law requires in other cases. Our law does not indeed extend this privilege so far as the civil law, which carried it to an extreme that borders upon the ridiculous. For if a soldier, in artivlo mortis, wrote anything in bloody letters on his shield, or in the dust of the field with the sword, it was a very good military testament. Finally, to encourage habits of frugality, military savings banks have been recently established for the soldiers, and other facilities given for their education and amusement. Besides the militia and regular army, numerous corps of yeomanry and volunteers were organized during the war with France. Several of the former are still annually mustered for a short period for the purpose of exercise and drill *, but they are few in number when compared with the rifle and artillery volunteers, which have recently sprung into existence. And thus much for the military state, as acknowledged by the laws of England. The Moss/Reim state is nearly related to the former. The Royal Navy of England has ever been its greatest defence and ornament. It is its ancient and natural strength, the floating bulwark of the island, an army, from which, however strong and worthful, no danger can ever be apprehended to liberty. And accordingly it has been assiduously cultivated, even from the earliest ages. To so much perfection was our naval reputation arrived in the 12th century, that the Code of Maritime Laws, which are called the Laws of Olron, and are received by all nations in Europe as the ground and substruction of all their marine constitutions. 47 Geo. M. Sin. 2c. 25. 7 Geo. Roman 4. Ca. 6. 21. 15. C. 16. 2 and 3 will. Roman 4. C. 106. 5 and 6. 5 and 6 Vict. C. 71. 8 and 9 Vict. C. 27. Vic. C. 70. G and 7 Vic. C. 31. 10, 11, 12, and 13 Vict. C. 71. 22 and 23 Vict. C. 20. Vic. 0. 4. 44 Geo. Roman 3. C. 54. 44 Geo. Roman 3. C. 94. 38 Vict. C. 7s. 40. 46 Geo. Roman 3. C. 125. 56 Geo. Roman 3. C. 39. Stat. 29 Car. Roman 2. C. 3. 5 and 6 W. And M. 57 Geo. UI. C. 44. 7 Geo. Roman 4. C. 58. C. 21. Section 6. 55 Geo. Roman 3. C. 104. 7 will. The Volunteer Act, 18 Lie 3. Though Volun Roman 4. And 1 Vict. C. 26. Tier Act 1869. 2. And Maritime States. Was confessedly compiled at the Isle of Oran on the coast of France, then part of the possessions of the Crown of England. And yet, so vastly inferior were our ancestors in this point to the present age, that even in the maritime reign of Queen Elizabeth, Sir Edward Coke thinks it matter of boast that the Royal Navy of England then consisted of 30 ships. Many laws have been made, having for their immediate object the supply of the Royal Navy with seamen, for their regulation when on board, and to confer privileges and rewards on them during and after their service. First, for their supply. The power of impressing seafaring. Blackstone, quoting Forins 144, Caugenes de Lemmer, 2, says, by Archinkicherdai. But this is a mistake. Lutke's inquiry into the origin of the laws of Olron, the flourishing coalition of our marine, was long attributed to the provisions of the statutes called Teli Navigation Acta, whereby it was said, the constant increase of English shipping and seamen was not only encouraged, but rendered unavoidably necessary by the Statute 5 Ric. Roman 2. c. Free, in order to augment the navy of England, then greatly diminished, it was ordained that none of the king's liege people should slip any merchandise out of or into the Arfium, but only in ships of the king's legions, on pain of forfeiture. In the next year, by Statute 6 Ric. Roman 2. c. 8, this provision was enervated, by only obliging the merchants to give English ships, if able and sufficient, the preference. But one of the most important statutes for the trade and commerce of these kingdoms was that Navigation Act, the rudiments of which were first framed in 1650, with a narrow partial view, being intended to mortify our own sugar islands, which were disaffected to the Parliament, and still held out for Charles Roman II by stopping the gainful trade which they then carried on with the Dutch, and at the same time to clip the wings of those our opulent and aspiring neighbors. This prohibited all Dutch ships of foreign nations from trading with any English plantations without license for in the Council of State. In 1551, the prohibition was extended also to the mother country, and no goods were suffered to be imported into England, or any of its dependencies, in any other than English bottoms, or in the ships of that European nation of which the merchandise imported was the genuine growth or manufacture. At the Restoration the former provisions were continued by Statute 12 Car. Roman 2. c. 18, with this very material addition, that the master and 3/4 of the mariners should also be English subjects. It would be an idle and wearisome task now to trace the various navigation acts, maintaining, down to a recent period, the same leading feature of exclusive trading, by which, as the titles of the acts show, it was thought British shipping and navigation were encouraged. The first great step in favor of free trade was effected by 12 and 13 Vict. c. 29, whereby the exclusive privileges of British ships were limited in effect to the coasting trade, but that act was almost entirely repealed by 16 and 17 Vict. c. 107, and the entire trade of this country thrown open to vessels of all nations, with very satisfactory results hitherto, both as regards commerce and private enterprise, and no ill effect on the manning of the Royal Navy. Navigation Acts, etc. 389 men for the sea service by the Royal Commission has been a matter of some dispute, and submitted to with great reluctance, though it has very clearly and learnedly been shown backlash and by Sir Michael Foster, that the practice of impressing and granting powers to the Admiralty for that purpose is of very ancient date, and has been uniformly continued by a regular series of precedents, whence he concludes it to be part of the common law, and its legality cannot now be doubted. The difficulty arose from this, that no statute expressly declared this power to be in the Crown, though many of them very strongly implied it. The Statute 2 Ric. Roman 2. c. 4 speaks of mariners being arrested and retained for the king's service, as of a thing well known and practiced without dispute, and provides a remedy against their running away. By 2 and 3 ph. and mc. 16, if any waterman, who uses the river Thames, shall hide himself during the execution of any commission of pressing for the king's service, he is liable to heavy penalties. by another 5 Aliz. c. 5. No fisherman shall be taken by the Queen's Commission to serve as a mariner, but the commission shall be first brought to 2 justices of the peace inhabiting near the sea coast where the mariners are to be taken, to the intent that the justices may choose out and return such a number of able-bodied men as in the commission are contained to serve Her Majesty. By other statutes, especial protections are allowed to seamen in particular circumstances to prevent them from being impressed. And lastly, by the statute 5 and 6 will. Roman 4. c. 24. It is enacted that no person shall be detained against his consent in the naval service for a longer period than 5 years, that after such service he shall be entitled to a certificate and protection from impressment, and that in the event of his continuing to serve, he shall be entitled to a fresh bounty. Fair men are also said to be privileged from being impressed, at common law. All which do most evidently imply a power of impressing to reside somewhere, and if anywhere, it must, from the spirit of our Constitution, as well as from the frequent mention of the King's Commission, reside in the Crown alone, and accordingly it has been so determined. But, beside this method of impressing, which is only defensible. Rep. 154. 5t. b. 277. 5 and 6 yu. Roman 4. c. 24, 88. See also column 245, bar. Observe 2 and 5, on the stat, 334. Amended by 16 and 17 Vict C. 69. Sex fee, TTMS, Calp. 512, X. P. Fox. Rex fee, Tubbs, Calp. 512. The military and maritime states. From public necessity, to which all private considerations must give way, there are other ways that tend to the increase of seamen, and manning the Royal Navy. And the voluntary enlistment of seamen is now so effectually encouraged that the ships of the Navy are effectually manned without any recourse to the revolting system of kidnapping which was formerly carried on during war. Guardians are authorized to bind out poor boys' apprentices to masters of merchantmen, and great advantages in point of wages are given to seamen in order to induce them to enter into the naval service, or the reserve volunteer forces. About the middle of King William's reign a scheme was set on foot for a register of seamen to the number of 30,000, for constant and regular supply of the King's fleet, with great privileges to the registered men, and, on the other hand, heavy penalties in case of their non-appearance when called for. This registry, being judged to be ineffectual as well as oppressive, was abolished by 9 Ann. c. 21. But has been again revived with careful provisions for forming and maintaining a register of all seamen engaged in the merchant service, the masters and mates of which may also be enrolled to serve as officers of reserve to the Royal Navy. 2. The method of ordering seamen in the Royal Fleet, and keeping up a regular discipline there, is directed by certain express rules, articles, and orders, first enacted by the authority of Parliament soon after the Restoration, and now contained in the Statute 29 and 30 Vict. c. 109. In these articles of the Navy almost every possible offence is set down, and the punishment thereof annexed, in which respect THQ seamen have much the advantage over their brethren in the land service, whose articles of war are not enacted by Parliament, but framed from time to time at the pleasure of the Crown. Yet from whence this dis 5 and G will. Roman 4, c. 24, 113 and 17 Vic. 17 and 18 Vic. c. 104. c. 69, 17 and 18 Vict. c. 18. Stat. 13 Car. Roman 2. Sin. 1 c. 9. The. 17 and 18 Vict. O. 104 SS. 141-145. Navy articles were remodeled by 22. Stat. 31 Geo. Roman 2. c. 10. Geo. Roman 2 c. 33, and afterwards amended. c. 22 and 23 Vict. c. 40 is to reeve first by 19 Geo. Roman 3. c. 17, and latterly serve force of seamen, 26 and 27 vict. C. By 10 and 11 vict. C. 59 and other acts 69 and 35 and 36 vict. C. 73, as to officers all of which have now been consolidated of merchant service, and 35 and 36 vict. In 1. Act to make provision for the sea, 77 as to naval artillery volunteers. Discipline of the Navy. The Merchant Shipping Act, 1854. Maritime laws. 391 Tinction arose, and why the executive power, which is limited so properly with regard to the Navy, should be so extensive with regard to the Army, it is hard to assign a reason, unless it proceeded from the perpetual establishment of the Navy, which rendered a permanent law for their regulation expedient, and the temporary duration of the Army, which subsisted only from year to year, and might therefore with less danger be subjected to discretionary government. But whatever was apprehended at the first formation of the Mutiny Act, the regular renewal of our standing force at the entrance of every year has made this distinction idle. For, if from experience we may judge of future events, the Army is now lastingly engrafted into the British Constitution, with this singularly fortunate circumstance, that any branch of the legislature may annually put an end to its legal existence, by refusing to concur in its continuance. The Royal Marine Forces are subject to the discipline of the Navy, while on board ship, but are regulated, while on shore, by an annual Marine Mutiny Act, containing a similar recital, and corresponding provisions to those contained in the annual act applicable to the Army. 3. With regard to the privileges conferred on sailors, they are pretty much the same with those conferred on soldiers, with regard to relief when maimed, or wounded, or superannuated, by pensions out of the funds of the Royal Hospital at Greenwich. With regard also to the power of making nimcupative testaments. And farther, no seaman on board Her Majesty's ships can be arrested for any debt unless the same were contracted previously to his having entered the service and be sworn to amount to at least £30. 28 and 29 vict. C. 89, 35 and 36 vict. E. 67. 392. Chapter Roman 14. Of master and servant. Having thus commented on the rights and duties of persons as standing in the public relations of magistrates and people, the method I have marked out now leads me to consider their rights and duties in private economical relations. The three great relations in private life are, 1. That of master and servant, which is founded in convenience, whereby a man is directed to call in the assistance of others, where his own skill and labor will not be sufficient to answer the cares incumbent upon him. 2. That of husband and wife, which is founded in nature, but modified by civil society. The one directing man to continue and multiply his species, the other prescribing the manner in which that natural impulse must be confined and regulated. 3. That of parent and child, which is consequential to that of marriage, being its principal end and design. And it is by virtue of this relation that infants are protected, maintained, and educated. But, since the parents, on whom this care is primarily incumbent, may be snatched away by death before they have completed their duty, the law has therefore provided a fourth relation. 4. That of guardian and ward, which is a kind of artificial parentage, in order to supply the deficiency, whenever it happens, of the natural. Of all these relations in their order. In discussing the relation of master and servant, I shall firstly consider the several sorts of servants and how this relation is created and destroyed. Secondly, the effect of this relation with regard to the parties themselves, and, lastly, its effects with regard to other persons. As to the several sorts of servants, I have formerly observed that pure and proper slavery does not, nay cannot, subsist in state of slavery. 393 England, such, I mean, whereby an absolute and unlimited power is given to the master over the life and fortune of the slave. And indeed it is repugnant to reason, and the principles of natural law, that such a state should subsist anywhere. The three origins of the right of slavery, assigned by Justinian are all of them built upon false foundations. As first, slavery is held to arise jure gentium from a state of captivity in war, whence slaves are called mancipia, quasi manu capii. The conquerors say that civilians had a right to the life of his captive, and, having spared that, has a right to deal with him as he pleases. But it is an untrue position, when taken generally, that by the law of nature or nations a man may kill his enemy. He has only a right to kill them in particular cases, in cases of absolute necessity, for self-defense, and it is plain this absolute necessity did not subsist, since the victor did not actually kill him, but made him prisoner. War is itself justifiable only on principles of self-preservation, and therefore it gives no other right over prisoners, but merely to disable them from doing harm to us, by confining their persons. Much less can it give a right to kill, torture, abuse, plunder, or even to enslave an enemy, when the war is over. Since, therefore, the right of making slaves by captivity depends on a supposed right of slaughter, that foundation failing, the consequence drawn from it must fail likewise. But, secondly, it is said that slavery may begin **jure divili, when one man sells himself to another. This, if only meant of contracts to serve or work for another, is very just, but when applied to strict slavery, in the sense of which we speak, is also impossible. Every sale implies a price, a quid pro quo, an equivalent given to the seller in lieu of what he transfers to the buyer. But what equivalent can be given for life and liberty, both of which, in absolute slavery, are held to be at the master's disposal? His property, also, the very price he seems to receive, devolves ipso facto to his master the instant he becomes his slave. In this case, therefore, the buyer gives nothing, and the seller receives nothing. Of what validity then can a sale be which destroys the very principles upon which all sales are founded? Lastly, we are told that besides these two ways by which slaves find or are acquired, they may also be hereditary. Servi naswer. The children of acquired slaves are jurinaires, by lust. 1, 3, 4. Montesq. SQ. L. Roman 15. 2. Master and servant. A negative kind of birthright, slaves also. But this, being built on the two former rights, must fall together with them. If neither captivity nor the sale of one's self can by the law of nature and reason reduce the parent to slavery, much less can they reduce the offspring. Upon these principles the law of England abhors, and will not endure the existence of, slavery within this nation, so that when an attempt was made to introduce it by statute 1 Edw. Vi. c. 3, which ordained that all idle vagabonds should be made slaves and be fed upon bread, water, or small drink, and refuse meat, should wear a ring of iron round their necks, arms, or legs, and should be compelled by beating, chaining, or otherwise to perform the work assigned them, were it never so vile. The spirit of the nation could not brook this condition even in the most abandoned rogues, and therefore this statute was repealed in 2 years afterwards. And now it is laid down that a slave or negro, the instant he lands in England, or puts his foot on the deck of a British man of war, becomes a freeman, that is, the law will protect him in the enjoyment of his person and his property. 1. The first sort of servants acknowledged by the laws of England are mateel servants, so called from being intra emsenia, or domestics. The contract between them and their masters arises upon the hiring. If the hiring be general, without any particular time limited, the law construes it to be a hiring for a year upon a principle of natural equity that the servant shall serve, and the master maintain him, throughout all the revolutions of the respective seasons, as well when there is work to be done, as when there is not. But the contract may be made for any larger or smaller term. And is by custom determinable by a month's notice, or what is an equivalent in the case of the servant, a month's wages. 2. Another species of servants are called apprentices, from equal stat. 3 and 4 Edw. Vi. c. 16. Co. Lit. 42. Beeston v. Collier, I. Smith v. Brown, Sal. 666. Bieg. 309. Facet v. Cash 5. B. Anat. Degrees Somerset's case, 11son. Tr. 340. Loft. 904. Lilly v. Elwyn 11Q. B. 742. Rep. 1. Nolan v. Allit 2 Cr. M. and R. 54. A governess is not a domestic Fewings v. Tistol 1x. 295. Vent Ferman v. Alfred 5h. and n. Apprentices and workmen. 395. Apprender, to learn, and are usually bound for a term of years by deed indented or indentures to serve their masters and be maintained and instructed by them. This is usually done to persons of trade, in order to learn their art and mystery, and sometimes very large sums are given with them as a premium for such their instruction. But it may be done to husbandmen, nay, to gentlemen and others. And children. Of poor persons may be apprenticed out by the overseers or guardians till 21 years of age to such persons as are thought fitting, who although formerly eligible to take them, are no longer subject to this involuntary engagement. For which purposes our statutes have made the indentures obligatory, even though such parish apprentice do not execute them. Free. A third species of servants are workmen, an expression which includes laborers servants in husbandry, journeymen, artificers, handicraftsmen, miners, and any person engaged in anemoxal labor, who are only hired by the day or the week and do not live inter masnia as part of the family. Concerning laborers, the statute 5 is c. 4 made many regulations. 1. Directing that all ixer 8 on 8 having no visible effects might be compelled to work. 2. Defining how long they should continue at work in summer and in winter. 3. Punishing such as left or deserted their work. 4. Entering the justices at sessions or the sheriffy of the county to settle their wages. And 5. Inflicting penalties on such as either gave or exacted more wages than were so settled. This act and several others attempting to regulate the value of labor have now been repealed, and differences between masters and workmen, an expression which includes apprentices to a workman, upon whose binding either no. Stat. 43 is c. True. 8 and 9 w. and any visible livelihood were by this act c. 30, 18 gu. Roman 3. c. 47. * 42 gu. Roman 3. Compellable by 2 justices to go out 46, 56 geo. Roman 3. c. 139. 4 and 5 will. Roman 4. To ervis in the husbandry or certain c. 35, 7 and 8 vic. c. 101. 14 and 15 vic. Specific trades for the promotion of c. 11, and as to the sea service, the honest indutry. And no master was to Merchant Shipping Act 1/854. Put away his servant or servant leave J 7 and 8 vict. c. 101 a. 13. His master, after being so retained, either * all single men between 12 years before or at the end of his term, without old and 60 and married ones under a quarter's warning, unless upon reason 30 years of age, and all single women able cause to be allowed by a justice of between 12 and 40, not having the peace premium or a premium not exceeding 25, has been paid, or who has been apprenticed under the acts relating to the relief of the poor, may now be determined either by the justices of the peace or in the county court. The law, however, imposes certain restraints in particular instances upon the natural freedom to contract for the value of his labor which every person ought to enjoy. Thus the employment of children in factories is regulated by statute, as is also the employment of women and children in mines, and that of children in agriculture under 8 prohibited, and, above that age, made conditional on their having previously received a certain amount of education. 4. Merchant seamen are, from the increase of commerce and the consequent number of persons employed in this service, entitled to be and are classed as a distinct species of servants, whose contracts and conduct are in a great measure regulated by recent acts of Parliament. * 5. There is yet a 5th species of servants, if they may be so called, being rather in a superior, a ministerial, capacity, such as stewards, factors, and bailiffs, whom however the law considers as servants, pro tempore, with regard to such of their acts as affect their master's or employer's property, which leads me to consider. This jurisdiction of the justices is p. 36 and 37 vict. c. 67. Exercised in a court of summary juris * see the Merchant Shipping Act diction that is, at petty sessions or in a 1854, amending and consolidating per police court. But to meet the objection via statutes, and amended by 18 and 19 of the workmen, that questions in which vict. C. 91, 35 and 36 vic. C. 73. The they are interested are decided in Employers and Workmen Act 1875, does criminal and not a civil court, T-Listat. Not apply to seamen or apprentices to the 38 and 39 vict. C. 90 s. 4. Expressly pro sea service. Vides that this criminal court is / or the. Upon this relation are founded all purposes of that act to be deemed a court the mutual rights, duties, and liabilities O/Sci OT 7J MMDTCFE on, a kind of legislation or principle and agent, constituting a which can only excite the smile, as the very large and important branch of the process of the court must be served and law merchant, which although part executed by police constables, the law in England does not fall. 38 and 39 vict. C. 86. Within the range of these elementary. 27 and 28 vict. C. 48, and 30 and 31 commentaries. The reader may on this vict. C. 103, 33 and 34 vict. C. 62, 34 and subject go referred to the treatise on 35 vic. C. 104. Mercantile Law by the late John William. 35 and 36 vict. C.C. 76 and 77. Smith. Roman 2. The manner in which this relation, a service, affects either the master or servant. The master is in general bound to supply a domestic servant with necessary food and lodging, and if, when legally bound to do so, he either neglects or refuses, he may be indicted under the statute 24 and 25 vict. C. 100 s. 26 or prosecuted summarily under the statute 38 and 39 vict. C. 86. The punishment in the former case may be penal servitude, in the latter a fine not exceeding 20 z, or an imprisonment not exceeding 6 months. The latter statute applies to apprentices and to cases in which a master is bound to provide clothing or medical aid, which in many cases he contracts to do. It is said that a master may by law correct his apprentice for negligence or other misbehavior, so it be done with moderation : but that if the master or master's wife beats any other servant of full age, it is good cause of departure. On the other hand, a master is entitled to have from his servant the proper performance of his duties as servant and obedience to all lawful orders in reference thereto, on failure of which he may put an end to the hiring. A servant therefore may be dismissed without notice for willful disobedience to it. Formerly by apprenticeship under indentures, a person gained a settlement in that parish wherein he last served 40 days, as any one D.L. who being bound had served for a year. And persons serving 7 years as apprentices to any trade formerly had also an exclusive wriglet to exercise that trade in any part of England, and this by the stat. 5 is. C. 4. Which with regard to the exclusive part of it was by turns looked upon as a hard law, or as a beneficial one, according to the prevailing humor of the times, which occasioned a great variety of resolutions in courts of law concerning it, and frequent attempts for its repeal. At common law every man might use what trade he pleased, but this statute restrained that liberty to such as had served as apprentices. The adversaries to which provision said that all restrictions which tend to introduce monopolies were pernicious to trade, the advocates for it alleged talent and skillfulness ill trades was equally detrimental to the public as monopolies. This reason indeed only extended to such trades, in the exercise whereof skill was required. But another of Telier arguments was that apprenticeships are useful to the commonwealth, by employing of youth, and learning them to be early industrious, but that no one would be induco to undergo a 7 years' servitude, if others, though equally skillful, were allowed the same advantages without having undergone the same discipline. However, the enactment of the statute on which this monopoly was founded was repealed by the Statute 54 Gu. Roman 3. C. 96. And by the Act 5 and G. Will. Roman 4. C. 76. The exclusive right of trading in boroughs was abolished. This act did not extend to the City of London, where several customs and bylaws excluding other than freemen from travelling within the city existed till abandoned by the Common Council. Gilhert v. Flechthier, Crow. Car. 179. X v. Du Hamel, Tusho. 289. F. N. Lie. 1G8, Bro. Aber. Tit. Lauren 51. Trespass 349. Master and servant. Lawful order. Or neglect of duty, asterisk, and in such cases he is not entitled to any wages from the day he is discharged, except those then to : and a domestic servant may also be sent away for moral misconduct / if wrongfully discharged. The servant is entitled to wages up to the end of the current period of his service / but if a servant, who is to be paid quarterly, or yearly, or at any other fixed time, improperly leaves his service, or is guilty of such misconduct as to justify his discharge during the currency of any such period, he is not entitled to wages for any part thereof * even to the day he quits. For by service all servants and workmen become entitled to wages, payment of which may be enforced either by an order of the justices, or in the county court, but the statute giving justices jurisdiction in these cases does not extend to domestic servants, nor to seamen or apprentices to the sea service. Spain v. Amat 2 Stark. 256, Turner Y. Mason, N.W. 112. Callow v. Bronk Jaser, 4C, and P. 518. Asterisk Rohingyan v. Hyman, 3 Esp. 235. Why such a pregnancy in a female servant, called cut. 14. Absence on an unfounded pretense, Crawford v. Bade 1 Show. Perry. C. 124. Pretending to be a partner when only a clerk, Ammer v. Theron 9 Ad. And L. 548. Gendel v. Pontigny 4 Camp. N. P. 375. Turner v. Bobinson 5b. And Ad. 789. The Employers and Workmen Act 1875 confers on the county court in any disputes between employers and workmen, in addition to the jurisdiction it already possesses, power to adjust and set off if the one against the other, all subsisting claims on the part either of employer or workman, incidental to the relation between them, whether such claims are liquidated or unliquidated, and are for wages, damages, or otherwise, or to rescind any contract between the employer and the workman upon such terms as it thinks just, or where it might award damages for breach of contract, if the defendant be willing to give and the plaintiff to accept security for the performance of the contract, to order performance thereof. In disputes between employers and workmen, the justices may order payment of any sum found to be due as wages, or damages, or otherwise, and may exercise all or any of the powers of a county court, but only where the amount claimed or the security to be given does not exceed £10. The justices have a similar jurisdiction in disputes between any apprentice to whom the Act applies and his master, and therein may make an order directing Eli apprentice to perform his duties under the apprenticeship, or rescind the instrument of apprenticeship, and order the whole or any part of the premium paid on the binding of the apprentice to be repaid. When an order is made directing an apprentice to perform his duties under the apprenticeship, the justices may, if the apprentice fails to comply, order him to be imprisoned for a period not exceeding 14 days. Eli justices may also order any person liable, under the instrument of apprenticeship, for the good conduct of the apprentice, to pay damages for any breach of Eli contract of apprenticeship to an amount not exceeding the limit, if any, to which he is liable under the instrument of apprenticeship. Payment of wages. 399 And wages must as a rule be paid in money, 4 by 1 and 2 will. Roman 4. C. 37, commonly called the Truck Act, the payment of wages in goods or otherwise than in the current coin of the realm, is prohibited. In like manner, the payment of the wages of persons employed in mines or collieries at public houses is forbidden, asterisk, so that wages so paid may in either case be recovered as if not paid at all. Statutory provisions have also been made for the decision by arbitration of disputes as to wages between masters and workmen. And it may be observed in this place that the law, in some respects, places the servant's right to wages very high. Thus in the payment of the debts of a testator or intestate they rank before specialty debts, and by the bankrupt law the salaries of the clerks or servants of the bankrupt for not exceeding 4 months, and the wages of laborers or workmen for not exceeding 2 months, may be paid in full, and proof made for any balance exceeding that amount registered. One important incident to the relationship of master and servant must also be mentioned. The latter cannot in general recover damages from his master for a mere non-feasance on his part, nor for the negligence of a fellow servant in the course of his employment, for he is as it were rowing in the same boat with them, and is supposed on entering the service to agree to incur any danger attaching to his position. In order, however, to bring the master within the benefit of Tli's rule of law, if the injury were the act of the fellow servant, the latter must be a person of ordinary skill and competence for the duties of his situation, although ftailing in the particular instance from which the injury to his fellow servant has arisen. Roman 3. Let us, lastly, see how strangers may be affected by this relation of master and servant. Or first, how a master may behave towards others on behalf of his servant. Secondly, what a servant may do on behalf of his master, asterisk, and thirdly, how third parties interested in the performance of the contract between these parties may enforce it. 1. First, the master may maintain, that is, abet, and assist his servant in any action at law against a stranger, whereas in 35 and 36 Vict. CC 76 and 77. In the Prize OEV, Fowler, 3M, and W. 1. Hosiery Trade, 37 and 38 Vic. C. 48. Huck Jason v. York and Newcastle. 30 and 31 Viet. C. 105. Railway Company 5X. 343. 32 and 33 Vict. C. 71 S. 32. Wiggett v. Fox, 11X. 400 Masek and Servan. General, it is an offense against public justice to encourage suits and animosities, by helping to bear the expense of them, and is called in law maintenance. A master also may bring an action against any man for beating or maiming his servant, but in such a case he must assign, as a special reason for so doing, his own damage by the loss of his service, and this loss must be proved upon the trial. A master likewise may justify an assault in defense of his servant, and a servant in defense of his master. The master, because he has an interest in his servant, not to be deprived of his service; the servant, because it is part of his duty, for which he receives his wages, to stand by and defend his master. Also, if any person do hire or retain my servant, being in my service, for which the servant departeth from me, and goeth to serve the other, I may have an action for damages against both the new master and the servant, or either of them. But if the new master did not know that he is my servant, no action lies, unless he afterwards refuse to restore him upon information and demand. The reason and foundation upon which all this doctrine is built seem to be the property that every man has in the service of his retainers, acquired by the contract of hiring, and purchased by giving them wages. 2. As for those things which a servant may do on behalf of his master, they seem all to proceed upon this principle, that the master is answerable for the act of his servant, if done by his command, either expressly given or implied. Warn qui fiat J per alium, facit per se. Therefore, if the servant commit a trespass by the command or encouragement of his master, the master shall be guilty of it, though the servant is not thereby excused, for he is only to obey his master in matters that are honest and lawful. If an innkeeper's servants rob his guests, the master is bound to restitution, for as there is a confidence reposed in him that he will take care to provide honest servants, his negligence is a kind of implied consent to the robbery. Nam qui non prohibit, com. Hall v. Hollander 4b, N.C. 660. Foster v. Stewart 3m, and s. 191. Hansel v. Stalker s. 11a. And E. 301. Degrees Burgess v. Gray, 1c. B. 578. 1. In like manner, by the laws of king the other hand, a master is not generally Alfred c. 38, a servant was allowed to responsible for the wilft as distinfied for his master, a parent for his child, gished from the negligent acts of the and a husband or father for the chastity servant, when not done by his command, of his wife or daughter, although while in his service. Savignac. Lumley v. J. 2L. and BL. 216. v. Room 60. E. 125. Gordon v. Row U. Blah TCEV. Lanyon 6T. R. 221. 4X. 365. Liabilities. 401 Prohibor possit JV bet. So likewise, if the drawer at a tavern sells a man bad wine, whereby his health is injured, he may bring an action against the master, for although the master did not expressly order the servant to sell it to the person in particular, yet his permitting him to draw and sell it at all is implicitly a general command. In the same manner, whatever a servant is permitted to do in the usual course of his business is equivalent to a general command. If I pay money to a banker's servant, the banker is answerable for it. If I pay it to a clergyman's or a physician's servant, whose usual business it is not to receive money for his master, and he embezzles it, I must pay it over again. If a steward lets a lease of a farm without the owner's knowledge, the owner must stand to the bargain, for this is the steward's business. A wife, a friend, a relation, that used to transact business for a man, are quod hoc his servants, and the principal must answer for their conduct. For the law implies that they act under a general command, and without such a doctrine as this no mutual intercourse between man and man could subsist with any tolerable convenience. If I usually deal with a tradesman by myself, or constantly pay him ready money, I am not answerable for what my servant takes upon trust, for here is no implied order to the tradesman to trust my servant, but if I usually send him upon trust, or sometimes on trust and sometimes with ready money, I am answerable for all he takes up, for the tradesman cannot possibly distinguish when he comes by my order, and when upon his own authority. If a servant, lastly, by his negligence does any damage to a stranger, the master shall answer for his neglect. If a smith's servant lames a horse while he is shoeing him, an action lies against the master, and not against the servant. But in these cases the damage must be done while he is actually employed in the master's service, otherwise the servant shall answer for his own misbehavior. Upon this principle by the common law, if a servant kept his master's fire negligently, so that his neighbor's house was burned down thereby, an action lay against the master, because this negligence happened in his service. Otherwise, if Leons v. Martin 8a, and E. 512, P.C. the rule in Vaughan v. Taffale hailed me company, Pre H. and N. 743. Vol. 402 Mastic and Servant. The servant, going along the street with a torch, by negligence sets fire to a house. Further, he is not in his master's immediate service, and must himself answer the damage personally. But now the common law is, in the former case, altered by statute *14 Geo. Roman 3. c. 78. Which ordains that no action shall be maintained against any in whose house, chamber, stable, barn, or other building, or on whose estate any fire shall accidentally begin, for their own loss is sufficient punishment for their own or telier servant's carelessness. But if such fire happens through negligence of any servant whose loss is commonly very little, such servant shall forfeit LOZ, to be distributed among the sufferers, and, in default of payment, shall be committed to some workhouse, and there kept to hard labor for 18 months. A master is, lastly, chargeable if any of his family layeth or casteth anything out of his house into the street or common highway to the damage of any individual, or the common nuisance of his majesty's liege people, for the master hath the superintendence and charge of all his household. And this also agrees with the civil law, which holds that the pater familias in this and similar cases. O ulterius culpam tenetur, sive servi sive lihari. We may observe that in all the cases here put, the master may be frequently a loser by the trust reposed in a servant, but never can be a gainer. He may frequently be answerable for his servant's misbehavior, but never can shelter himself from punishment by laying the blame on his agent. The reason of this is still uniform and the same, that the wrong done by the servant is looked upon in law as the wrong of the master himself, and it is a standing maxim that no man shall be allowed to make any advantage of his own wrong. 3. Finally, strangers may be interested in the performance of a contract of hiring or service, in so far that a breach of that contract by the servant, either alone or in combination with others, may endanger human life, or cause serious bodily injury, or expose valuable property to destruction or injury. And hence it is that any municipal authority, company, or contractor whose duty it is to supply gas or water to the community may eye upon a similar principle, by the law bound to pay double to the sufferers, or of the 12 tables at home, a person, if he was not able to pay, was to suffer, by whose negligence any fire began, was corporal punishment. Breach of contract. 403 proceeds summarily against any person whose duty it is to supply, or who has assumed the duty of supplying such gas or water, and who willfully and maliciously breaks his contract. The punishment in any of these cases is by a fine not exceeding £20, or an imprisonment not exceeding 3 months. 339 Vict. c. 86. Passed in Knopf 1874 among the Kietokers of the Messignants of the combination in the Wintertropolis not to work. 404. Chapter Roman 15. Of husband and wife. The second private relation of persons is that of marriage, which includes the reciprocal rights and duties of husband and wife, or, as most of our elder law books call them, of Heron and Feme. In the consideration of which I shall, in the first instance, inquire how marriages may be contracted or made, shall next point out the manner in which they may be dissolved, and shall, lastly, take a view of the legal effects and consequences of marriage. Our law considers marriage in no other light than as a civil contract. The holiness of the matrimonial state is left entirely to the ecclesiastical law, the temporal courts not having jurisdiction to consider unlawful marriage as a sin, but merely as a civil inconvenience. The punishment, therefore, of incestuous or other unscriptural marriages is the province of the spiritual courts, which act pro salute anims, and, taking it in a civil light, the law treats it as it does all other contracts, allowing it to be good and valid in all cases where the parties at the time of making it were, in the first place, willing to contract, secondly, able to contract, and, lastly, actually did contract in the proper forms and solemnities required by law. First, they must be willing to contract. Consensus non concuvitus facit nuptias is the maxim of the civil law in this case, and it is adopted by the common lawyers, who indeed have borrowed, especially in ancient times, almost all their notions of the legitimacy of marriage from the canon and civil laws. Secondly, they must be all to contract. In general, all persons are able to contract themselves in marriage, unless they labor under some particular disabilities and incapacities. What these are, it will be here our business to inquire. Now these disabilities are of 2 sorts. First, such as are canonical disabilities, 405 canonical, and secondly, such as are civil. The former were sufficient by the ecclesiastical laws to avoid the marriage in the spiritual court, but in our law, until recently, only made the marriage voidable, and not ipso facto void, until sentence of nullity had been obtained. Of this nature were pre-contract, consanguinity, or relation by blood, and affinity, or relation by marriage, and of this nature also is the only remaining canonical disability, corporal infirmity. These canonical disabilities being either grounded upon the express words of the divine law, or else consequences deducible from thence, it is, by the canon law, considered sinful in the persons who labor under them to attempt to contract matrimony together, and they are therefore properly the object of the ecclesiastical magistrate's coercion, in order to inflict penance for the offense, pro salute animarum. But such marriages not being void ab initio, but voidable only by sentence of separation, they were esteemed valid by our law, to all civil purposes, unless such separation was actually made during the life of the parties. For after the death of either of them, the courts of common law would not suffer the spiritual courts to declare such marriages to have been void, because such declaration could no longer tend to the reformation of the parties. And therefore when a man had married his first wife's sister, and after her death the bishop's court was proceeding to annul the marriage and bastardize the issue, the Court of King's Bench granted a prohibition quod hoc, but permitted them to proceed to punish the husband for incest. These canonical disabilities being entirely the province of the ecclesiastical courts, our books are perfectly silent concerning them, and the last alone of those above referred to can now be made the ground of a suit. The first interference of the legislature on the subject of marriage was by the Statute 32 Hen. Roman 8, c. 38, which declares that all persons may lawfully marry but such as are prohibited by God's law, and that all marriages contracted by lawful persons in the face of the Church, and consummated with bodily knowledge and fruit of children, shall be indissoluble. And, because a great variety of degrees of kindred had been made impediments to marriage, which impediments might however have been bought off for money, it is declared by the same statute, that nothing, God's law excepted, shall impeach any marriage, but within the Levitical degrees, the farthest of which is that husband and wife, between uncle and niece. By the same statute all impediments arising from pre-contracts to other persons were abolished and declared of none effect, unless they had been consummated with bodily knowledge, in which case the canon law holds such contract to be a marriage de facto. This branch of the statute was repealed by 2 and 3 Edwa. Vi. c. 23, but the 26 Geo. Roman 2. c. 33 reenacted by 4 Geo. Roman 4. c. 76, having again prohibited all suits in the ecclesiastical courts to compel a marriage in consequence of any contract, whether J per verba de piarsis and egt per verba de future, the impediment created by pre-contract is entirely abolished. The statute of Henry Roman 8 left marriages within the Levitical degrees in precisely the same position as they were before, voidable in the spiritual courts, but not void until sentence of nullity had been obtained. And notwithstanding repeated and memorable attempts to put the law on a better footing, in this unsatisfactory position all such marriages remained until the Statute 5 and 6 will. Roman 4. c. 64 entirely altered the law with respect to them. After reciting that marriages between persons within the prohibited degrees are voidable only by sentence of the ecclesiastical court pronounced during the lifetime of both the parties, and that it is unreasonable that the state and condition of the children of marriages between persons within the prohibited degrees of affinity should remain unsettled during so long a period, and that it is fitting that all marriages which may thereafter be celebrated between persons within the prohibited degrees of consanguinity or affinity should be ipso facto void, and not merely voidable. The statute proceeds to enact, firstly, that all marriages previously celebrated between persons within the prohibited degrees of affinity shall not thereafter be annulled, for that cause, by any sentence of the ecclesiastical court, and secondly, that all marriages thereafter celebrated between persons within the prohibited degrees of consanguinity or affinity shall be absolutely null and void to all intents and purposes whatsoever. This statute was passed to put a presence of a person in holy orders stop to the disgraceful practices which these contracts, when consummated by then prevailed at the Fleet, Mayfair, copula, or valid marriages, and elsewhere, by which boys and girls. This enactment has given rise to or were forced or entrapped into contracts great deal of discussion in and out of parof marriage per verba de piarsis senti, in the liament, and to repeated efforts to obtain civil disabilities. 407 so that the only canonical disability on which marriage is otherwise regular can now be declared void is corporal infirmity, or an inability at the time of the marriage to procreate children. The civil disabilities, among which may now be numbered affinity and consanguinity, are those which are created, or at least enforced, by the municipal laws, and though some of them may be grounded on natural law, yet they are regarded by the laws of the land not so much in the light of any moral offense as on account of the civil inconveniences they draw after them. These civil disabilities make the contract void a initio, and not merely voidable, not that they dissolve a contract already formed, but they render the parties incapable of performing any contract at all. They do not put asunder those who are joined together, but they previously hinder the junction. And if any persons under these legal incapacities come together, it is a meretricious and not a matrimonial union. 1. The first of these legal disabilities is a prior marriage, or having another husband or wife living, in which case, besides the penalties consequent upon it as a felony, the second marriage is to all intents and purposes void. Polygamy being condemned both by the law of the New Testament and the policy of all prudent states, especially in these northern climates. And tfustuian, even in the climate of modern Turkey, is express ** that dies uxors eadem tempor liae non licit. 2. The next legal disability is want of age. This is sufficient to avoid all other contracts on account of the imbecility of judgment in the parties contracting. A fortiori, ihareox, it ought to avoid this, the most important contract of any. Therefore, if a boy under 14, or a girl under 12 years of age, marries, this marriage is only inchoate and imperfect, and when either of them comes to the age of consent aforesaid, they may disagree its repeal, its effect being to avoid martian ui the legislature of any of the rages between a man and his deceased foreign possessions of the crown and wife's sister. Eg. V. Chadwick, Roman 2 Q. V. That such a marriage should be valid 173. A marriage between an English there, it would still be invalid here, subject and his deceased wife's sister, 28 and 29 Vict. C. 64. Although valid by the law of the country. Barry's case, 5 Rep. 98. 2 Leon. 1 U9. Where it is celebrated, is invalid hero. Ins. 1 10 6. Rookfee. Brook, 9H. L. 193. And husband and wife. And declare the marriage void, without any divorce or the sentence of any court. This is founded on the civil law. But the canon law pays a greater regard to the constitution than the age of the parties, for if they are debiles ad matrimonium, it is a good marriage, whatever their age may be. And in our law it is so far a marriage that, if at the age of consent they agree to continue together, they need not be married again. If the husband be of years of discretion, and the wife under 12, when she comes to years of discretion he may disagree as well as she may, for in contracts the obligation must be mutual. Both must be bound, or neither. And so it is, vice versa, when the wife is of years of discretion and the husband under 3. Another incapacity arises from want of consent of parents or guardians. By the common law, if the parties themselves were of age to consent, there wanted no other concurrence to make the marriage valid, and this was agreeable to the canon law. But by several statutes, penalties were laid on every clergyman who married a couple either without publication of bans, which may give notice to parents or guardians, or without a license to obtain which the consent of parents or guardians must be sworn to. And by the statute 4 and 5 ph. and m. c. 8, whosoever married any woman child under the age of 16 years without consent of parents or guardians were subjected to fine, or 5 years' imprisonment, and her estate during the husband's life went to and was enjoyed by the next heir. The civil law indeed required the consent of the parent or tutor at all ages, unless the children were emancipated, or out of the parent's power, and if such consent from the father was wanting, the marriage was null, and the children illegitimate, but the consent of the mother or guardians, if unreasonably withheld, might be redressed and supplied by the judge, or the president of the province. And if the father was non-compos, a similar remedy was given. These provisions are partially adopted and imitated by the French, and also in Holland and Belgium, and it having been thought proper to introduce somewhat of the same policy into our laws, the Statute 26 Geo. Roman 2. c. 33 enacted that all marriages celebrated by license for bans suppose notice where either of the parties was under 21, not being a widow or leon. Constat. 109. DT Credel. 1. For lit. Took. Free. Co. Li. 79. STR. 937. consent of parents and guardians. 409 widower who are supposed emancipated without the consent of the father, or, if he be not living, of the mother or guardians, should be absolutely void. A like provision was made, as in the civil law, where the mother or guardian was non-compos, beyond sea, or unreasonably froward, to dispense with such consent at the discretion of the Lord Chancellor. But no provision was made in case the father should labor under any mental or other incapacity. Much may be, and much has been said, both for and against this innovation upon our ancient laws and constitution. On the one hand, it prevents the clandestine marriages of minors, which are often a terrible inconvenience to those private families wherein they happen. On the other hand, restraints upon marriages, especially among the lower class, are evidently detrimental to the public, by hindering the increase of the people, and to religion and morality, by encouraging licentiousness and debauchery among the single of both sexes, and thereby destroying one end of society and government, which is coiquidu prosper vego. And of this last inconvenience the common laws were so sensible, that at the same time that they forbade marriage without the consent of parents or guardians, they were less rigorous upon that very account with regard to other restraints. For if a parent did not provide a husband for his daughter by the time she arrived at the age of 25, and she afterwards made a slip in her conduct, he was not allowed to disinherit her upon that account, quia nan sua culpa, sed perit eum, id commiis. Cognoscitur. Whatever may have been or may be urged for or against the restraints upon marriage first imposed by the statute of George Roman II, it is still the policy of our law to prevent such unions when the parties are, or one of the parties is, under age, unless with the permission of the parent or guardian. The consent thus required, in the case of a person not having been previously married, for then the child is deemed to have been emancipated from parental control, is that of the father, or if he be dead, of the guardian, or if there be no guardian, of the mother, if 4 Dio. Roman 4. C. 76, 6 and 7 will Roman 4. C was abolished by the canon law. Share 85, 8, 10. V mod V. Bait I more P. C. C. 353. The patriapotity of the civil law. Husband and wife. Unmarried, or if there be no mother unmarried, then of any guardian appointed by the High Court of Justice. And if the father, guardian, or mother be non-compos mentis, or in parts beyond the seas, or unreasonably, or from undue motives withholds consent, application may be made to the High Court, which may give an effectual consent. The marriage of a minor without the requisite consent is, nevertheless, valid, for the provisions of the statute 4 Geo. Roman 4. C. 76 are in this respect only directory. But where such a marriage is solemnized by means of the louse oath or fraudulent procurement of one of the parties, the party so offending is liable to forfeit all the property which would otherwise accrue from the marriage. 4. A fourth incapacity is want of reason, without a competent share of which, as no other, so neither can the matrimonial contract be valid. It was formerly adjudged that the issue of an idiot was legitimate, and consequently that his marriage was valid. A strange determination, since consent is absolutely requisite to matrimony, and neither idiots nor lunatics are capable of consenting to anything. And therefore the civil law judged much more sensibly when it made such deprivations of reason a previous impediment, though not a cause of divorce, if they happened after marriage. And modern resolutions have adhered to the reason of the civil law, by determining that the marriage of a lunatic, not being in a lucid interval, was absolutely void. But as it might be difficult to prove the exact state of the party's mind at the actual celebration of the nuptials, upon this account, concurring with some private family degrees reasons, the statute 15 Geo. Roman 2. C. 30 has provided that the marriage of lunatics and persons under frenzies, if found lunatics under a commission or committed to the care of trustees by any act of Parliament, before they are declared of sound mind by the Lord Chancellor, or the majority of such trustees, shall be totally void. Lastly, the parties must not only be willing and able to contract, but actually must contract themselves in due form of law, to make it a good civil marriage. Any contract made per verba J.X. Swat. C. 3 Mai. NCR. 471. Morrison's case Quorum Delegat. Lane v. Goodwin 4Q. B. 361. See more C8 I C Siley the Private Act 1 EL. Aber. 357. 23 Dio. Roman 2. C. 6. Form of the contract. 411 de Piersa senti, or in words of the present tense and in case of cohabitation per verba de futuro also, between persons able to contract, was before the statute of George Roman II. So far a valid marriage, that the parties might be compelled in the spiritual courts to celebrate it in facie ecclesias. But these verbal contracts are now of no force to compel a future marriage degrees *, their only operation being to give the party who is willing to perform his promise a right of civil action against the one who refuses to do so. * Until the statute 6 fee 7 will. Roman 4. C. 35. No. Marriage * was valid that was not celebrated in some parish church or public chapel, unless by dispensation from the Archbishop of Canterbury. It must also have been preceded by publication of bans or by license from the spiritual judge. Many other formalities were likewise prescribed, the neglect of which, though penal, did not invalidate the marriage, but it was essential to a marriage that it should be performed by a person in orders *, though the intervention of a priest to solemnize this contract is merely juris posuavi, and not juris naturalis aut divini. It being said that Po II Innocent Roman III was the first who ordained the celebration of marriage in the Church, before which it was totally a civil contract. The statute above referred to was passed for the relief of those who scrupled at joining in the services of the national Church, and was the result of a long and arduous struggle carried on for many years in and out of Parliament, the bitterness of which, the question being polemical, has not yet wholly subsided. It provides for places of religious worship being registered for the solemnization of marriage *, and it also permits of this contract being entered into without any religious sanction whatever. It is, therefore, no longer essential to the validity of a marriage, either that it should be solemnized in a church, or 26 Geo. Roman 2. C. 33. 4 Geo. Roman 4. C. 76. Solemnization, BJ Statute 12 Car. Roman 2. C. 33. He Wild v. Harris 7 C. B. 999. To the registration of Protestant. Reg. V. My Uis 1001. And Fen. 534. Places of worship. C1W. And M. Ses. Heppenwad v. Haddon 13M. And W. 261. 1 C. 18 and 52 Geo. Roman 3. C. 155. Of Roman. More. 170. Catholic chapels 31 Geo. Roman 3. C. 32 and in the times of the Grand Rebellion 2 and 3 will. Roman 4. C. 115. And of Jewish all marriages were performed by the synagogues 9 and 10 Vict. 59. As to justices of the peace, and these marriages registration by the Registrar General were declared valid without any fresh 15 and 16 Vict. C. 36 and 18 and 19 Vict. C. Husband and wife. By a person in holy orders, but it must in all cases be accompanied by certain circumstances of publicity, or be entered into in virtue of a license, obtainable only on a declaration, equivalent to an oath, being made that there is no legal impediment. With reference to marriages celebrated in facie ecclesiae, the Statute 4 Geo. Roman 4. C. 76, commonly called the Marriage Act, directs the observance of the rules contained in the office for the solemnization of matrimony in the Book of Common Prayer Trade, and that bans shall be published in conformity with the canons, or a license be obtained from the proper ecclesiastical authority to marry without them. This license cannot be granted unless one of the parties make oath that he or she has had his or her usual place of abode in the parish for which it is sought for 15 days immediately preceding. And all ministers are forbidden to solemnize marriage more than 3 months after complete publication of the bans or grant of the license. The marriage must also take place between 8 and 12 in the forenoon in a church or chapel wherein bans may be lawfully published. The publication of bans is made void by the open declaration of dissent by the parent or guardian of a minor, and no license can be granted if one of the parties be under age, unless oath be made either that the necessary consent has been obtained, or that there is no one having authority to give consent. These requirements of publicity in all cases, and consent in the case of minors, are enforced by those penal provisions of the statute which avoid the marriage altogether if the parties knowingly and willfully intermarry in any other place than a church or chapel wherein bans may be lawfully published, except by special license, or knowingly and willfully intermarry without due publication of bans or license from the proper authority, or knowingly and willfully acquiesce in the solemnization of marriage by a person not in holy orders. It is also an offense, amounting to felony, to solemnize marriage except between the stated hours of 8 and 12, unless by special license, or to Herod v. Herod, 1 K&J. 4. District and other churches and the common license is obtained at chapels may be licensed for this purpose. The office of the Diocesan Court on Pay see also 7 will, Roman 4, and 1 Vict. C. 22, SS. Ment of the fees. 1 from the Arch 33, 34, and 7 and 8 Vict. C. 56, S. 1. Bishop is called a special license. It per error without fraud does not invalidate the marriage to be performed at any date the marriage. 14 and 15 Vict. C. 97 S. 25. Place or time. Mealy v. Bede Tukert. 833. Celebration of marriage. 413 Solemnize it without due publication of bans, unless by license, or to solemnize it according to the ceremonies of the Church, under a false pretense of being in holy orders. The other modes of entering into the contract are those provided by the Statute 6 and 7 will, Roman 4. C. 85 under the Marriage Act, giving legal effect to the requirements of the law ecclesiastical. A marriage may be solemnized either by virtue of a license, or after due publication of hands. 2 other modes have now been provided, viz. By license or by certificate from the Superintendent Registrar of Births, Deaths, and Marriages *, the former resembling the license obtained from the ordinary, the latter the certificate which is given after the publication of bans in the parish church. To obtain a license, notice must be given stating that the marriage is intended to be by license to the superintendent, as amended by 1 Vict. C. 22, 3 and 4 Vict. C. 72, and 19 and 20 Vict. C. 119. Tli Office of Superintendent Registrar was created by the Statute 6 and 7 will. R.V. C. 86, which was passed for the purpose of forming a complete register of births, deaths, and marriages in England. For this purpose the poor law unions were divided into districts, for which registrars were appointed. These registrars, with the superintendent registrar in each union, generally the clerk to the board of guardians, having the care of all the registers therein. For the complete registration of births and deaths, the father and mother of every child, or the occupier of every house in which any birth or death happens, is required, under a penalty, to furnish information of the fact to the registrar, within 42 days in the case of births, and within 5 days in the case of deaths, who enters particulars of such births or deaths in books furnished to him for that purpose by the Registrar General. 15 and 16 Vict. C. 25. In the case of deaths, some person present or in attendance during the illness of the deceased, or the occupier or an inmate of the house, furnishes the particulars required by the registrar. No body sin be buried, nor any funeral or religious service be performed, without the execution of the registrar's certificate. Certified copies of the entries of births and deaths are sent quarterly by the registrar to the superintendent registrar and by him to the registrar general, the register book itself, when filled, being transmitted to, and kept by, the superintendent registrar. In like manner, copies of the entries of marriages from their respective register books are transmitted by the clergy of the national church, and by the proper officers of Quakers, meeting houses and Jewish synagogues, and by the registrars who register marriages in other places of religious worship to the Registrar General, one of the duplicate register books of marriages remaining in the church or other building. The superintendent registrar's license or certificate has the same legal effect, and may be substituted for the license of the ordinary or the publication of banns, 7 will. Roman 4, and 1 Vic. C. 22 S. 36. But a minister of the national church is not obliged to act upon it and marry the parties. See now 19 and 20 Vict. C. 119 S. Husband and wife. Registrar of the district within which one of the parties has resided for not less than 15 days. To obtain a certificate, notice must be given to the superintendent registrars of the districts in which both parties have resided for not less than 7 days. This notice must in each case be accompanied by a solemn declaration, which, if false, involves the penalties of perjury, that there is no lawful impediment to the marriage, and when either of the parties is under age, either that the required consent has been given, or that there is no person who has authority to give it. The notice is next entered in a book, open without fee, to persons desirous of inspecting it, and in the case of a marriage by certificate, a copy is suspended in the office of the superintendent registrar, so as to give it publicity. A license may then be obtained the day after the notice. A certificate can only be obtained after the lapse of the 21 days during which the notice of marriage is suspended in the office, because in the meantime, and before it is issued, any person may forbid the marriage, upon which the notice becomes utterly void. But under either license or certificate, when obtained, the marriage may be performed according to any form the parties choose to adopt, in a building registered for the purpose or at the office of the superintendent registrar, in the presence of that official. The ceremony must in every case take place in the presence of some registrar of the district, a distinct officer from the superintendent registrar, and 2 or more credible witnesses. It must be performed with open doors, and between the hours of 8 and 12 in the forenoon, and the parties must in some part of the ceremony declare that they know of no lawful impediment to their marriage, and call upon the persons present to witness that they take each other for husband and wife. Quakers and Jews were expressly excepted from the operation of the Marriage Act, and may have their unions celebrated according to their own usages. Marriages entered into under this statute must be celebrated within 3 months after the notice to the superintendent registrar, * 19 and 20 Vict. C. 119. Object of this is to satisfy any subsequent. The statute 19 and 20 Vict. C. 119. Religious scruples raised by or suggested allows persons contracting a complete to the parties. Marriage before the registrar to have. As to Jewish marriages and divorces, the ceremonies of their church or persuasi must fee. Smith 1M. Nt. 232. 10 and IN added in a church or chapel. The 1 Vict. C. 58. Dissolution of marriages. 416. Compliance with its other provisions is obtained by making a disregard of its enactments more or less penal. Finally, all marriages must be registered in one or other of the modes prescribed by the Statute 6 and 7 will. Roman 4. C. 86. The whole machinery for this purpose, as for the registration of births and deaths, being under the control of the Registrar General, whose duty it is to prepare and publish those statistical details relating to marriages and the mortality and increase of the population, which have been found so useful in directing our recent sanatory legislation. It may be added here that marriages contracted in Scotland or Ireland, or elsewhere abroad, are valid here if valid by the law of the country where they took place. That marriage is solemnized by a person in holy orders in the house of a British ambassador or resident minister, or in the chapel of a British factory, or within the lines of a British army abroad, are equally valid as if solemnized at home *, and that by the Statute 12 and 13 Vict. C. 68. Marriages celebrated by British consuls in foreign countries are equally valid as if solemnized in England, provided the forms required by that statute are duly observed. We may upon the whole collect IRS/ that no marriage * between single persons not within the prohibited degrees of consanguinity or affinity and of sound mind, although one or both be under age, is by the temporal law ipso facto void. Secondly, that no marriage is voidable after the death of either of the parties, nor during their lives, unless for the canonical impediment of corporal imbecility, subsisting previous to the marriage. Asterisk T.J. Erdley, that marriages within the prohibited degrees of consanguinity or affinity are absolutely null and void. N. I am next to consider the manner in which marriages may be dissolved, and this is either by death or divorce. There are two kinds of divorce, the one for the canonical impediment before mentioned, existing before the marriage, not supervenient, or Juzirem Bai's case, by Dottlebon, London, Forsyth, and Finn, 649. 1811, Dodie, Birtwistle v. Vardy 5. The whole law on this subject will be N.C. 438 6 N.C. 385. Dalhousie found in the report laid before Par v. M. All 7 Sci. And Finn, 817. Kent v. Leament in 1893 of the Commissioners Burgess 11 Sim. 361. Appointed to inquire into the law of asterisk 4 Geo. Roman 4. C. 91. Wa Jada Grave Peerage, Divorce. 416 Husband and wife. Arising afterwards. The other for adultery, committed after the marriage. In divorces on the ground of corporal infirmity, the marriage is declared null, as having been absolutely unlawful a initio, and the issue of such marriage as is thus entirely dissolved are bastards. In cases of divorce for a cause arising after marriage, no such result takes place, for in that case the marriage was just and lawful a initio. The canon law deems so highly and with such mysterious reverence of the nuptial tie, that it will not allow it to be unloosed for any cause whatsoever that arises after the union is made, and this is said to be built on the divine revealed law, though that expressly assigns incontinence as a cause, and indeed the only cause why a man may put away his wife and marry another. The civil law, which is partly of pagan origin, allows many causes of absolute divorce, and some of them pretty severe ones, as if a wife goes to the theatre or the public games, without the knowledge and consent of the husband, but among them adultery is the principal, and with reason named the first, with us in England. Nevertheless, adultery was long only a cause of separation from bed, and bore for which the best reason that could be given was that if divorces were allowed to depend upon a matter within the power of either of the parties, they would probably be extremely frequent, as was the case when divorces were allowed for canonical disabilities, on the mere confession of the parties, which was prohibited by the canons of 1603. Asterisk the inadequacy, as it was deemed, of the redress thus afforded by the spiritual arts, and their inability to grant a divorce of inculo matrimonii, except for corporal imbecility, gave rise to the practice of dissolving marriages by special acts of Parliament, or privilegia, the consideration of which was for a long time a branch of the judicial functions of the House of Peers, and the exercise of which was guarded by stringent rules, for a divorce was only granted to a husband after he had obtained a separation amendst et thoro in the ecclesiastical court, and provided his conduct had been free from reproach, and he had recovered damages against the adulterer in an action. A divorce was not accorded to a wife except in cases of aggravated enormity, such Ma. Roman 19. 9. More. 683. Foljam's case in the Star Chamber Lk. Divorce. 417 as incestuous intercourse with her relations which precluded the possibility of future reconciliation. The remedy thus given for the greatest injury which a husband can sustain was from its nature only within the reach of the wealthier classes. Its cost became, therefore, a subject of natural and just complaint by those to whom redress was in this way denied. While, on the other hand, the various steps to be taken to obtain it, by those who had the means of doing so, involved an examination by 3 different tribunals into the same facts, for practically the same object, and consequently the repeated publication of details, often of a gross, always of an indelicate nature, and necessarily offensive to public decency and morality. A demand for inquiry resulted in the appointment of a royal commission, the greater part of whose recommendations were adopted by the legislature, and the law of marriage in this respect entirely altered, for the previous dilatory and expensive proceedings of 3 tribunals, was substituted one inquiry by a court specially constituted to exercise this jurisdiction, and on this court was conferred all the authority of the ecclesiastical courts in causes matrimonial, and also power to grant a divorce of inquilo, as a right, not as a privilegium, to a husband, on the adultery simply of the wife, and to a wife when this offense against the married state had been accompanied by bigamy, rape, an unnatural offense, cruelty, or desertion. In cases of divorce, or of a judicial separation which may be accorded when, for some supervenient cause, it becomes improper or impossible for the parties to live together, as in case of intolerable ill temper, cruelty, or adultery in either of the parties, the law allows alimony to the wife, which is that allowance which is made to a woman for her support out of the husband's estate, being settled at the discretion of the court, on consideration of all the circumstances of the case. It is generally proportioned to the rank and quality of the parties, but in cases *20 and 21 vict. C. 85, 21 and 22 vict. C. Probate Divorce and Admiralty Division 108, 22 and 23 vict. C. 61, 23 and 24 vict. Thereof C. 144, 20 and 21 vict. C. 85 S. 16. The jurisdiction of the court for Evam v. Evam 1 Hag. 30. Divorce and matrimonial causes has since degrees Saunders v. Snundern 1 Rob. E. Been transferred to the Higley Court of Rep. 549. Raider Con v. P. N. Lersnu 3 IT. L. Just DIC, and is now exercised by TLU.Ca.308. Vol. 1. 2e. Husband and wife. Of elopement and living with an adulterer, the law allows her no alimony. Roman 3. Having thus shown how marriages may be made or dissolved, I come now, lastly, to speak of the legal consequences of such making or dissolution. By marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband, under whose wing, protection, and cover she performs everything, and is therefore called in our law French of femme covert, femina viro cooperata, is said to be covert laren, or under the protection and influence of her husband, or heron, or lord, and her condition during her marriage is called her coverture. Upon this principle of a union of person and husband and wife depend almost all the legal rights, duties, and disabilities that either of them acquire by the marriage. I speak not at present of the rights of property, for these will form the subjects of explanation in the next volume of these commentaries. I speak only of such rights, duties, and liabilities as are merely personal. Therefore, a man cannot generally grant anything to his wife, or enter into a covenant with her, for the grant would be to suppose her separate existence, and to covenant with her would be only to covenant with himself, and therefore it is also generally true that all compacts made between husband and wife, when single, are voided by the intermarriage. A woman indeed may be agent for her husband, for that implies no separation from, but is rather a representation of her lord. And a husband may also bequeath anything to his wife by will, for that cannot take effect till the coverture is determined by his death. The husband is bound to provide his wife with necessaries by law, as much as himself, and if she contracts debts for them, he is obliged to pay them ***, unless he supplies her with necessaries himself. But for anything besides necessaries he is not chargeable, unless the wife had authority express or implied to contract for him. Registered P. Montagu v. Benedict 2 Smith Cell. C. Renox v. Tilda 8. X. G80. Cell. 118. Monteux. Scott 2 Smith Cell. C. Hyde. Seaton v. Benedict 5 Bing. 28. V. Tewi 13-0. B. 627. Their unity of person, 409. Also, if a wife elopes / or lives with another man, the husband is not chargeable, even for necessaries. * And if the person who furnishes the wife with goods is sufficiently apprised * that she has no authority to pledge her husband's credit, he is not responsible. If the wife be indebted before marriage, the husband is bound aftenwards to pay the debt, provided he has received avith her sufficient gisets wherewith to do so, for he has adopted her and her circumstances together. And so she, if she have separate property, must support her husband if he become chargeable to the parish. If the wife be injured in her person or her property, she can bring no action for redress without her husband's concurrence and in his name as well as her own, neither can she be sued, without making the husband a defendant. There are however cases where the wife may sue and be sued as a feme soi. Thus, 1. Where the husband has abjured the realm, or is banished for then he is dead in law, and, the husband being thus disabled to sue for or defend the wife, it would be most unreasonable if she had no remedy, or could make no defense at all. 2. Where the wife has obtained a judicial separation from the husband, and 3. Where she sues in respect of wages, earnings, money, or property, which is her separate property, either by contract before marriage or under the statute 33 and 34 vict. C. 93. In criminal prosecutions the wife may be indicted and punished separately. For the union is only a civil union. But although a husband and wife may now be witnesses for and against each other in civil actions they are not allowed to give evidence for or against each other in criminal cases. Partly because it is impossible their testimony should be indifferent, but principally. Cleald v. Illerdeman 2 Straw. 875. Co. Lid. 1.33. This rule does not. Straw. 647, 706. Apply when he is an alien enemy. De. Etherington v. PNR Sauk. 118. Wall v. Braun 1H. And N. 178. By Teli married Weymouth's property 20 and 21 vict. C. 85 SS. 25-26. Act 1 870, 33 and 34 vict. C. 93. Teli whose this act has rendered unnecessary band was declared no longer liable for the enactments which enabled a wife, his wife's debts contracted LF or mar deserted by her husband, to obtain an riage. This remained the law and, as order of justices for the protection, from to husbands who married between 9th her husband and his creditors of the August 1870 and 30th July 1874, is the fruits of her own industry. Law still, till altered by 37 and 38 vict. 1 Hawk. P. C. Free. C. 50. Including divorce to be reason of RTS/85 and 36 vict. C. 93. Turi 32 and 33 vict. Husband and wife. Because of the union of person, and therefore, if they were admitted to be witnesses for each other, they would contradict one maxim of law. Nemo JCR oprid causa testis estebit. And if against each other, they would contradict another maxim. Nemo tenetur sepsum equiser. Where, however, the offense is directly against the person of the wife, this rule does not apply. And therefore, in case a woman be forcibly taken away and married, she may be a witness against such her husband in order to convict him of felony, for in this case she can with no propriety be reckoned his wife, because a main ingredient, her consent, was wanting to the contract, and also there is another maxim of law, that no man shall take advantage of his own wrong, which the ravisher here would do, if by forcibly marrying a woman he could prevent her from being a witness who is perhaps the only witness to that very fact. Although again our law in general considers man and wife as one person, yet there are some instances in which she is separately considered, as inferior to him, and acting by his compulsion. And therefore all deeds executed, and acts done by her during her coverture, are void except it be a deed properly acknowledged, in which case she must be solely and secretly examined, to learn if her act be voluntary. She cannot by will devise lands to her husband, unless under special circumstances, for at the time of making it she is supposed to be under his coercion. And in some felonies and other inferior crimes committed by her through constraint of her husband, the law excuses her, but this extends not to treason or murder. The husband also, by the old law, might give his wife moderate correction. For, as he is to answer for her misbehavior, the law thought it reasonable to entrust him with this power of restraining her, by domestic chastisement, in the same moderation that a man is allowed to correct his apprentices or children, for whom the master or parent is also liable in some cases to answer. But this power of correction was confined within reasonable bounds *, and the husband was prohibited from using any violence to his wife. Aliter quam adverum, ex causa regiminis et castigationis. Marshall v. Uter, 80, R. 545, 20 and 21 Vict. C. 57. 3 and 4 will. Roman 4. C. 74. C. Allow beta. *mtxn. Authority of the husband. (421) Uxorus Susa, lit et rationa hiliter pertinet. The civil law gave the husband the same, or a larger authority over his wife, allowing him for some misdemeanors, jail agelis et fustibus acretivere ucusorum, for others, only modicam castigationem ad burda. But with us, in the politer reign of Charles Roman II, this power of correction began to be doubted: and a wife may now have security of the peace against her husband *, or, in return, a husband against his wife. Yet the lower rank of people, who are always fond of the old common law, still claim and exert their ancient privilege. And the courts of law will still permit a husband to restrain a wife of her liberty, in case of any gross misbehavior. These are the chief legal effects of marriage during the coverture, upon which we may observe that even the disabilities which the wife lies under are for the most part intended for her protection and benefit. So great a favorite is the female sex of the laws of England. *Nov. 117 c. 14. Van Leeuwen in. 2 Lev. 128. Low. J. Straw. 1207. 1 Sid. 113. 3 Keb. 433. Coam Jui $OE 6 Dowell. P. C. 630. 422. Chapter Roman 16. Of parent and child. The next and the most universal relation in nature is immediately derived from the preceding, being that between parent and child. Children are of two sorts, legitimate and spurious, or bastards, each of which we shall consider in their order, and, erst, of legitimate children. I. A legitimate child is he that is born in lawful wedlock, or within a competent time afterwards. Pater est cor nuptiis. Demonstrant is the rule of the civil law, and this holds with the civilians, whether the nuptials happen before or after the birth of the child. With us in England the rule is narrowed, for the nuptials must be precedent to the birth ***, of which more will be said when we come to consider the case of bastardy. At present let us inquire into 1. The legal duties of parents to their legitimate children. 2. Their power over them. 3. The duties of such children to their parents. 1. And, first, the duties of parents to legitimate children, which principally consist in 3 particulars: their maintenance, their protection, and their education. The duty of parents to provide for the maintenance of their children is a principle of natural law, an obligation laid on them not only by nature herself, but by their own proper act in bringing them into the world. For they would be in the highest. And 80 strict is this rule, that where country in which he was born, he is still a person, born a bastard, becomes, by a bastard, so far as regards the inherit subsequent marriage of his parents, os of lands in England. Do d. Bird legitimate according to the laws of the Ivisal v. Vardil 6 Big. N. 0. Maintenance of children. 423 manner injurious to their issue, if they only gave their children life, that they might afterwards see them perish. By begetting them, therefore, they have entered into a voluntary obligation to endeavor, as far as in them lies, that the life which they have bestowed shall be supported and preserved. And thus the children will have a perfect right of receiving maintenance from their parents. And the President Montesquieu has a very just observation upon this head. that the establishment of marriage in all civilized states is built on this natural obligation of the father to provide for his children. For that ascertains and makes known the person who is bound to fulfill this obligation. Whereas, in promiscuous and illicit conjunctions, the father is unknown, and the mother finds 1,000 obstacles in her way: shame, remorse, the constraint of her sex, and the rigor of laws that stifle her inclinations to perform this duty, and besides, she generally wants ability. The municipal laws of all well-regulated states have taken care to enforce this duty, though Providence has done it more effectually than any laws, by implanting in the breast of every parent that natural araphy, or inseparable degree of affection, which not even the deformity of person or mind, not even the wickedness, ingratitude, and rebellion of children can totally suppress or extinguish. The civil law obliges the parent to provide maintenance for his child, and, if he refuses, **jtt dextet edvi cognacet. Nay, it carries this matter so far that it will not suffer a parent at his death totally to disinherit his child without expressly giving his reason for so doing, and there are 14 such reasons reckoned up ** which may justify such disinheritance. If the parent alleged no reason, or a bad, or a false one, the child might set will aside, tanquam testamentum ifficium, a testament contrary to the natural duty of the parent. And it is remarkable under what color the children were to move for relief in such a case, by suggesting that the parent had lost the use of his reason when he made the Fius testament. And this, as Puffendorf observes *, was not to bring into dispute the testator's power of disinheriting his own offspring, but to examine SB L B 23 C 2 *nov 11 FF 2.S 35 L 4 L parent and child, the motive upon which he did it, and, if they were found defective in reason, then to set them aside. But perhaps this is going rather too far. Every man has, or ought to have, by the laws of society, a power over his own property, and, as Grotius very well distinguishes, natural right obliges to give a necessary maintenance to children, but what is more than that they have no other right to than as it is given them by the favor of their parents, or the positive constitutions of the municipal law. Let us next see what provision our own laws have made for this natural duty. It is a principle of law, that there is an obligation on every man to provide for those descended from his loins, and the manner in which this obligation shall be performed is pointed out by the statutes 43 Lis. C. 2 and 5 Geo. IC. 8. The father and mother, grandfather and grandmother of poor impotent persons shall maintain them at their own charges, if of sufficient ability, according as the quarter session shall direct : and if a parent runs away, and leaves his children, the churchwardens and overseers of the parish may obtain an order of justices to seize his rents, goods, and chattels, and dispose of them toward their relief. And he may also be committed to prison and hard labor, by the interpretations which the courts of law have made upon these statutes, if a mother or grandmother married again, and was before such second marriage of sufficient ability to keep the child, the husband was charged to maintain it on the ground that, being a debt of hers when single, it should like others extend to charge the husband. But it was afterwards determined that the obligation imposed by the statutes applied only to relations by blood, and consequently that the husband was not responsible for the maintenance of the children of his wife. Now, however, by the statute 4 and 5 will. Roman 4. C. 76 A husband is liable to maintain his wife's children born before marriage, whether legitimate or illegitimate, until they reach the age of 16, or until the death of the mother. De J. B at P. 1. 2C. 7 N. Free. Appeal to the quarter sessions. 59 Geo. S. In the case of children detained in a Roman 3. C. 12 S. 26. Reformatory or industrial school. The Stubb v. Dixon 5 East. 166. Parent or step-parent or other person. Re 5 Geo. Roman 4. C. 83. Sponsible may be made to contribute. Styles 283. To bolster. 346. 29 and 30 Vict. Co. 117 and 118. Tubb v. Harrison 4T. K. 118. Cooper. This order may be made by 2 v. Martin 4 East. 76. Justices in petty sessions, there being an protection of children. 425 4. At her death, the relation being dissolved, the husband is under no further obligation. No person is bound to provide a maintenance for his issue, unless where the children are impotent and unable to work, either through infancy, disease, or accident, and then is only obliged to find them with necessaries, the penalty on refusal being no more than 208 a month. Trade for the policy of our laws, which are ever watchful to promote industry, did not mean to compel a father to maintain his idle and lazy children in ease and indolence, but thought it unjust to oblige the parent against his will to provide them with superfluities and other indulgences of fortune, imagining they might trust to the impulse of nature, if the children were deserving of such favors. 8. La in BV La Vie has made no provision to prevent the disinheriting of children a will, leaving every man's property in his own disposal, upon a principle of liberty in this, as well as every other action, though perhaps it had not been amiss if the parent had been bound to leave them at the least a necessary subsistence. Indeed, among persons of any rank or fortune, a competence is generally provided for younger children, and the bulk of the estate settled upon the eldest by the marriage articles. Heirs also, and children, are favorites of our courts of justice, and cannot be disinherited by any dubious or ambiguous words, there being required the utmost certainty of the testator's intentions to take away the right of an heir. From the duty of maintenance we may easily pass to that of Winston v. Nedoman 6a, and L. Riches, whose only D. Nutker having M. 301, Seaborn v. Mighty 7c, and P. 497. Bierencon Christianity he turned her out of. As nothing is so apt to stifle the doors, and on her application for relief, calls of nature as religious bigotry, it at law held she was entitled to none, was enacted by the Stat. 11 and 12 will. Lord Rame. 699. But this gave occasion Roman 3. c. 4, that if any popish parent should calm, Dur. 18 Feb. 12 Mar. 1701, to refuse to allow his Protestant child another statute, 1 Ann. Sin. 1 c. 30, which fitting maintenance with a view to calm ordained that if Jewish parents refused pell him to change his religion, the Lord to allow their Protestant children a chancellor should, by order of court, fitting maintenance suitable to the fore constrain him to do what was just and tune of the parent, the Lord Chancellor reasonable. But Thea did not extend to on complaint should make such order persons of another religion, of no less therein as he should see proper. Both bitterness and bigotry than the popish statutes were repealed by 9 and 10 Vict, and, therefore, in the very next year we see, 59. Find an instance of a Jew of infuse one love. Parent and child. Protection, which is also a natural duty, but rather permitted than enjoined by any municipal laws, nature, in this respect, working so strongly as to need rather a check than a spur. A parent may by our laws maintain and uphold his children in their lawsuits without being guilty of the legal crime of maintaining quarrels. And he may also justify an assault and battery in defense of their persons. The last duty of parents to their children is that of giving them an education suitable to their station in life, a duty pointed out by reason, and of far the greatest importance of any. For, as Puffendorf very well observes, it is not easy to imagine or allow that a parent has conferred any considerable benefit upon his child by bringing him into the world, if he afterwards entirely neglects his culture and education, and suffers him to grow up like a mere beast to lead a life useless to others, and shameful to himself. Yet the municipal laws of most countries seem to be defective in this point, by not constraining the parent to bestow a proper education upon his children. Perhaps they thought it punishment enough to leave the parent, who neglects the instruction of his family, to labor under those griefs and inconveniences which his family, so uninstructed, will be sure to bring upon him. Our laws, though their defects in this particular cannot be denied, made provision in one instance, by the statutes, which have been already referred to, for the education of for the apprenticing poor children. And for many years large annual grants have been made by Parliament for a similar purpose, the money thus placed at the disposal of the government being distributed by the Committee of Privy Council for Education. Finally, the legislature has put education within the reach of all by the Statute 33 and 34 Vict c. 75, under which parents may now be compelled to cause their children, between the ages of 5 and 13 to attend the schools provided by the school boards constituted under that Act, unless they are already being properly educated at some other efficient school. The rich are left at their own option, whether they will breed up their children to be ornaments or disgraces to their family. **PL of N. B. 6c. 2 Section 12. 3 Jack. IC. 5. It was provided that if, in one case, that of religion, they any person scut any child under Liesgau or formerly under peculiar restrictment beyond the seas, either to produce, for, by stat. 1 ye. I. C. 4. And vend its good education in England or in. Power of parents. 427-2. The power of parents over their children is derived from the former consideration, their duty. This authority being given them, partly to enable the parent more effectually to perform his duty, and partly as a recompense for his care and trouble in the faithful discharge of it. And upon this score the municipal laws of some nations have given a much larger authority to the parents than others. The ancient Roman laws gave the father a power of life and death over his children, upon this principle, that he who gave had also the power of taking away. But the rigor of these laws was softened by subsequent constitutions, so that we find a father banished by the Emperor Hadrian for killing his Sioux, though he had committed a very heinous crime, upon this maxim, that patria potestas in pietate debet non in atrocitate consister. But still they maintained to the last a very large and absolute authority. For a son could not acquire any property of his own during the life of his father, but all his acquisitions belongs to the father, or at least the profits of them for his life. The power of a parent by our English laws is much more moderate, but still sufficient to keep the child in order and obedience. He may lawfully correct his child, being under age, in a reasonable manner. For this is for the benefit of his education. The consent or concurrence of the parent to the marriage of his child under age was also directed by our ancient law to be obtained. And it is still required, although the want of such consent does not of itself render the marriage invalid. And this also is another means, which the law has put into the order to enter into or reside in any popish family, in order to be instructed, percoleuc, or to be instructed, persuaded, swayed, or confirmed in the papacy or strengthened in the popish religion, or contributed anything towards in such case, besides the disabilities ether and maintenance when abroad by any curd by the child so sent, the parent pretext whatever, the person both senduig or person sending forfeited which and sent or disabled to sue in law or went to the sole use and benefit of him equity, or to be executor or administrator that discovered the afflanco, 11 and 12 to any person, or to enjoy any legacy or will. Roman 3. C. 4. And by stat. 3 car. I. Deed of gift or to bear any office in the sea. 2. If any parent or other sent or con realm, and forfeited all his goods and vade any person beyond sea to enter chattels, and likewise all his real estate into, or be resident in, or trained up in for life. These disabilities no longer any priory, abbey, nunnery, popish exist. 31 Geo. Roman 3. C. 32. 10 Geo. Roman 4. Versity, college or school or house of C. 7. 2 and 3 will. Roman 4. C. 115. Jesuits or priests or any private popib. 1 ha. P. C. Parent and child. Parent's hands in order the better to discharge his duty. First, of protecting his children from the snares of artful and designing persons. And next, of settling them properly in life, by preventing the ill consequences of too early and precipitate marriages. A father has no other power over his son's estate than as his trustee or guardian, for though he may receive the profits during the child's minority, yet he must account for them when he comes of age. He may indeed have the benefit of his children's labor while they live with him, and are maintained by him, but this is no more than he is entitled to from his apprentices or servants. The legal power of a father over the persons of his children ceases at the age of 21, for they are then enfranchised by arriving at years of discretion, or that point which the law has established, as some must necessarily be established, when the empire of the father, or other guardian, gives place to the empire of reason. Yet till that age arrives, this empire of the father continues even after his death, for he may by his will appoint a guardian to his children. He may also delegate part of his parental authority during his life to the tutor or schoolmaster of his child, who is then loco parentis and has such a portion of the power of the parent committed to his charge, viz. That of restraint and correction, as may be necessary to answer the purposes for which she is employed. During the father's life, the mother, as such, is entitled to no power, but only to reverence and respect, and until the statute 2 and 3 vict. c. 54 might have been excluded by the father from all access to her children. But under the provisions of the Act, 36 vict. c. 12, an order may now be made by the High Court giving a mother access to such of her children as are under the age of 16, and directing, if it be thought fit, that they remain in her custody until they attain that age. By the father's death the mother becomes entitled to the custody of her children until they are of age, and where no, generally called Telford's Act, on had been established, was entitled to dare which the mother could have access apply under the statute 2 and 3 vict. c. 54, 2 and the custody of the children until which has been repealed. In such a case they were 7 years of age. The court will now have discretion to Rex v. Greenhill 4a, N.D. 328, make or refuse an order. No mother against whom adultery. Duties of children, 429 other guardian has been appointed stands, if unmarried, in the one/father's place, as to the consent required to the marriage of the child during its minority. But she cannot appoint a guardian by will, not being within the Statute 12 Car, Roman 2. c. 24. Free. The duties of children to their parents arise from a principle of natural justice and retribution. For to those who gave us existence, we naturally owe subjection and obedience during our minority, and honor and reverence ever after. They, who protected the weakness of our infancy, are entitled to our protection in the infirmity of their age. They who by sustenance and education have enabled their offspring to prosper, ought in return to be supported by that offspring in case they stand in need of assistance. Upon this principle proceed all the duties of children to their parents which are enjoined by positive laws and the Athenian laws * carried this principle into practice with a scrupulous kind of nicety, obliging all children to provide for their father, lean fallen into poverty, with an exception to spurious children, to those whose chastity had been prostituted by consent of the father, and to those whom he had not put in any way of gaining a livelihood. The legislature, says Baron Montesquieu, considered that in the first case the father, being uncertain, had rendered the natural obligation precarious, that in the second case he had sullied the life he had given, and done his children the greatest of injuries in depriving them of their reputation, and that in the third case he had rendered their life, so far as in him lay, an insupportable burthen, by furnishing them with no means of subsistence. Our laws agree with those of Athens with regard to the first only of these particulars, the case of spurious issue. In the other cases the law does not hold the tie of nature to be dissolved by any misbehavior of the parent, and therefore a child is equally justifiable in defending the person, or maintaining the cause or suit of a bad parent as a good one, and is equally compellable, if of sufficient ability, to maintain and provide for a wicked and unnatural progenitor, as for one who has shown the greatest tenderness and parental piety. Under the statutes relating to the Potter's Antic, v. 4c. 15. Relief of the poor, children are bound to SB, LB, 26c. 5. Support T liter pierant. Roman 2. We are next to consider the case of illegitimate children, or bastards, with regard to whom let us inquire, 1. Who are bastards? 2. The legal duties of the parents towards a bastard child. 3. The rights and incapacities attending such bastard children. 1. Who are bastards? A bastard, by our English laws, is one that is not only begotten, but born, out of lawful matrimony. The civil and canon laws do not allow a child to remain a bastard, if the parents afterwards intermarry. And herein they differ most materially from our law, which, though not so strict as to require that the child shall be begotten, yet makes it an indispensable condition, to make it legitimate, that it shall be born after lawful wedlock. And the reason of our English law is surely much superior to that of the Yeoman, if we consider the principal end and design of establishing the contract of marriage taken in a civil light, abstractedly from any religious view, which has nothing to do with the legitimacy or illegitimacy of the children. The main end and design of marriage, therefore, being to ascertain and fix upon some certain person to whom the care, the protection, the maintenance, and the education of the children should belong. This end is undoubtedly better answered by legitimating all issue born after wedlock, than by legitimating all issue of the same parties, even born before wedlock, so as wedlock afterwards ensues. 1. Because of the very great uncertainty there will generally be in the proof that the issue is generally begotten by the same man, whereas by confining the proof to the birth, and not to the begetting, our law has rendered it perfectly certain what child is legitimate, and who is to take care of the child. 2. Because by the common law a child may be continued a bastard, or made legitimate, at the option of the father and mother by a marriage ex post facto, thereby opening a door to many frauds and partialities which by our law are prevented. 3. Because by those laws a man may remain a bastard till 40 years of age, and then become legitimate by the subsequent marriage of his parents, whereby the main end of marriage, the protection of infants, is totally frustrated. 4. Because this rule of the Roman law admits of no limitations as to the time or number of bastards so to be legitimated, but see a curious case of legitimatio persusiciens e matrimonium in care v. Marian. 1 Macqueen's Appeal Oases, 650. Are bastards? 431. A dozen of them may, 20 years after their birth, by the subsequent marriage of their parents, be admitted to all the privileges of legitimate children. This is plainly a great discouragement to the matrimonial state, to which one main inducement is usually not only the desire of having children, but also the desire of procreating lawful heirs. Whereas our constitutions guard against this indecency, and at the same time give sufficient allowance to the frailties of human nature. For, if a child be begotten while the parents are single, and they will endeavor to make an early reparation for the offense, by marrying within a few months after, our law is so indulgent as not to bastardize the child, if it be born, though not begotten in lawful wedlock, for this is an incident that can happen but once, since all future children will be begotten, as well as born within the rules of honor and civil society. Upon reasons like these we may suppose the peers to have acted at the Parliament of Lurton, when they refused to enact that children before marriage should be esteemed legitimate. From what has been said, it appears that all children born before matrimony are bastards by law, and so it is of all children born, so long after the death of the husband, that by the usual course of gestation they could not be begotten by him. But this being a matter of some uncertainty, the law is not exact as to a few days. And this gives occasion to a proceeding at common law, where a widow is suspected to feign herself with child, in order to produce a supposititious heir to the estate, an attempt which the rigor of the Gothic constitutions esteemed equivalent to the most atrocious theft, and therefore punished with death. In this case with us the heir presumptive, or a contingent divisi, may have a writ de venire inspiciendo, to examine whether she be with child or not, and, if she be, to keep her under proper restraint till delivered, which is entirely conformable to the practice of the civil law. But if the widow be rogaverant omnes episcopi magnates, meet et approbate, stat. 20 hen. Roman 3. Ut consenterent quod nati ante matrima. 9. See the introduction to the great Nema Sent Legitimi, Stratiliqui nati charter edit. Uxan, Maran riot 9, sub anno 1 to 3. Sub post matrimonium, quia ecclesia tails steamhook, de judi goth. 1. 3 c. 5. Halit pro legitimis. Et omnis comit set. Co. Lit. By Harg 8 bn. 3. 123b. Barons una voce responderant quad nolenten. 1. Ex. Wallop 4 bro. c. 90 leges Anglam muter, quam hucusc dubitato asmigs case 2p. WMS. And child. Upon due examination found not pregnant, the presumptive heir shall be admitted to the inheritance, though liable to lose it again, on the birth of a child within 40 weeks from the death of a husband. But if a man dies and his widow soon after marries again, and a child is born within such a time as that by the course of nature it might have been the child of either husband, in this case he is said to be more than ordinarily legitimate, for he may, it is said, when he arrives to years of discretion, choose which of the fathers he pleases. To prevent this, among other inconveniences, the civil law ordained that no widow should marry infra annum luctus, a rule which obtained so early as the reign of Augustus if not of Eomulus, and the same constitution was probably handed down to our early ancestors from the commons during their stay in this island, for we find it established under the Saxon and Danish governments. Registered as bastards may be born before the coverture or marriage state is begun, or after it is determined, so also children born during wedlock may in some circumstances be bastards, as if the husband be out of the kingdom of England, or, as the law somewhat loosely phrases it, extra quattro Maria, for above nin copyright months, so that no access to his wife can be presumed, her issue during that period shall be bastards. But, generally during the coverture, access of the husband shall be presumed, unless the contrary can be shown, which is such a negative as can only be proved by showing him to be elsewhere. For the general rule is PRW sumiter pro legitimation. After a judicial separation, if the wife breeds children they are bastards, for the law will presume the husband and wife conformable to the sentence of separation, unless access be proved, but in a voluntary separation by agreement, the law will suppose access, unless the negative be shown. So also if there is an apparent impossibility of procreation on the part of the husband, as if he be 8 years old, or the like, that the issue of the wife shall be bastards. Likewise in case. This doctrine has been questioned. 5 Kep. 98. Morris v. Davis 5 Sci. And cannot be held for law, see Co. Lit. And Fenn. 163, Reg. V. Mansfield 1Q. V. 8 and Hargrave's note. Rep. 444, Hargrave v. Hargrave 9, but the year was then only 10 Bev. 552, Cia XSO I /G Gardner Peerage Months, Ovid. Fast. 1. 27. Case reported by Low Marchant. Telic let every widow continue husband Banheri peerage case, Sir Harris Nicholas less a 12 a month. 1 Thorpe, 323 4 17. Unadulterine bastardy. Maintenance of bastards. 433 of divorce. On the ground of corporal imbecility. All the issue balm during the coverture are bastards, because the marriage was unlawful and null from the beginning. 2. Let us next see the duty of parents to their bastard children by our law, which is principally that of maintenance. For though bastards are not looked upon as children to any civil purposes, yet the ties of nature, of which maintenance is one, are not so easily dissolved, and they hold indeed as to many other intentions, as particularly, that a man shall not marry his bastard sister or daughter. The civil law, therefore, when it denied maintenance to bastards begotten under certain atrocious circumstances, was neither consonant to nature nor reason. However profligate and wicked the parents might justly be esteemed, the method by which the English law provides maintenance for them is, now, after many changes, as follows. The woman may, either before or at any time within a year after the birth of an illegitimate child, or at any time thereafter upon proof that the putative father has within the 12 months next after the birth of the child paid money for its maintenance, or any time within 12 months after his return to England on proof that he ceased to reside in England within the year following the birth of the child, obtain a summons for the alleged father to appear at petty sessions, and on his appearance, or proof of the service of such summons, and on hearing the evidence of the mother corroborated in some material particular, the justices may make an order on such putative father for the payment of a weekly sum not exceeding 5 shillings until the child attains the age of 13, or, if the justices shall so direct, 16, or until the marriage of the mother, or death of the child. In case of neglect to make payment, the amount and costs may be levied by distress on the father's effects, and he may be detained in custody until the result of the distress be known, and if it prove insufficient, he may be committed to prison for 3 months. A right of appeal to the quarter sessions from the order of justices is, however, given to the putative father on his giving security for costs. The money payable under such an order is Lord Rere, G8, Combe, 356, 7 and 8 Vic, C, 101, 35 and 36 Vic, C, asterisk Nov, 89 C, 15, 65, 36 Vic, C, 9, Vol. I, 2F, 434 P and 10 child. Given to the mother, but if she be dead, or insane, or in prison, or under sentence of transportation, the justices may appoint some other person to have the custody of the child and receive the money. And if such person misapply the money, or withhold proper nourishment from the child, or otherwise abuse or maltreat it, he or she is liable to a fine of 10. But whether an order of maintenance on the putative father be obtained or not, the mother, who is entitled to the custody of her child, in preference to the father, is in any case bound to maintain it, and if, being of ability, wholly or in part, she neglects to do so, whereby the child becomes chargeable to the parish, she may be punished as an idle and disorderly person under the statute 5 Geo. Roman 4, c. 83, and on a second conviction, as a rogue and vagabond under the same statute. The guardians may also take proceedings in such a case against the putative father. 3. I proceed next to the rights and incapacities which pertain to a bastard. The rights are very few, being only such as he can acquire, for he can inherit nothing, being looked upon as the son of nobody, and sometimes called Julius Nuius, sometimes Julius II Opuli, yet he may gain a surname by reputation, though he has none by inheritance. Trade all other children have their primary settlement in their father's parish, but a bastard in that of his mother until he attains 16 years of age, upon which his settlement is in the parish of his birth. Degrees. The incapacity of a bastard consists principally in this, that he cannot be heir to anyone, neither can he have heirs, but of his own body, for, being nullius Julius, he is therefore of kin to nobody, and has no ancestor from whom any inheritable blood can be derived. A bastard was also, in strictness, incapable of holy orders, and though that were dispensed with, yet he was utterly disqualified from holding any dignity in the church. J. Bexby, Hopkins, 7 East, 579, XP, of the mother. Keene, 1 Boss, and Paul, N. R. H. A. Bodenham v. St. Andrews, Worcester. 4 and 5 Will. Roman 4. C. 76, S. 71. 1 L. and BL, 4 G5. Fort de LTI. C. 40. P. When the property of a bastard. Co. Lit. 3 escheats to the crown, it is generally 4 and 5 Will. Roman 4. C. 76, S. 71. Pre-restored to the nearest members of his viously to this statute. A bastard's settle family. Medgel v. Johnson, Doug. 542. Meant was in general in Teelick parish of its toller, X. 107. Birth Sauk, 427, in some cases in that. Fordesk, C. 40, 5 Rep. 58. Incapacity of bastards. 435. But this doctrine seems now obsolete, and in most other respects there is no distinction between a bastard and another man. And really any other distinction but that of not inheriting, which civil policy renders necessary, would, with regard to the innocent offspring of his parents' crimes, be odious, unjust, and cruel to the last degree. And yet the civil law, so boasted of for its equitable decisions, made bastards in some cases incapable even of a gift from their parents. A bastard may, lastly, be made legitimate and capable of inheriting by the transcendent power of an act of Parliament, and not otherwise as was done in the case of John of Gaunt's bastard children, by a statute of Richard Roman II. Ca. 657 5, Forians. 36. 2. 436. Chapter Roman 17. Of guardian and ward. The only general private relation now remaining to be discussed is that of guardian and ward, which bears a very near resemblance to the last and is plainly derived out of it. The guardian being only a temporary parent, that is, for so long a time as the ward is an infant or under age. In examining this species of relationship, I shall first consider the different kinds of guardians, how they are appointed, and their power and duty. Next, the different ages of persons, as defined by the law, and, lastly, the privileges and disabilities of an infant, or one under age and subject to guardianship. The guardian with us performs the office both of the tutor and curator of the Roman laws, the former of which had the charge of the maintenance and education of the minor, the latter the care of his fortune, or, according to the language of the Court of Chancery, the tutor was the committee of the person, the curator the committee of the estate. But this office was frequently united in the civil law, as it is always in our law with regard to minors, though as to lunatics and idiots it is commonly kept distinct. 1. Of the several species of guardians, the first are guardians H/nature, viz. the father and, in some cases, the mother of the child. This guardianship is a mere personal right in the father or other ancestor to the custody of the person of the infant until he or she attains 21 years of age. *4. If an estate be left to an infant, the father is by common law the guardian, and must account to his child for the profits. 2. There are also guardians for nurture, which are the father, late, by Hard. 88 N. 63-71, Reg. V. Thorpe Orth. 386. Several kinds of guardians. 437 or, if he be dead, the mother, till the infant attains the age of 14 years. A guardianship which, like that by nature, has no reference to the infant's property, but relates merely to his person, in default of father or mother, the court usually assigns some discreet person to take care of the infant's personal estate, and to provide for his maintenance and education. 3. Next are guardians in socage, an appellation which will be fully explained in the second book of these commentaries, who are also called guardians high the common law. These take place only when the minor is entitled to some estate in lands, and then by the common law the guardianship devolves upon his next of kin, to whom the inheritance cannot possibly descend. As, where the estate descended from his father, in this case his uncle by the mother's side cannot possibly inherit this estate, and therefore shall be the guardian. For the law judges it improper to trust the person of an infant in his hands, who may by ex-eighth's ability become heir to him, that there may be no temptation, nor even suspicion of temptation, for him to abuse his trust. The Roman laws proceed on a quite contrary principle, committing the care of the minor to him who is the next to succeed in the inheritance, presuming that the next heir would take the best care of an estate to which he has a prospect of succeeding. And this they boast to be summa piovidentia. But in the meantime they seem to have forgotten how much it is the guardian's interest to remove the encumbrance of his pupil's life from that estate for which he is supposed to have so great a regard. And this affords Fortescue and Sir Edward Coke an ample opportunity for triumph, they affirming that to commit the custody of an infant to him that is the next in succession is Putici agnum committer, Ludgebo ad divorandum. These guardians in socage like those. More. 738. Pre Rep. 38. C Stat. Hilbum. 14 Hen. Roman 3. This *2 Jones, 90, 2 Lev. 163. Policy of our English law is warranted *. By descent, quadring v. Down to 2 by the wise institutions of Solon, Humad. 176. Provided that no one should be another's. Gland. 1. 7 C. 11. FF. 26 4 1. Guardian who was to enjoy the estate. The Roman satirist was fully aware after his death. Potter's Antic. B. 1 C. of this danger when he puts this private 26. And ch Tyrandas, another of the prayer into the mouth of the selfish Grecian legislators, directed that the guardian inheritant shall go to the father's pupium otium quem proximus relations, but the education of the child tours to the mothers, that the guardianship impello expungam. Verse 112. And right of succession rage ht always. 438 Quotidian and ward. For nurture, continue only till the minor is 14 years of age, for then, in both cases, he is presumed to have discretion, so far as to choose his own guardian. 4. For this he may do, unless one be appointed by the father, by virtue of the statute 12 Car. Roman 2. c. 24, which, considering the imbecility of judgment in children of the age of 14, and the abolition of guardianship in chivalry, which lasted till the age of 21, and of which we shall speak hereafter, enacts, that any father, under age or of full age, may by deed or will dispose of the custody of his child, either born or unborn, to any person, either in possession or reversion, till such child attains the age of 21 years. These are called guardians by statute or testamentary guardians. The Act of Charles Roman II, it will be observed, enables the feather only to appoint guardians. It confers no such power on the mother, and it does not extend to a putative father, nor a person in loco parentis, though the High Court, in the exercise of its general jurisdiction over infants, pays great attention to nominations of guardians by such testators. 5. Guardians may be chosen or elected by the infant on attaining 14, but this kind of guardianship, which is quite unknown in practice, seems not to extend beyond giving the consent to marriage required by the statutes mentioned in a previous part of this volume, and the infant's election, it may be added, in no case supersedes the jurisdiction of the High Court. For the Lord Chancellor was, by right derived from the Crown, the general and supreme guardian of all infants, that is, of all such persons as have not discretion enough to manage their own concerns, until his jurisdiction was vested in the High Court of Justice. Be kept distinct. Petit. Leg. At 1. G. and M. C. 8. That act was repealed by 9t. 7. Dio. Roman 4. C. 31. Wade v. Baker 1 LD. EM. 131. Vaughan's Eep. 180. J. Sir William Blackstone mentions Chatteris v. Young 1 Jack. And Walk. Under the head of guardianship high nature, 106. One species of guardianship which seems Curtis v. Bipoi 4 Man. 462. To have been by statute only, viz. that. And it is accordingly now exercised, which occurred where a father assigned in the Chancery Division the Judia guardian to a woman child under Couture Act 1873 S. 34. 16. By virtue of the Statute 4 and 5. Jurisdiction of Chancery 439 6. This jurisdiction, whatever may have been its origin, had long been firmly established and beyond the reach of controversy, degrees it being a settled maxim that the sovereign is the universal guardian of all the infants in the kingdom. The court, therefore, will appoint a suitable guardian for an infant, where there is no other who will or can act, for if there are testamentary guardians, the court has no jurisdiction to do so. It will also, in general, abstain from interference, unless the infant has property, not from any want of jurisdiction, but from the want of means to exercise its authority with effect. When, however, guardians are appointed, and their nomination is entirely a matter of discretion, they are treated as officers of the court, and are held responsible accordingly. The court will not only remove guardians appointed by its own authority, but it will also remove guardians at the common law, and even testamentary or statute guardians, whenever sufficient cause can be shown for so doing. For guardianship is always regarded by the law as a delegated trust for the benefit of the infant. And in case therefore any guardian abuses his trust, the court will check and punish him, nay, sometimes will proceed to the removal of him, and appoint another in his stead. The court will sometimes also require security to bow given by the guardian, and on the other hand will assist him in the performance of his duties, as well in obtaining the custody of the person of the ward as otherwise. The jurisdiction of the Court of Chancery extends to the care of the person of the infant, so far as is necessary for his protection and education, and to the care of his property, for its management and preservation, and proper application for his maintenance. It is upon the former ground that the court interferes with the ordinary rights of parents, as guardians by nature or by nurture, for whenever a father is guilty of gross ill-treatment of or cruelty to his children, or is in constant habits of drunkenness and blasphemy, or a low and gross debauchery, or professes atheistical or irreligious principles, or his domestic associations are such as tend to the corruption and contamination of his children, the court will interpose and deprive him of the custody of the infants, appointing at the same time a suitable person to act as guardian, and superintend their education. And Wellesley v. Wellesley, 2 Blig, N. S. Stories Ek. Jur. Vol. Roman 2. Ch. 5. 124-145. 1 Cit. 424. 1 P. WMS. Guardian and ward. This interference may be obtained on the petition of the infant himself, or of any of his friends or relatives. Nay, a mere stranger may at any time set the machinery of the court in motion. In most instances, however, its jurisdiction arises from a suit being actually pending relative to the person or property of the infant, and in such cases, although not under the care of any guardian appointed by the court, the infant is treated as a ward. And a ward in chancery is in all cases under the special protection of the court, for no act can be done affecting the minor's person, property, or estate, unless under its express or implicit direction, every act done without such direction being considered a contempt, exposing the offender to be attached and imprisoned. Thus it is a contempt to conceal or withdraw the person of the infant from the proper custody, or to disobey any order of the court relative to its maintenance or education, or to marry the infant without the approbation of the court. For the court, in approving a person to be guardian, usually gives him express directions how to exercise the powers which it has conferred, prescribes the residence, and settles a scheme for the education of the infant, and regulates, if necessary, his choice of a profession or trade, approves or prohibits the minor's marriage, and performs all the other duties of guardians by nature or for nurture. With respect to the property of the ward, the court not only superintends its management during the owner's minority, but directs a proper settlement on the marriage of its ward, and this protection is not always removed upon the minors attaining 21, but is, for some purposes, continue afterwards, especially with regard to the marriage of female wards, in these and other respects. Therefore, guardians appointed by the court have extensive delegated powers, this species of guardianship being one far more capable of adaptation to the various requirements of modern society, the intentions of testators, the wants and wishes of the infants themselves, and the different kinds of property which may call for administrative care, than all or any of the other guardianships known to the law. The guardian, for instance, may case for the opinion of the court, and he represent infants under the acts. Author may represent infants in the winding up easy advances of public money for of joint stock companies. Draining, he may concur in a special. Incidents of infancy. 441. The court has also a statutory authority to appoint a guardian for the purpose of consenting to the marriage of any infant who has no father or unmarried mother, or other guardian, and may also give an effectual consent to the marriage of a minor, when the consent required by law cannot be obtained, or is improperly withheld. The court may also, by statute 3 and 4 Vict. C. 90, confer all the rights of a guardian, to the exclusion of the parents or other guardians, on any person who is willing to take the charge of, and to provide for the maintenance and education of an infant who has been convicted and suffered the punishment of felony. 7. A guardian ad litem, or as he is in general termed, a prochine ami or next friend, is one who is appointed by the court to prosecute the suit or manage the defense of an infant. This prochine ami may be any person who will undertake the infant's cause, and it frequently happens that an infant, by his prochine ami, institutes an action against a fraudulent guardian. The prochine ami, who is usually the father, acquires by this kind of guardianship no authority over the person or property of the infant except as regards the suit itself, but as he possesses all the authority and incurs all the responsibility for costs and otherwise of an ordinary suitor, the court will not allow him, if an uncertificated bankrupt or an insolvent, to act as a guardian ad litem. 8. There are also special guardians, such as guardians in gave-kind, whose authority does not cease till the infant attains 15 years of age, and guardians by the custom of London and other places. But they are particular exceptions, and do not fall under the general law. The power and reciprocal duty of a guardian and ward are the same, pro tempore, as that of a father and child, and therefore I shall not repeat them, but shall only add that the guardian, when the ward comes of age, is bound to give him an account of all that he has transacted on his behalf, and must answer for all losses by his wilful default or negligence. In order, therefore, Geo. Roman 4. C. 76. A. 16. Co. Lit. 88. Back. Aber. A. 2. Row Watson v. F. Sir. 8M. N. W. 060. Binson on Givkamal. 237. IHD Chit v. Sachisel 12M. N. W. 442 Guardian and Ward. 4. To prevent disagreeable contests with young gentlemen, it has become a practice for many guardians, of large estates especially, to indemnify themselves by applying to the court, acting under its direction, and accounting annually before its officers. 2. Let us next consider the ward or person within age, for whose assistance and support these guardians are constituted by law, or who it is that is said to be within age. The ages of male and female are different for different purposes. A male at 12 years old may take the oath of allegiance, did 14 is at years of discretion, and therefore may consent or disagree to marriage, may choose his guardian, may be an executor, although he cannot act until of age, and at 21 is at his own disposal, and may alien and devise his lands, goods, and chattels. A female also at 7 years of age may be betrothed or given in marriage, at 9 is entitled to dower, at 12 is at years of maturity, and therefore may consent or disagree to marriage, at 14 is at years of legal discretion, and may choose a guardian, at 17 may be executrix, and at 21 may dispose of herself and her lands. So that full age in male or female is 21 years, which age is completed on the day preceding the anniversary of a person's birth, who till that time is an infant and so styled in law. Among the ancient Greeks and Eomans, women were never of age, but subject to perpetual guardianship, unless, when married, nisi convenescent in manum biri, and when that perpetual tutelage wore away in process of time, we find that, in females as well as males, full age was not till 25 years. Thus by the constitution of different kingdoms this period, which is merely arbitrary, and juris positivi, is fixed at different times. Scotland agrees with England in this point, both probably copying from the old Saxon constitutions on the continent, which extended the age of minority. Ad annum bidesum primum, et eo usque juvens sub tutelem reponant. Asterisk. XP, Whitfield 2 ATK, 316. Sal. 44, 625, Lord Eam. 480. Asterisk formerly, if a minor's discretion 1096, Toter v. Sansum Dom. Proc. 27 were actually proved, he or she might feb. 1775. Make a testament of personal estate, BL. Pa. Antic. B. 4 C. 11. Sic. Procom. Vol. I. P. 463. But a minor can in Murin. 12. No case now make a will. Sterntuk 1. 2 C. 2. 38 Geo. Roman 3. C. Of infancy. 443 3. Infants have various privileges and various disabilities. But their varied disabilities are privileges, in order to secure them from hurting themselves by their own improvident acts. An infant cannot be sued, but under the protection, and joining the name, of his guardian, for he is to defend him against all attacks as well by law as otherwise, but he may sue either by his guardian, or as we have already seen, by his Iwichin Amy, his next friend who is not his guardian. In criminal cases, an infant of the age of 14 years may be capitally punished for any capital offense, but under the age of 7 he cannot. The period between 7 and 14 is subject to much uncertainty, for the infant shall, generally speaking, be judged prima facie innocent. Yet if he was dully epax and could discern between good and evil at the time of the offense committed, he may be convicted and undergo judgment and execution, though he has not attained to years of puberty or discretion. With regard to estates and civil property, an infant has many privileges, which will be better understood when we come to treat more particularly of those matters. But this may be said in general, that an infant shall lose nothing by non-claim, or neglect of demanding his right, nor shall any other lashes or negligence be imputed to an infant, except in some very particular cases. It is generally true that an infant can neither alien his lands, nor do any legal act, nor make a deed, nor indeed any manner of contract that will bind him. But still to all these rules there are some exceptions, part of which were just now mentioned in reckoning up the different capacities which they assume at different ages. And there are others, a few of which it may not be improper to recite as a general specimen of the whole. And, first, it is true that infants cannot alien their estates. But infant trustees, or mortgagees, are enabled to convey, under the an infant may sty for wage/eason the who is liant, for by hiding he knew county court as if he were of full age. He had done wrong, and malicia supplet. Sir Matthew Hale gives us to an addendum. A boy of 10 years old, who stances, one of a girl of 13, who was guilty of a heinous murder, was burned for killing her mistress, held a proper subject for capital punishment of a boy still younger, that Hale meant, by the opinion of all the judges, killed his companion and hid himself, foster, guardian and ward. Direction of the court, the estates they hold in trust or mortgage to such person as the court shall appoint, a mode of transfer not always necessary, since the court can effect the same object by its own order. So, infants may make conveyances and mortgages under order of the court in suits for the payment of debts, and with the consent of the court may make valid settlements of either real or personal estate on their marriage. Also it is generally true that an infant can do no legal act, yet an infant, who has an advocen, may present to the benefice when it becomes void. For the law in this case dispenses with one rule, in order to maintain others of far greater consequence. It permits an infant, at least with the concurrence of the guardian, to present a clerk who, if unfit, may be rejected by the bishop, rather than either suffer the church to be unserved till he comes of age, or permit the infant to be debarred of his right by lapse to the bishop. An infant may also purchase lands, but his purchase is incomplete, for when he comes to age, he may either agree or disagree to it, as he thinks prudent or proper, without alleging any reason, and so may his heirs after him, if he dies without having completed his agreement. It is, farther, generally true that an infant, under 21, can make no deed, but what is afterwards voidable, registered. Yet in some cases he may bind himself apprentice by deed indented or indentures for 7 years, and he may by deed appoint a guardian to his children, if he has any doubt. Lastly, it is generally true that an infant can make no other contract that will bind him. Yet he may bind himself to pay for his necessary meat, drink, apparel, physic, and such other necessaries, and likewise for his good teaching and instruction, whereby he may profit himself afterwards. But the contract of an infant, not for necessaries, would seem to be voidable only, and not void if for his benefit, and therefore if it be ratified by him on his attaining full age, he will be bound by it. Thus a lease made by him while an infant is voidable, but if he accepts rent at full Shopland v. Biter, Crow, Jack, 99, Bank, and in certain cases if 14 Harg, Co. Lit. 89 N. 71 years of age may execute a power of XP. Davis 5T. R. 715. Attorney to withdraw the deposits, and *5 Eliz. C. 4. 43 Eliz. C. 2. Bex v. may be a member of, and execute in Great Wigston, 3b, and c. 485. Struments relating to friendly societies. E. Stat. 12 Car. Roman 2, c. 24. This he. Smithy, Willens 4L, and BL 180. Might formerly do by will, but an infant *co. Lit. 172. Cannot now make a will. Gibbs v. Merrill, Treatise, 307. Good. He may invest money in the savings. V. Harrison 5b, and aid, 159. Of infancy. 445 age, he cannot afterwards avoid the demise. So if after attaining majority he remains in possession of premises leased to him during his infancy, he affirms the lease, and is liable even for arrears of rent accrued during his non-aged trade, but as to any other contract than one for necessaries, or for his benefit, he is not bound by it, and all contracts, even by specialty for the repayment of money lent or to be lent or for goods supplied except necessaries, and all accounts stated, are absolutely void, and no ratification after full age of any contract made during infancy, or any promise to pay a debt contracted during infancy, now affords ground of action. And thus much, at present, for the privileges and disabilities of infants. Ashfield v. Ashford, Sir William. C. As to the liability of infant Jones, 157. Partners of Joint Stock Companies, Dublin. 1 Roll, Aber. N/Ants. Curtin v. and Wicklow Railway Company v. Black, Elliot, 3 Bu Lt. 69. Evelyn v. Chichester, 8x, 181. 3 Burr, 1709. 37 and 38 Vict. C. Chapter Roman 18. Of corporations in general. We have hitherto considered persons in their natural capacities, and have treated of their rights and duties. But as all personal rights die with the person, and, as the necessary forms of investing a series of individuals, one after another, with the same identical rights, would be very inconvenient, if not impracticable, it has been found necessary, when it is for the advantage of the public to have any particular rights kept on foot and continued, to constitute artificial persons, who may maintain a perpetual succession, and enjoy a kind of legal immortality. These artificial persons are called bodies politic, bodies corporate, corpora corporata, or corporations, of which there is a great variety subsisting, in order to preserve entire and for ever those rights and immunities, which, if they were granted only to those individuals of which the body corporate is composed, would upon their death be utterly lost and extinct. To show the advantages of these incorporations, let us consider the case of a college in either of our universities, founded ad studendum et orandum, for the encouragement and support of religion and learning. If this was a mere voluntary assembly, the individuals which compose it might indeed read, pray, study, and perform scholastic exercises together, so long as they could agree to do so. But they could neither frame nor receive any laws or rules of their conduct, none, at least, which would have any binding force, for want of a coercive power to create a sufficient obligation. Neither could they be capable of retaining any privileges or immunities. For if such privileges be attacked, which of all this unconnected assembly has the right or ability to defend them? And, when they are dispersed by death or otherwise, how shall they transfer these advantages to another set of students equally unconnected as themselves? Origin of corporations. 447. So also with regard to holding estates or other property, if land be granted for the purpose of religion or learning to 20 individuals not incorporated, there is no legal way of continuing the property to any other persons for the same purposes, but by endless conveyances from one to the other, as often as the hands are changed. But when they are consolidated and united into a corporation, they and their successors are then considered as one person in law. As one person they have one will, which is collected from the sense of the majority of the individuals. This one will may establish rules and orders for the regulation of the whole, which are a sort of municipal laws of this little republic, or rules and statutes may be prescribed to it at its creation, which are then in the place of natural laws. The privileges and immunities, the estates and possessions of the corporation, when once vested in them, will be forever vested without any new conveyance, to new successors. for all the individual members that have existed from the foundation to the present time, or that shall ever hereafter exist, are but one person in law, a gerson that never dies, in like manner as the river Thames is still the same river, though the parts which compose it are changing every instant. The honor of originally inventing these political constitutions entirely belongs to the Romans. They were introduced, as Plutarch says, by Numa, who finding, upon his accession, the city torn to pieces by the two rival factions of Sabines and Romans, thought it a penitent and iolytic measure to subdivide these two into many smaller ones by instituting separate societies of every manual trade and profession. They were afterwards much considered by the civil law, in which they were called universities, as forming one whole out of many individuals, or collegia, from being gathered together. They were adopted also by the canon law, for the maintenance of ecclesiastical discipline, and from them our spiritual corporations are derived. But our laws have considerably refined and improved upon the invention, according to the usual genius of the English nation, particularly with regard to sole corporations consisting of one person only, of which the Roman lawyers had no notion, their maxim being that tres fatant collegium. Though they held that if a corporation originally consisting of 3 persons be reduced to 1, see Universitas ad inerti redit, it may still subsist as a corporation. Et stet nomen universitatis. 448 Corporations. Before we proceed to treat of the several incidents of corporations as regarded by the laws of England, let us first take a view of the several sorts of them, and then we shall be better enabled to apprehend their respective qualities. The first division of corporations is into aggregate and sole. Corporations aggregate consist of many persons united together into one society, and are kept up by a perpetual succession of members, so as to continue forever, of which kind are the mayor and commonalty of a city, the head and fellows of a college, the dean and chapter of a cathedral church. Corporations sole consist of one person only and his successors in some particular station, who are incorporated by law, in order to give them some legal capacities and advantages, particularly that of perpetuity, which in their natural persons they could not have had. In this sense the sovereign is a sole corporation, so is a bishop, so are some deans and prebendaries, distinct from their several chapters, and so is every parson and vicar dovesterisk, and the necessity, or at least use, of this institution will be very apparent if we consider the case of a parson of a church. At the original endowment of parish churches, the freehold of the church, the churchyard, the parsonage house, the glebe, and the tithes of the parish were vested in the then parson by the bounty of the donor as a temporal recompense to him for his spiritual care of the inhabitants, and with intent that the same emolument should ever afterwards continue as a recompense for the same care. But how was this to be effected? The freehold was vested in the parson, and if we suppose it vested in his natural capacity, on his death it might descend to his heir and would be liable to his debts and encumbrances, or at best, the heir might be compellable at some trouble and expense to convey these rights to the succeeding incumbent. The law therefore has wisely ordained that the parson, quatenus parson, shall never die, any more than the sovereign, by making him and his successors a corporation, by which means all the original rights of the parsonage are preserved entire to the successor. For the present incumbent, and his predecessor who lived 7 centuries ago, are in law one and the same person, and what was given to the one was given to the other also. Another division of incorporations, either sole or aggregate, is into ecclesiastical and lay. Ecclesiastical corporations are where a vicar choral, for instance, Greener v. F in RFIU 7c. B. N. S. Division of corporations. 449 The members that compose it are entirely spiritual persons, such as bishops, certain deans and prebendaries, all archdeacons, parsons, and vicars, which are sole corporations, deans and chapters at present and formerly prior and convent, abbot, and monks, and the like, bodies aggregate. These are erected for the furtherance of religion and perpetuating the rights of the church. Lay corporations are of 2 sorts, civil and eleemosynary. The civil are such as are erected for a variety of temporal purposes. The sovereign, for instance, is made a corporation to prevent in general the possibility of an interregnum, or vacancy of the throne, and to preserve the possessions of the crown entire, for immediately upon the demise of one sovereign, his successor is, as we have formerly seen, in full possession of the regal rights and dignity. Other lay corporations are erected for the good government of a town or particular district, as a mayor and commonalty, bailiff and burgesses, or the like, some for the advancement and regulation of manufactures and commerce, as the trading companies of London, and other towns, and some for the better carrying on of divers special purposes, as churchwardens, for conservation of the goods of the parish. The colleges of physicians and surgeons in London, for the improvement of the medical science, the Royal Society for the advancement of natural knowledge, and the Society of Antiquaries for promoting the study of antiquities. And among these the general corporate bodies of the universities of Oxford and Cambridge must be ranked. For it is clear they are not spiritual or ecclesiastical corporations, being composed of more laymen than clergy ***, neither are they eleemosynary foundations, though stipends are annexed to particular magistrates and professors, any more than other corporations where the acting officers have standing salaries, for these are rewards pro opera et labor, not charitable donations only, since every stipend is preceded by service and duty. They seem therefore to be merely civil corporations. The eleemosynary sort are such as are constituted for the perpetual distribution of the free alms, or bounty, of the founder of them to such persons as he has directed. Of this kind are all hospitals for the maintenance of the poor, sick, and impotent. And all colleges, both in our universities, and out of them, which colleges are founded for two purposes. 1. For the promotion of. See the observations of Lord Mansfield, in 3 Bur. 1656. Such as at Manchester, Eton, Winchester, and C. Vol. I. Piety and learning by proper regulations and ordinances. 2. For imparting assistance to the members of those bodies, in order to enable them to prosecute their devotion and studies with greater ease and assiduity. And all these eleemosynary corporations are, strictly speaking, lay and not ecclesiastical, even though composed of ecclesiastical persons ***, and although they in some things partake of the nature, privileges, and restrictions of ecclesiastical bodies. These are the several species of corporations known to our law. Of some of them, which possess peculiar qualities, and of others which have not all the usual incidents of a corporation, I shall treat separately, and with this view shall consider. First, corporations in general, secondly, municipal corporations, and thirdly, trading corporations. Let us then proceed to consider. With reference to corporations in general. 1. How corporations may be created. 2. What are their powers, capacities, and incapacities? 3. How corporations are visited. And 4. How they may be dissolved. 1. Corporations, by the civil law, seem to have been created by the mere act and voluntary association of their members. Provided such convention was not contrary to law, for then it was a licitum collegium. It does not appear that the prince's consent was necessary to be actually given to the foundation of them, but merely that the original founders of these voluntary and friendly societies, for they were very little more than such, should not establish any meetings in opposition to the laws of the state. But, with us in England, the consent of the Crown is absolutely necessary to the erection of any corporation, either implicitly or expressly given. The sovereign's implied consent is to be found in corporations which exist by force of the common law, to which our former kings are supposed to have given their concurrence, common law being nothing else but custom, arising from the one Lord Rame. 6. Which the consent of the feudal cities and towns were first erected sovereign was absolutely necessary, into corporate communities on the con as many of his prerogatives and revenant, and endowed with many values were thereby considerably dimeable privileges, about the 11th nisht century. Robertson, Charter v. 2. Creation of corporations. 451 Universal agreement of the whole community. Of this sort are the sovereign himself, all bishops, parsons, vicars, churchwardens, and some others, who by common law have ever been held, as far as our books can show us, to have been corporations, vidi ufficii. And this incorporation is so inseparably annexed to their offices that we cannot frame a complete legal idea of any of these persons, but we must also have an idea of a corporation capable to transmit his rights to his successors at the same time. Another method of implication, whereby the consent of the Crown is presumed, is as to all corporations by prescription, such as the City of London, and many others which have existed as corporations time whereof the memory of man runneth not to the contrary, and therefore are looked upon in law to be well created. For though the members thereof can show no legal charter of incorporation, yet in cases of such high antiquity, the law presumes there once was one, and that by the variety of accidents which a length of time may produce, the charter is lost or destroyed. The methods by which the consent of the Crown is expressly given are either by Act of Parliament or Charter. By Act of Parliament, of which the royal assent is a necessary ingredient, corporations may undoubtedly be created, but it is observable that, till of late years, most of those statutes which have been usually cited as having created corporations either confirm such as had been before created by the sovereign, as in the case of the College of Physicians erected by a charter of Henry Veal, which charter was afterwards confirmed in Parliament by 14 and 15 Hen. Roman 8. c. 5. Or they enabled the sovereign to erect a corporation in feudere with such and such powers, just as the case of the Bank of England and the Society of the British Fishery. For although it was always in the JW or of the Crown to confer on any set of individuals the privileges of a corporation, such as a common seal and perpetual succession, to sue and be sued, and receive and convey by its corporate name, yet there were many powers which the Crown could not by its prerogative, but which Parliament alone could confer. Formerly, indeed, when the want of these powers was not much felt, the immediate creative act was usually performed by the sovereign alone, in virtue of the royal prerogative. But in Stat. 5 and 6 W, and MC. 20 Stat. 23 Geo. Roman 2. c. Modern times corporations have been usually created either directly by Act of Parliament, or erected by the Crown under the authority of a statute. Thus the sovereign is enabled by 5 and 6 Will. Roman 4. c. 76 to grant charters of incorporation to populous towns, which are thenceforth to have the municipal government, powers of police, and other privileges conferred on such corporations by the legislature, the most important of which is the right to levy rates for municipal and other purposes. Of corporations, again, formed under the provisions of an Act of Parliament, registered joint stock companies are familiar instances. The creation of a corporation by the Crown may be performed by the words primus, erigimus, fundamus, incorporamus, or the like. Nay, it is held that if the sovereign grants to a set of men to have gilda meritorium, a mercantile meeting or assembly ***, this is alone sufficient to incorporate and establish them for ever. The sovereign, it is said, may grant to a subject the power of erecting corporations, though the contrary was formerly held. That is, he may permit the subject to name the persons and powers of the corporation at his pleasure, but it is really the Crown that erects, and the subject is but the instrument. For, though none but the sovereign can make a corporation, yet qui facit per alium fiat per se. In this manner the Chancellor of the University of Oxford has power by charter to erect corporations, and has actually often exerted it, in the erection of several matriculated companies of tradesmen subservient to the students. So by one of the charters of the City of London, power is given to the corporation to establish companies, fraternities, and guilds, which are to be subject to the general control of the civic authorities. The Parliament, we observed, by its absolute and transcendent authority, may perform this or any other act whatsoever, and actually did perform it to a great extent, by Statute 39 Eliz. c. 5, which incorporated all hospitals and houses of correction founded by charitable persons, without farther trouble, and the same has been done in other cases of charitable foundations. In this, guild signified among the Saxons a 10 rep. 30, 1 roll, aber. 513. Fraternity, derived from the verb gilden bro, aber. Te. Prerog. 53. Viner. To pay, because every man paid his prerog. 88. Pi. 16. share towards the expenses of the Commentaries yearbook to Han. Roman 7:13. Munity, and hence their place of meetsi as a modern instance, the ing is frequently called the Guild, or Elementary Education Act, 1870, s. 30, Guild Hall, and the Public Health Act, 1875. Particular instance it was done, as Sir Edward Coke observes, to avoid the charges of incorporation and licenses of morbane and small benefactions, which in his days were grown so great, that they discouraged many men from undertaking these pious and charitable works. So the Parliament may remodel any existing corporations, as was done by the Statute 4 and 5 Will. Roman 4, c. 76, usually called the Municipal Corporation Reform Act, by which all laws, statutes, and usages, and so much of all royal and other charters, grants, and letters patent then in force, relating to 178 corporations, were, so far as inconsistent with its provisions, repealed, and the Constitution, privileges, powers, capacities, and incapacities of all these bodies assimilated in all respects. When a corporation is erected, a name must be given to it, and by that name alone it must sue and be sued and do all legal acts. Trade such name is the very being of its constitution, and though it is the will of the sovereign that erects the corporation, yet the name is the knot of its combination, without which it could not perform its corporate functions. The name of incorporation, says Sir Edward Coke, is as a proper name, or name of baptism, and therefore when a private founder gives his college or hospital a name, he does it only as a godfather, and by that same name the king baptizes the incorporation. 2. After a corporation is so formed and named, it acquires many powers, rights, capacities, and incapacities, which we are next to consider. Some of these are necessarily and inseparably incident to every corporation, which incidents, as soon as a corporation is duly erected, are tacitly annexed of course. As 1. To have perpetual succession. This is the very end of its incorporation, for there cannot be a succession for ever without an incorporation, and therefore all aggregate corporations have a power necessarily implied of electing members in the room of such as go off. 2. To sue or be sued, implead or be impleaded. Sir W.M. Blackstone adds, though changed, b. v. Registrar and joint a very minute variation therein is not stock companies, 10q. b. 839. Material. But see Rampro v. Hull N. Those here mentioned chiefly relate London Insurance Co. 3H. and N. 789. To corporations by charter or prescript gilb. Is. C. P. 182. A name, it on, and not in general to modem is said, may be implied. 1 Sal. 191. Corporations created by statute, or under, and in some corporations it may be the powers of acts of Parliament. 454 corporations. Grant or receive, by its corporate name, and do all other acts as natural persons may. 3. To purchase lands and hold them for the benefit of themselves and their successors, which two are consequential to the former. 4. To have a common seal. For a corporation being an invisible body, cannot manifest its intention by any personal act or oral discourse. It therefore acts and speaks only by its common seal. For, though the particular members may express their private consents to any act, by words or signing their names, yet this does not bind the corporation. It is the fixing of the seal, and that only, which unites the several assents of the individuals who compose the community, and makes one joint assent of the whole. 5. To make bylaws or private statutes for the better government of the corporation if which are binding upon themselves, unless contrary to the laws of the land * or inconsistent with their charter, or unreasonable, and then they are void. This is also included by law in the very act of incorporation. For as natural reason is given to the natural body for the governing it, so bylaws or statutes are a sort of political reason to govern the body politic. These 5 powers are inseparably incident to every corporation, at least to every corporation aggregate. For 2 of them, though they may be practiced, yet are very unnecessary to a corporation's soul, viz. to have a corporate seal to testify his sole assent, and to make statutes for the regulation of his own conduct. There are also certain privileges and disabilities that attend an aggregate corporation, and are not applicable to such as are sole. The reason of them ceasing, and of course the law. It must always appear by attorney, for it cannot appear in person, being, as Sir Edward Coke says, invisible, and existing only in intendment and consideration of law. It can neither maintain, nor be made defendant to, an action of battery or such like personal injuries, for a corporation can neither beat nor be beaten in its body politic, but it may sue and be sued for breaches of contract. P. Piper v. Chappell 14M, N.W. 624. They be approved by the Chancellor 1 Rex v. The Coopers. Company of Treasurer and Chief Justices or the Newcastle 70. K. 543. No trading judges of assize in their circuits, and company is with you allowed to make even though they be so approved, still, by laws which may affect the kings if contrary to law, they are void, prerogative, or the common profit of. Bex v. Cutbush. Forber. 2204. The people, under penalty of 40L, unless. Carter v. Sanderson 5 Bing. Capacities and incapacities of corporations. 455 and in certain cases maintain an action for injuries received, and be liable in damages for wrongs committed by it. A corporation cannot commit treason or felony, or other crime, in its corporate capacity. Yet it may be indicted in certain cases for acts of omission, as for the non-repair of a bridge or a highway, when this duty is imposed on it by law. Neither is a corporation capable of suffering a traitor's or felon's punishment, for it is not liable to corporal penalties, nor to forfeiture. It cannot be executor or administrator, or perform any personal duties, for it cannot take an oath for the due execution of the office. It cannot be seized of lands to the use of another, for such kind of confidence is foreign to the end of its institution. Neither can it be committed to prison, for its existence being ideal, no man can apprehend or arrest it. And therefore also it cannot be outlawed. For outlawry always supposes a precedent right of arresting, which has been defeated by the parties absconding, and that also a corporation cannot do. Neither can a corporation be excommunicated, for it has no soul, as is gravely observed by Sir Edward Coke. And therefore it is not liable to be summoned into the ecclesiastical courts upon any account, for those courts act only pro salute anini, and their sentences can only be enforced by spiritual censures, a consideration which, carried to its full extent, would alone demonstrate the impropriety of these courts interfering in any temporal rights whatsoever. There are also other incidents and powers which belong to some sort of corporations and not to others. An aggregate corporation may take goods and chattels for the benefit of themselves and their successors, but a sole corporation cannot, for such movable property is liable to be lost or embezzled, and would raise a multitude of disputes between the successor and executor, which the law is careful to avoid. In ecclesiastical and eleemosynary foundations, the sovereign or the founder may give them rules, laws, statutes, and ordinances which they are bound to observe. But corporations merely lay, constituted for civil purposes, are subject to no particular statutes, but to the common law, and to their own bylaws, not contrary to the laws of the realm. Aggregate corporations also, that have by their constitution a head as a dean, warden, master, or the like, cannot do any acts. 4H and N. 87, 8L, and BL. 801. Suit were formerly in all civil cases. For these reasons the proceedings and in criminal cases still are. By distress to compel a corporation to appear to any on their lands and goods. Corporations. During the vacancy of the headship, except only appointing another, neither are they then capable of receiving a grant, for such corporation is incomplete without a head. Yet there may be a corporation aggregate constituted without a head, as the Collegiate Church of Southwell in Nottinghamshire, which consists only of prebendaries, and the governors of the Charterhouse, London, who have no president or superior, but are all of equal authority. In aggregate corporations also, the act of the major part is esteemed the act of the whole. By the civil law, this major part must have consisted of 2/3 of the whole, else no act could be performed, which perhaps may be one reason why they required 3 at least to make a corporation. But with us, any majority is sufficient to determine the act of the whole body. And whereas, notwithstanding the law stood thus, some founders of corporations had made statutes in derogation of the common law, making very frequently the unanimous assent of the society to be necessary to any corporate act, which King Henry Roman VIII found to be a great obstruction to his projected scheme of obtaining a surrender of the lands of ecclesiastical corporations. It was therefore enacted by Statute 33 Hen. Roman A. C. 27. That all private statutes shall be utterly void, whereby any grant or election made by the head with the concurrence of the major part of the body is liable to be obstructed by any one or more, being in the minority. But this statute extends not to any negative or necessary voice given by the founder to the head of any such society. We before observed that it was incident to every corporation to have a capacity to purchase lands for themselves and successors, and this is regularly true at the common law. But they are excepted out of the statute of wills, so that no devise of lands to a corporation by will is good, except for charitable uses, by statute 43 Lis. C. 4, which exception is again greatly narrowed by the statute 9 Glio. Roman 2. C. 36. And also, by a great variety of statutes, their privilege even of purchasing from any living grantor is much abridged, so that a corporation, either ecclesiastical or lay, must have now a license from the crown to purchase, before they can exert the capacity which is vested in them by the common law, nor is even this in all cases sufficient. Bex v. Monday, Calp. 530. From Magna Charta 9 Hen. Roman 3. C. 3G to 9 Geo. Roman 2. C. 36. Duties of corporations. 457. These statutes are generally called the Statutes of Mortmain. All purchases made by corporate bodies being said to be purchases in mortmain, in morte manu, for the reason of which appellation Sir Edward Coke offers many conjectures, but there is one which seems more probable than any that he has given us, viz. That these purchases being usually made by ecclesiastical bodies, the members of which, being professed, were reckoned dead persons in law, land therefore, holden by them, might with great propriety be said to be held in morte manu, as shall defer the more particular exposition of these statutes of mortmain till the next book of these Commentaries, when we shall consider the nature and tenure of estates, and also the exposition of those disabling statutes of Queen Elizabeth, which restrain spiritual and eleemosynary corporations from alienating such lands as they are at present in legal possession of, only mentioning them in this place, for the sake of regularity, as statutable in capacities incident and relative to corporations. The general duties of all bodies politic, concited in their corporate capacity, may, like those of natural persons, be reduced to this single one, that of acting up to the end or design, whatever it be, for which they were created by their founder. 3. 1. Proceed therefore next to inquire, how these corporations may be visited. For corporations, being composed of individuals subject to human frailties, are liable, as well as private persons, to deviate from the end of their institution. And for that reason the law has provided proper persons to visit, inquire into, and correct all irregularities that arise in such corporations, either sole or aggregate, and whether ecclesiastical, civil, or eleemosynary. With regard to all ecclesiastical corporations, the ordinary is their visitor, so constituted by the canon law, and from thence derived to us. The Pope formerly, and now the sovereign, as supreme ordinary, is the visitor of the archbishop or metropolitan. The metropolitan has the charge and coercion of all his suffragan bishops, and the bishops in their several dioceses are in ecclesiastical matters the visitors of all deans and chapters, of all parsons and vicars, and all other spiritual corporations. With respect to all lay corporations, the founder, his heirs or assigns are the visitors, whether the foundation be civil or eleemosynary, for in a laying corporation the ordinary neither can nor ought to visit, I know it is generally said that civil corporations are subject to no visitation, but merely to the common law of the land, and this shall be presently explained. But first, as I have laid it down as a rule that the founder, his heirs or assigns, are the visitors of all lay corporations, let us inquire what is meant by the founder. The founder of all corporations in the strictest and original sense is the sovereign alone, for he only can incorporate a society. And in civil incorporations, such as mayor and commonalty, and c. where there are no possessions or endowments given to the body, there is no other founder but the sovereign. But in eleemosynary foundations, such as colleges and hospitals, where there is an endowment of lands, the law distinguishes and makes two species of foundation, the one fundatio incipiens, or the incorporation, in which sense the sovereign is the general founder of all colleges and hospitals, the other fundatio j perficiens, or the dotation of it, in which sense the first gift of the revenues is the foundation, and he who gives them is in law the founder. And it is in this last sense that we generally call a man the founder of a college or hospital. But here the sovereign has his prerogative. For if he and a private man join in endowing an eleemosynary foundation, the sovereign alone shall be the founder of it. And, in general, the crown being the sole founder of all civil corporations and the endower the proficient founder of all eleemosynary ones, the right of visitation of the former results, according to the rule laid down, to the sovereign, and of the latter to the patron or endower. The sovereign being thus constituted by the law visitor of all civil corporations, the law has also appointed the place wherein he shall exercise this jurisdiction, which is the High Court of Justice, where and where only all misbehaviors of this kind of corporations are inquired into and redressed and all their controversies decided. And this is what I understand to be the meaning of our lawyers, when they say that these civil corporations are liable to no visitation, that is, that the law having by immemorial usage appointed them to be visited and inspected by the sovereign their founder, in his own proper court, according to the rules of the common law, they ought not to be visited elsewhere, or by any other authority. And this is so strictly true, that though King Henry Roman VIII, by his letters patent had subjected the College of Physicians to the visitation of 4 very, and in the Queen's Bench division thereof, as for the time exercising all the powers of the Court of King's Bench. Visitors of corporations. 459 respectable persons, the Lord Chancellor, the 2 Chief Justices, and the Chief Baron, though the college had accepted this charter with all possible marks of acquiescence and had acted under it for nearly a century. Yet, in 1753, the authority of this provision coming in dispute, or an appeal preferred to these supposed visitors, they directed the legality of their own appointment to be argued. And, as this college was merely a civil and not an eleemosynary foundation, they at length determined, upon several days' solemn debate, that they had no jurisdiction as visitors, and remitted the appellant, if aggrieved, to his regular remedy in the Court of King's Bench. As to eleemosynary corporations, by the dotation the founder and his heirs are of common right the legal visitors to see that such property is rightly employed, as might otherwise have descended to the visitor himself. But if the founder has appointed and assigned any other person to be visitor, then his assignee so appointed is invested with all the founder's power in exclusion of his heir. Eleemosynary corporations are chiefly hospitals or colleges in the universities. These were all of them considered by the clergy as of mere ecclesiastical jurisdiction. However, the law of the land judged otherwise, and with regard to hospitals, it has long been held that if the hospital be spiritual, the bishop shall visit, but if lay, the patron. This right of lay patrons was indeed abridged by statute 2 Hen. v. c. 1, which ordained that the ordinary should visit all hospitals founded by subjects, though the right of the crown was reserved to visit by his commissioners such as were of royal foundation. But the subjects' right was in part restored by statute 14 Eliz. c. 5, which directs the bishops to visit such hospitals only, where no visitor is appointed by the founders thereof, and all the hospitals founded by virtue of the statute 39 Eliz. c. 5 are to be visited by such persons as shall be nominated by the respective founders. But still, if the founder appoints nobody, the bishop of the diocese must visit. Colleges and the universities, whatever the common law may now, or might formerly judge, were certainly considered by the clergy under whose direction they were as ecclesiastical, or at least as clerical, corporations, and therefore the right of visitation was claimed by the ordinary of the diocese. This is evident because in many of our most ancient colleges, where the founder, Yearbook 8 Edwa, Roman 3, 28, 8s, 29, had a mind to subject them to a visitor of his own nomination, he obtained for that purpose a bull to exempt them from the jurisdiction of the ordinary, several of which are still preserved in the archives of the respective societies. And in some of our colleges, where no special visitor is appointed, the bishop of that diocese, in which Oxford was formerly comprised, has immemorially exercised visitatorial authority, which can be ascribed to nothing else but his supposed title as ordinary to visit this, among other ecclesiastical foundations. And it is not impossible that the number of colleges in Cambridge which are visited by the Bishop of Ely may in part be derived from the same origin. But, whatever might be formerly the opinion of the clergy, it is now held as established common law that colleges are lay corporations, though sometimes totally composed of ecclesiastical persons, and that the right of visitation does not arise from any principles of the canon law, but of necessity was created by the common law. And yet the power and jurisdiction of visitors in colleges was left so much in the dark at common law, that the whole doctrine was very unsettled till the famous case of Phillips and Barry. In this the main question was, whether the sentence of the Bishop of Exeter, who, as visitor, had deprived Dr. Barry, the rector of Exeter College, could be examined and redressed by the Court of King's Bench. And the 3 puisne judges were of opinion that it might be reviewed, for that the visitor's jurisdiction could not exclude the common law, and accordingly judgment was given in that court. But the Lord Chief Justice Holt was of a contrary opinion, and held that by the common law the office of visitor is to judge according to the statutes of the college, and to expel and deprive upon just occasions, and to hear all appeals of course. And that from him, and him only, the party aggrieved ought to have redress, the founder having reposed in him so entire a confidence that he will administer justice impartially, that his determinations are final, and examinable in no other court whatsoever. And, upon this, a writ of error being brought into the House of Lords, they concurred in Sir John Holt's opinion, and reversed the judgment of Lord Rame. A. See Lord Holt's judgment, printed Lord Eaney, 5, 4 Mod. 106, show. From his own MS in 2t. R. 346. 35, Skin. 407, Sulk. 403, Carthew, 180. Are dissolve. 461 The Court of King's Bench, to which leading case all subsequent determinations have been conformable. It is said that if a founder of an eleemosynary foundation appoints a visitor, and limits his jurisdiction by rules and statutes, if the visitor in his sentence exceeds those rules, an action lies against him. But it is otherwise, where he mistakes in a thing within his power. If no visitor has been appointed by the founder, the right of visitation in default of his heirs devolves upon the Crown, and is exercised by the Lord Chancellor, the Queen's Bench division having no jurisdiction over such foundations. 3. We come now, in the last place, to consider how corporations may be dissolved. Any particular member may be disfranchised or lose his place in the corporation by acting contrary to the laws of the society, or the laws of the land, or he may resign it by his own voluntary act. But the body politic may also itself be dissolved in several ways, which dissolution is the civil death of the corporation. And in this case their lands and tenements shall revert to the person or his heirs, who granted them to the corporation. For the law annexes a condition to every such grant, that if the corporation be dissolved, the grantor shall have the lands again, because the cause of the grant faileth. The grant is indeed only during the life of the corporation, which wty endure forever, but when that life is determined by the dissolution of the body politic, the grantor takes it back by reversion, as in the case of every other grant for life. The debts of a corporation, either to or from it, are totally extinguished by its dissolution, so that the members thereof cannot recover, or be charged with them in their natural capacities, agreeably to that maxim of the civil law. Si quid universitate debitor singulis non debitor, ni, quod debet universitas, singuli ddn. A corporation may be dissolved 1. By Act of Parliament, which is boundless in its operations. 2. By the natural death of all its members, in case of an aggregate corporation. 3. By surrender of its franchises into the hands of the sovereign, which is a kind of suicide. 4. By forfeiture of its charter, through negligence or abuse of its franchises, in which case the law judges that the 2 Lepla 1566 233 XP Rangam 2 Ves 619 Re Bex fee 10 Maxter and fee $1 of St. Dowming Co. Uge 2 Mai and CR 642 Catherine Asterisk Hall Cambridge 4T R 462 Corporations. Body politic has broken the condition upon which it was incorporated, and thereupon the incorporation is void, and the regular course is to bring an information in nature of a writ of quo warranto, to inquire by what warrant the members now exercise their corporate power, having forfeited it by such and such proceedings. The exertion of this act of law for the purposes of the state, in the reigns of King Charles and King James Roman II, particularly by seizing the charter of the City of London, gave great and just offence, though perhaps, in strictness of law, the proceedings in most of them were sufficiently regular. But the judgment against that of London was reversed by Act of Parliament registered after the Convolution, and by the same statute it is enacted, that the franchises of the City of London shall never more be forfeited for any cause whatsoever. And, because by the common law corporations were dissolved, in case the mayor or head officer was not duly elected on the day appointed in the charter or established by prescription, it is now provided that for the future no corporation shall be dissolved upon that account, and ample directions are given for appointing a new officer, in case there be no election, or a void one, made upon the prescriptive or charter day. 2L. And Mary C. A. Stat. 11 Geo. IC. 4. 463. Chapter Roman 21. Of Municipal Corporations. Hitherto of corporations in general, among which might formerly have been classed all those boroughs which are now regulated by the Municipal Corporations Form Act. That statute asterisk applies to 178 corporate towns, the remainder including the City of London 68 in number, were not brought within its operation. London, the greatest of all, with its many wealthy trading companies, each a corporation in itself, was said to be reserved for separate legislation. The others, being inconsiderable either in extent or population, continued to be governed by their charters or prescriptive usages, like corporations existing at the common law. The provisions of the statute apply, however, to another, a more important and a more modern class of municipal corporations, those, namely, which have obtained charters of incorporation under the Act itself, which, after reciting that sundry towns and boroughs were not towns corporate, and that it was expedient that several of them should be so, expressly enables the Crown, with the advice of the Privy Council, to grant a charter extending to the householders of the towns referred to, the powers, privileges, and authorities contained in the Act. And under its provisions various charters of incorporation have accordingly been granted, and such charters in some instances afterwards confirmed by Parliament. The origin of our municipal corporations is to be found in the town communities, or municipia, which were first planted in Britain during the Roman occupation, an organization which would seem to have been afterwards adopted by the Anglo-Saxons. See the schedules of the Act 5 and 6. Manchester, Birmingham, Sheffield, Roman 4, c. 76. Field, Bolton, Peterborough. As it certainly formed a part of their great system of self-government, the towns being placed within the administrative care of a Huro or J. Portreve, when the country districts or shires were put under the jurisdiction of the shireve. After the conquest these elective reves were supplanted by a vice-gums in the shires, and a hailif in the towns, officers appointed directly by the sovereign and responsible to him alone. To rid themselves of the oppression of these Norman bailiffs, the towns offered to pay a larger revenue to the exchequer, provided it were collected by themselves, than the king could obtain through his own officer, and in this way repurchased from the crown the right of self-government which they had enjoyed before the conquest. In some cases, the old designation of borough or of port-brevet was resumed by the chief magistrate elected under the newly granted franchise. In most he received the Norman appellation of mayor. In a few instances only was the title of bailiff retained. This newly acquired municipal freedom, so long as the boroughs remained excluded from political existence, was, however, subject to repeated encroachments by the successors of the conqueror, chiefly to obtain pecuniary resources for their contests with the great vassals of the crown. Hence the frequent forfeitures of the borough charters, and in many instances the repeated regranting, on payment of a fine, of the same franchises to the same place. London itself, although from motives of expediency the most favored of all the municipalities, was not exempt from extortion by these arbitrary stretches of power, which ultimately gave rise to that limitation of the prerogative embodied in the Great Charter, expressly declaring that all cities, boroughs, and ports shall have their liberties and free customs. For many years, however, after this first assertion of their independence, the Crown continued to levy talliages on the boroughs in the most oppressive and vexatious manner. And there can be no doubt that the exercise of this prerogative, after burgesses had been summoned to Parliament by Edward I. In many cases, however, perhaps any repudiation by him of the act is in most of them, the renewal of the predecessors, a precaution which seems charters of the boroughs was obtained to have resulted from the unsettled state from the sovereign de facto in pass off the succession to the crown. Cession of the throne in order to prevent. Municipal corporations. 465 contributed, among other causes, to the enactment of the Statute de Tallagio non concedendo 25 Edwa, by which the political existence of the boroughs was solemnly recognized, and the right of taxing them arbitrarily finally relinquished. Asterisk in the great national measure of 1327, which closed the calamitous reign of the second Edward, the representatives of the boroughs appear with the knights of the shires under the general name of commons, by whose counsel and assent, as well as that of the prelates, earls, barons, and other great men, it was stated in the writs issued to the sheriffs by Edward Roman III that his father had removed himself, and that he had taken upon him the government of the realm. And when the commons afterwards declared to this prince that they would not be compelled by any of his statutes or ordinances made without their assent, the king was too mindful of the popular concurrence in the revolution which had deposed his father to oppose this assertion of their newly acquired privilege. The contest between his misguided grandson and successor, Richard Roman II, and the great body of the nation, ended in the complete attainment by the commons of that legislative character, to which they had been tending since their first summons to Parliament, the acquisition of which had the effect of reviving in the municipal bodies by which they were elected that political life which, since the conquest, had been almost extinct. Asterisk for several centuries after the conquest, however, any select body forming, within a municipal town, a corporation, in the modern sense of the term, was entirely unknown. The chief object of the Norman sovereigns in granting to the burgesses the right of electing their own chief magistrate was to obtain, under the penalty of a forfeiture of the franchise, punctual payment of the stipulated rent, and to ensure at the same time in each locality as much internal peace and order as was requisite to enable the community to perform this stipulation with exactness. The municipal body consisted of the resident and trading inhabitants paying scot and bearing lot, that is, sharing in the payment of the local taxes and the performance of local duties. Strangers residing temporarily in the town for purposes of trade had no voice in its affairs, as they incurred no liability to its burdens. Hearth, apprenticeship, and marriage, all titles to borough freedom of very remote antiquity, being so many modes of ascertaining the general condition of established residents. A title by redemption was obtainable by an individual previously unconviol. I. 2h. Connected with the community, in those days when admission to its freedom conferred peculiar advantages of trading, the right of bestowing the freedom by free gift being one necessarily inherent in the community, and for the exercise of which it was not responsible to any authority whatever. For the appointments of its officers, the imposition of taxes, the administration of justice, or the enacting of local laws, the whole community originally met in the Saxon Falmote, called in country districts the hundred, or where held within doors by the Danish name of husting or common hall, but in course of time the affairs of the towns were often left in the hands of a committee of the more wealthy and influential inhabitants, annually elected to assist with their advice the mayor and other officers of the community. These persons were sometimes tempted to seek a continuance of their authority without the necessity of an annual appeal to the popular voice, and even to usurp powers which it had not delegated at all, as early, indeed, as the reign of Henry Roman III. We find the aldermen of London, and those calling themselves the more discreet of the city, endeavoring to elect a mayor in opposition to the popular will, the election, however, ending in the triumph of the latter, in a general folkmote held at St. Paul's Cross. Similar usurpations elsewhere were often vigorously resisted by the community, the contests being sometimes so violent and obstinate as to lead to bloodshed. In course of time, and especially when the representatives of the boroughs had obtained a seat and a voice in Parliament, and in this way made their support essential to the existence of every government, the Crown, so long indifferent to the details of municipal arrangements, found abundant motives for endeavoring to form close ruling bodies, irresponsible to the general community, and in this indirect way to obtain the appointment of the representatives. But this policy was not generally adopted till after the e-formation, although indications of it are to be found in several charters of Henry Roman VII. As in one to Bristol in 1499, establishing a self-elective council of aldermen, the great instruments of the Crown in influencing the composition of the popular branch of the legislature were at first the sheriffs of the several counties returning members, of which, in the time of Edward I there were 37, Durham and Cheshire having then Powhatanay parliaments of their own, and Monmouthshire. Municipal corporations. 467 being part of Wales, which was not yet legislatively incorporated with England, nor even effectively subjected to the English crown. For as the writ addressed to these officers specified no particular city or borough, but required them in general terms to cause to be elected 2 citizens for each city, and 2 burgesses for each borough. In their bailiwick, a discretionary power of determining what towns were qualified to send representatives seems to have rested with them, and this power they no doubt exercised in accordance with their instructions. As we may gather from several statutes evidently passed to restrain, if possible, the indirect influence which the Crow Avon thus obtained in the election of the House of Commons. So sensible, indeed, did the Commons become of the existence of this mode of undermining their independence, that, in the legislative incorporation of Wales and Cheshire with England, a new principle was introduced, that of determining by parliamentary enactment what towns within a particular territory should elect representatives and what number they should elect. This act may be regarded as the first assertion of the right of Parliament to alter the constitution, but the principle was not extended to England, and the prescriptive powers of the sheriffs continued to be exercised in accordance with the royal wishes. In their exercise, however, it soon became necessary to use a discretion. The omission of any town which in public estimation had a prescriptive right to be represented would have been too open an attack on the freedom of Parliament. The calling of this right into action in boroughs wherein it had been dormant, or had fallen into disuse, was a more plausible course of proceeding, and, notwithstanding the evident partiality with which it was conducted, it was permitted to pass without legislative interference. Accordingly, in the reigns of Edward VI, Mary, and Elizabeth, besides 46 boroughs, which now first began to send members, 17 were restored to parliamentary existence, making altogether an addition to the former representation of 63 places, returning 123 members. Not content with this indirect nomination of the representatives, the Crown at this period assumed a new right, that of 5 rich. Roman II. 7 hen. Roman 4. CL 5, 8 hen. VI. C. 7, 10 hen. VI. C. 2, 23 hen. VI. C. 14. Remolding the municipal constitutions of the boroughs by granting governing charters, which vested the local government, and sometimes the immediate election of the parliamentary representatives in small councils originally nominated by the Crown to be ever after self-elected. The success of this attempt encouraged succeeding sovereigns not only to continue the system of erecting close boroughs, but to make a second and a bolder advance in the same direction, by attacking the constitutions of the municipalities themselves. Asterisk already, in Michaelmas term, 40 and 41 registered the judges had given an extrajudicial opinion extremely favorable to the prosecution of this object. Attempts having been made to have popular elections of the principal officers of several boroughs, in opposition to the custom of leaving the elections in the hands of the common councils, a question was raised whether such elections were legal. On the application of the Privy Council, the judges determined that such custom was good, because the several boroughs had power to make bylaws, and where no bylaw was to be found it might nevertheless be presumed to have existed, because such custom must have originated in common consent. Elections of municipal officers by common councils were thus not only declared to be legal, but, where such customs had grown up, the community at large was forever excluded from the elections. This dictum of the judges was followed in 12 Jack I. by the case of the new borough of Dungannon in Ireland, in which it was held that the Crown could vest in a corporation the right of sending burgesses to Parliament, and at the same time restrain the exercise of that right to the select classes. Such was thenceforth the form of all the corporations which were created or remodelled under James I and Charles I. A total addition to the borough representation of 41 members, besides the 4 members for the 2 universities, having been effected in the reign of these 2 sovereigns. I shall not, in this place, attempt any explanation of the legal proceedings by quo warranto, revived on so extensive a scale during the reigns of Charles Roman II and James Roman II, which led to the forfeiture of its franchises by the City of London, and to the surrender of their charters by many of the other municipal corporations of the kingdom. Nor need I further pursue their general history since the Kevolution. The successive govern. The case of the corporations 4 Ep. 77a. 12 Rep. 120. Municipal corporations. 469 men which have held office since that great event have abstained from open interference with the liberties of the corporations, contenting themselves with using the more effective weapons of private corruption, until at last the perversion of municipal institutions to political ends, the sacrifice of local interests to party purposes, frequently pursued through the complete demoralization of the electoral bodies, the alienation of corporate property, and the other abuses arising from the whole powers of the municipal corporations being vested in select bodies, became too flagrant to be defensible. And a remedy was at length applied by the statute already referred to, the general effect of which, as amended by several subsequent statutes, I shall now proceed to explain. The principal objects of municipal government have usually been the appointment and superintendence of the police, the administration of justice both civil and criminal, the lighting and paving of the town, and in a few cases, the management of the poor. The Statute 5 and 6 will. Roman 4. c. 76 did not attempt to extend the number of useful public objects which might be placed under municipal management. It was directed solely to the improvement of the means by which the objects of the old corporations were thereafter to be attained. And the first section of the Act, in repealing so much of all laws, usages, charters, grants, and letters patent, as were inconsistent with its general provisions, left untouched the whole of those local laws which relate merely to the objects of municipal government. But the statute rendered the functionaries of the municipalities eligible by, and consequently directly responsible to, the persons whose interests they are appointed to protect, and created a constituency, which ought, in ordinary cases, to include all those who are interested in the proper performance of their public duties by the municipal officers. The constituents of the old corporations were known by the name of the freemen, and were usually admitted by the ruling body, which was in turn to be elected by the freemen. The patents of George Roman III. Do not missioners on TBE municipal corporatifer in any respect from those granted Tions, 1835. In the worst period of the history of. Report of the Commissioners on the boroughs. Report of the calm municipal corporations, prop finem. 470 corporations. Freedom was obtainable by birth, or by marriage with the daughter or widow of a freeman, or by servitude or apprenticeship. In London, Shrewsbury, and other towns, a previous admission into certain guilds or trading companies was required in addition, but this was generally obtainable by payment of a fine. The rights attached to the freedom, being privileges confined to few persons, were in many cases of considerable value to the possessor, particularly when they conferred a title to the enjoyment of funds derivable from corporation property, or to exemption from tolls or other duties, and they had often been obtained by considerable sacrifices. The rights of the freemen in S were consequently preserved by the statute, which at the same time enacted that no freedom should thenceforth be acquired by gift or purchase, and then proceeded to provide, for the reformed corporations, a constituency of electors, lists of whom are annually made up by the overseers, corrected and published by the town clerk, and revised by the mayor and his assessors in the same manner as the lists of parliamentary electors, the complete list forming the burgess roll of the borough. The qualification of a burgess was originally the occupation of premises within the borough for 3 years, but 1 year is now sufficient. Residence within the borough or 7 miles thereof, and being rated to the relief of the poor, and payment of borough rates, are also required of any person claiming to be enrolled as an elector, the privilege being open to females as well as males. But except the right of electing their representatives in the town council, an election which, following the precedent of elections to Parliament, must now be by ballot, these burgesses have none of the exclusive privileges which were formerly enjoyed by the freemen. One of the most pernicious of these was that of exclusive trading within the limits of the municipality. This was abolished in all the boroughs, and has since been abandoned by the corporation of the City of London. The mayor and aldermen, with the constituency, constitute the corporation, and collectively with the councillors form the town council, to which is entrusted its whole deliberative and administrative functions. The council appoints the town clerk, treasurer, *32 and 33 Vict. C. 55. The Ballot Act, 1872, 38 and 39 Vict. C. 40. And other executive officers, appoints and superintends the police force, and is the local sanitary authority under the Public Health Act, 1875/ in the council is vested the power, which we have seen is incident to all corporations, of making bylaws for the good rule and government of the borough, and the prevention and suppression of all such nuisances as are not punishable in a summary manner. And these bylaws may be made enforceable by such fines, not exceeding 51, as may be thought sufficient for the prevention of offences against them. The exercise of this power of legislation is subject, however, to the approval of one of the Secretaries of State. The council has also the control of the borough fund, any surplus in which, after payment of all necessary expenses and just demands, is to be applied for the benefit of the inhabitants and improvement of the borough. If it be insufficient, a borough rate may be levied. The council may also grant leases of land for building purposes, and further erection of dwellings for working men. But to prevent the partial and fraudulent transactions common in the old corporations, these powers are subject to very considerable restrictions. Other subsidiary and occasional powers are vested in the council, which is thus seen to be effectually the governing body of the corporation. It is necessary to mention, however, one most important check on the exercise of their powers over the funds of the corporation, which was first provided by the statute before referred to, viz. The periodical audit of the accounts of the borough, and their subsequent publication. The frauds by the officers of the old corporations, the division of the funds for the interest of the governing body, their application to the corruption of the freemen in every shape in which money could be applied, formed the chief heads of accusation against those bodies. It was thought, and possibly not without reason, that the uncontrolled disposition of power is conferred on municipal. 37 and 38 Vict. C. 59. Certain municipal corporations and other governing bodies, corporations, including London, have in certain cases to expend T-Lear funds largo powers under the Artisans. And in promoting or opposing bills in Parliamentary Dwellings Improvement Act, Mont by Stat. 35 and 36 Vict. C. 91. 1875. /472 corporations of funds by the new councils might eventually lead to similar abuses. The statute, therefore, provides for the appointment of auditors, persons qualified to be councillors, but not actually of that body, lest identity of interest might lead to partiality in the exercise of their functions, and by them the accounts of the borough are to be audited half-yearly, a full abstract of the accounts for the year being afterwards printed and published, a copy of which is obtainable by any of the ratepayers. No person is eligible as a councillor unless qualified, so far as regards the occupation of premises and rating, to be on the burgess list, trademark, and no minister of religion can in any case be elected a councillor. 1/3 of the body is elected annually on the 1st of November, when 1/3 of the members, those longest in office, go out. The mayor is chosen from among the councillors and must serve the office or pay a fine of LOOZ. He presides at the meetings of the council and has precedence in all places within the borough, but he has few other exclusive functions or privileges. He also presides with the assessors at the election of councillors, and during his continuance in office is a justice of peace for the borough, and continues such for the succeeding year. In boroughs returning members to Parliament he is the returning officer. The aldermen seem to be little more than councillors having a title of precedence. They are elected by the council itself from the councillors, and consist of 1/3 of the number of councillors. An alderman, who holds his office for 6 years, cannot be elected coroner or recorder, and is exempted from serving on juries. The towner preserves the minutes of the transactions of the council and makes out and publishes the burgess and ward lists. He is responsible for the safe custody of all charters, deeds, and records, is subjected to various fines in case of neglect of duty, and is disqualified from acting as auditor. The treasurer is appointed by the council, of which he cannot be a member, and he must give security for the discharge of his duties and keep accounts of all receipts and disbursements, which are not only open to the inspection of the aldermen and councillors, but must be submitted half-yearly to the auditors, 2 in number, elected by the burgesses annually, on the 1st of March. From the persons. An alderman or councillor must be resident within 15 miles, but need not be on the burgess roll. Municipal corpo if eolons. 473 qualified to be councillors. The quassel also appoints the inspectors of weights and measures. Asterisk the most important alterations made by the Statute 5 and 6 will, Roman 4, c. 76, were thought to be those which related to the administration of justice. In certain boroughs the Crown is empowered to appoint as many persons as may be thought proper to be justices of the peace, and these justices are not required to have any qualification by estate. The council, when a commission of the peace is granted to the borough, provides the requisite police officers, but the justices themselves appoint their own clerk. The town council may, however, on voting a suitable salary, have 1 or more stipendiary magistrates appointed by the Crown, and on complying with certain preliminaries as to the jail and the salary of the judge, may also obtain a separate court of quarter sessions, for which the Crown appoints a recorder, who is the sole judge of the court. The recorder, when appointed, may either act as judge of, or appoint a judge for, the civil court of the borough, if there is one, but the appointment of the clerk of the peace is in the council. These judicial appointments were given to the Crown, in order, it was said, that the administration of justice might be above the suspicion of being tainted by party or local interests, but the exercise of the patronage thus conferred on the Home Secretariat and not hitherto given satisfaction either to the boroughs themselves or to the bar, from which these legal functionaries are usually chosen. And it is not improbable that the town councils may endeavour to recover that right of appointing their local magistrates, which from the earliest times was enjoyed by the municipalities, and in the opinion of many ought never to have been taken from them. These municipal corporations, it will be observed, possess some peculiar powers and are subject, on the other hand, to some peculiar restrictions not applicable to corporations in general, an observation which will apply to another species of corporations, possessing many of the municipal functions usually entrusted to the town councils of boroughs. I refer to the numerous local hordes which, by special legislation, are invested with extensive powers for the conservation of the public health, and are for that purpose enabled to provide for the effective drainage of the towns or other corporations. Populous places over which their authority extends, the removal of nuisances arising within their districts, the regulation of new buildings, the construction of streets, the supply of water, and many other matters of local importance, too numerous to mention. These corporations are either urban or rural sanitary authorities, and they have perpetual succession and a common seal and most of the usual powers of corporations. These may be regarded, indeed, as a development of that system of local government which has hitherto been represented by our municipal corporations, and which it is the tendency of modern legislation to extend. Chapter Roman 20. Trading corporations. I have reserved for separate consideration that class of corporations which consists of individuals associated together for the purposes of trade or business, and with a view to individual profit. Besides this last distinctive mark, which is not to be found in any of those corporate bodies, the nature of which has been already explained, those I am now to treat of possess other peculiarities equally deserving of notice. The system of association to which I allude, and which has received such gigantic development in modern times, is by no means of recent origin. Institutions founded on the same principle as the trading guilds of the Middle Ages seem to have existed among the Saxons, though the particulars relating to such associations which have come down to us are so extremely scanty that we can form no precise idea of their object. We can only conjecture that at that early period it must have been mutual aid and defense against the violence and encroachments of princes or marauding adventures rather than the increase of profits by means of conjoint enterprise or united capital. Soon after the conquest, however, we find guilds of different trades established in the various seaports and other towns of importance in the kingdom. These fraternities generally became in course of time charter corporations, each possessing its common hall, making bylaws for the regulation of its particular trade, and disposing of its common property. What constituted the bond of union £pound is the exclusive privilege possessed by its members of following the particular occupation, which the company professed to protect. In this position these communities seem to have continued till about the time of the Reformation, when they mostly became merged in the municipal corporations, the franchises of which could in many cases be enjoyed by those only who were free of one or other of the companies. Corporations, into which the community is divided. For these companies, as they were generally taxed after the Norman era, hadn't contrived to obtain from the *5m not only exclusive privileges of trading, but also exemptions from tolls and dues to which merchants generally were subject, it was a matter of great importance to a trader to belong to one of them. In most cases, indeed, it was impossible for him to carry on business at all, without being entitled by such membership to enjoy the franchises thereby obtained. It is somewhat curious at the present day to contemplate the state of trade even in times of such comparative enlightenment and activity as those of the 3 Edwards. Every transaction was the subject of strict regulation, the extreme jealousy which prevailed between the different trading communities not only affording abundant pretext for the imposition of restrictions by the ruling powers, but necessitating a constant change in the measures adopted towards each of them separately. Of this capricious legislation the foreign merchants, notwithstanding the express declaration of the Great Charter, seem to have been the principal objects, and, as a natural consequence, early formed themselves into compact bodies, with a distinct locality and existence, precisely as is the case with our traders at the present day in the ports of China, or the Dutch in the harbors of Japan. In 1220 the merchants of Cologne had a hall in London, afterwards known as the Guild Latitudinicorum, or General Company of Germans, called also the Merchants of the Hanse, a fraternity which in the 15th century became the Company of the Steelyard, that being the name of a tenement granted to them by authority of Parliament in the 14th year of Edward Roman IV. Steelyard wares long continued to be a general expression for the class of goods imported by this company, of as wide a signification comparatively as Manchester wares at the present day. In 1505 a rival company, called the Merchant Adventurers of England, for trading in woolen cloths to the Netherlands, obtained a charter of incorporation prohibiting the merchants thus in 1275 the foreign merchants to come safely to all that were ordered by Edward I, to sell all their dominions of the crown with all kinds goods within 40 days of their arrival, of merchandise. And their residence in England was for the existence of this association bidden, except by the special license of can be traced to the end of the 13th the king. In 1303 the same monarch's century, it originated in an association granted a charter, permitting foreign of English merchants for trading in Trading Corporatios, 477 of the Steelyard from interfering with new rivals. Violent disputes raged between these fraternity, and the company of the Steelyard seems to have gradually declined. In the 16th century, the discoveries of the Portuguese and Spaniards roused the spirit of mercantile adventure among the English, and joint stock companies sprung up, whose first object was to obtain a charter, giving the adventurers the exclusive right of enjoying the advantages to be derived from the discovery of new countries or the opening of fresh sources of trade. Thus in 1553 some merchants of London, together with several noblemen, established a company under the title of the Merchant Adventurers, for the discovery of lands, countries, isles, and sea. Not before known by the English. This adventure resulted in the establishment of a trade with Russia. The company subsequently obtained several acts of Parliament, and still elects its officers. 20 years later, the Turkey Company obtained a charter, giving them a monopoly of the English trade with the Ottoman Empire. This association ceased to exist in 1825. An African company was formed as early as 1530, the trade at first being open. The Eastland Company, consisting of merchants trading to the ports of the Baltic, was incorporated in 1579, with a view of encouraging an opposition to the Hanse merchants. The origin and progress of the East India Company is a part of our national history. Of all these old trading associations, the Hudson's Bay Company, incorporated in 1670, alone remains on its ancient footing. Soon after the Revolution, the principle of association began to be applied to a variety of purposes besides those of foreign adventure and trade. Numerous projects were started, the execution of which could not be compassed by private means, but which it was thought might be attained by raising capital on the joint stock principle. Hence arose, in the early part of the 18th century, the speculative mania, the frauds and panics, foreign parts called the brotherhood of caged in any kind of commerce. St. Thomas of Canterbury, a title which the merchant adventurers traded, may seem somewhat curious at the largely with the Low Countries, having sent day. It must be recollected how for this purpose a large establishment at Ever, that until 1344 the Cistercian Antwerp, in the reign of Elizabeth monks, taking advantage of the exempt their annual shipments of cloths were done of ecclesiastics from customs duties of the value of 80 yen. The company were the greatest wool merchants and entertained the Emperor Charles V. on kingdom. In that year ecclesiastical his triumphal entry into Antwerp and persons were prohibited from being in 1520 corporations, which are remembered in connection with the famous South Sea Company, and of Wiki. We have seen the counterparts more than once in our own Tixuks. To meet the evils occasioned by this novel development of the associative tendency, the famous Bubble Act 6 Geo. I. C. 18 was passed, declaring all companies which presumed to act as corporate bodies and to raise or pretend to raise transferable stock, public nuisances, and the promoters of them punishable accordingly. This statute was directed not so much against the theoretical offense of acting as a corporation without legal authority, as with a view to prevent the frauds of unprincipled adventurers, who proposed schemes merely as baits to extract money out of the pockets of the thoughtless, but such an object is not to be effected by mere legislation. The gambling in stocks and shares which seems to be periodically revived among us and which, in 1719, produced the Bubble Act, only came to an end during the crash following inevitably the wild speculation which led to the statute. But the Act, nevertheless, had some effect in restraining for the future projects of a similar character to those against which its provisions were directed. During the last century a large number of useful public undertakings, such as the making of canals, bridges, harbors, docks, and the like, have been carried into effect by companies formed on the joint stock principle and incorporated by Acts of Parliament, and more recently our gigantic system of intercommunication by railway has been obtained in a similar way. In these undertakings, the assistance of the legislature was necessary, not so much to give a corporate existence to the association of capitalists who joined in the schemes, for this might have been obtained by a royal charter, as to enable the company to carry out the project for which it was formed, by the compulsory purchase of property necessary for the purpose, and to make bylaws binding on the public for protecting the rights and interests of the corporation. These companies, like the old trading associations of an earlier period which have been referred to, partake of the peculiar advantages derived from incorporation, advantages in which mere associations of die. This act was repealed by the Porate body, being a usurpation of a statute 6 Geo. Roman 4. C. 91. Royal franchise is an offence at common. There seems to be no doubt that law. Duvergier v. Fellows 5 Bing. 267. Acting or presuming to act as a core. Trading corporations /479 individuals joined together to promote such FMON objects cannot possibly participate. A mere assembly PV of adventures cannot, for instance, by any agreement among .if/l themselves, sue or be sued in the name of any one of their body, or of any officer they may select for the purpose. They are liable, on the contrary, to the same laws as ordinary partnerships, and each individual is responsible to his last shilling for the acts and omissions, the contracts and debts of the body generally. To facilitate the operations of such associations, many of which have been framed in recent times with the most laudable objects under the name of joint stock companies, various statutes have been passed, but owing to the fluctuation in opinion regarding the true policy to be pursued towards such associations, the legislation relating to them has not been altogether consistent. The original mode of forming a joint stock company was by means of a deed of settlement, which constituted trustees of the partnership property, directors of the partnership affiliates, auditors of its accounts and other officers, defined the number of shares into which the capital was divided, and the form and mode of transferring them, and laid down rules for periodical meetings of the shareholders. In the absence of legislative interference, the rights and liabilities of the members of such bodies, in relation to the public, were the same as those of other members of ordinary partnerships. Their rights and liabilities inter se depended on the provisions of the deed of settlement. The difficulties which were soon found to arise in carrying on the business of such undertakings induced the earlier joint stock companies to obtain private acts of Parliament, which usually enabled the company to sue and be sued in the name of the secretary or some public officer appointed for the purpose, and almost invariably concluded with the proviso that nothing therein should tend to incorporate the partnership, for one effect of incorporation would have been to destroy the individual responsibility of the members for the acts of the association, which the legislature until quite recently most carefully retained. As joint stock companies, however, increased in number and in usefulness, the cost and trouble necessary to obtain a private act of Parliament were felt to be extremely burdensome, and the attention of Parliament being called to the subject, it was thought expedient by the legislature to empower the Crown to grant to joint stock companies such powers as were likely to be most useful to them, without, however, corporations conferring all the inguarentias of a corporation. The first attempt at legislation in this didaction was not a very happy one. The Statute 6 Geo. Roman 4. C. /RX.L enabled the Crown, in any charter of incorporation thereafter to be granted, to provide that the members should be individually liable for the debts, contracts, and engagements of the corporation. This act proved almost inoperative, and subsequently another mode of proceeding was tried by the Statute 4 and 5 Will. Roman 4. C. 94. Which enabled the Crown by letters patent to grant to joint stock companies the privilege of bringing or defending actions in the name of any of their officers. This act does not seem to have been of much greater use than its predecessor, and accordingly it was repealed, and another attempt made in the same direction by the Statute 7 Will. Roman 4. And 1 Vic. C. 73. Though this act seems to have been more calculated to meet the public exigencies than those preceding it, very few applications were made for charters under its provisions, and at length the Statute 7 and 8 Vict. C. 110 was passed for the registration, incorporation, and regulation of all future joint stock companies not requiring nor obtaining a charter or act of Parliament. This statute introduced a system of public registration, by which the company became incorporated, for the purpose of carrying on the business for which it was formed, according to the provisions of its deed of settlement. But every shareholder remained liable individually for the debts and contracts of the company, and might be proceeded against as though he were not a member of the corporation. Companies formed for the purpose of carrying on the business of bankers were excepted from the operation of this statute, the Act 7 and 8 Vict. C. 113 being passed at the same session of Parliament for their special regulation. A great many joint stock companies were formed, and by registration obtained the corporate privileges, which they were enabled to do under the provisions of the Statute 7 and 8 Vict. c. 110. It was not long, however, before the affairs of several became involved, and the difficulties which then presented themselves in attempting an adjustment of the rights and liabilities of the shareholders led to what becomes celebrated as the Winding Up Acts, 11 and 12 Vict. c. 45, and 12 and 13 Vict. c. 108, which for several years exercised the acumen of the judges of the Court of Chancery in a series of hopeless attempts to interpret and follow out their provisions. The effect of the flood of litiga. Trading corporations. Asterisk 481 Tian carried on under these acts was to thw a very strong light upon the principles of legislation applied to joint stock companies, and the knowledge was purchased at an enormous expense, which ultimately led to the repeal of the Registration and Winding Up Acts and to a consolidation of the laws relating to joint stock companies, the principle of limited liability, or the restriction of the responsibility of each member to the amount of the capital subscribed by him, which had long been conceded to companies incorporated by Act of Parliament, without baneful effects to the Commonwealth, being extended to all joint stock companies who chose to adopt it. Asterisk I have thus cursorily traced the history of trading corporations from the earliest period of our history down to the present time. To sum up all, it appears that there now exist 4 classes of joint stock companies, the result of that partial and progressive system of legislation which is characteristic of our national genius, and these, for the sake of clearness, I shall now proceed to describe in their order, viz. 1. Trading companies incorporated by special acts of Parliament. This class includes railway, dock, harbor and canal companies, a great many insurance companies, and a vast number of other bodies engaged in every species of profitable employment. Formerly each company thus incorporated was governed by the peculiar provisions of the Act which it obtained, and as these varied considerably, uncertainty and confusion often arose. In order, therefore, to introduce uniformity with respect to companies thus established, a general act, applying to all companies to be thereafter incorporated by Act of Parliament, was passed under the title of the Companies Clauses Consolidation Act 8 and 9 Vict. c. 16, which embodies all the clauses which had usually been inserted in special acts of Parliament establishing public companies, and contains a complete code for the regulation of the proceedings, the transfer of the shares, and the general management of companies thus incorporated. Another act, called the Lands Clauses Consolidation Act 1845, was passed at the same time, consolidating all those provisions which it had previously been necessary to insert in the special act of any company which required powers of acquiring land compulsorily for the purposes of the undertaking. Asterisk. Since amended by the Statute 2.s and 24 Vict. c. 106. Vol. I. 2I. The peculiar character of railway undertakings rendered a third act necessary especially applicable to them. This was the Railways Clause Consolidation Act 1845, which laid down regulations as to the construction of railway works, the amount and mode of enforcing the payment of tolls and fares, and the making of bylaws for the conduct of their business *, which are binding upon all persons whatsoever. Besides this general act, which applies only to railway companies established after its passing, there are various other statutes connected with the general working of railways by which certain conditions are attached to their construction and working, and their traffic regulated, and general controlling powers vested in the Board of Trade. Other acts provide for their being wound up and facilitate their abandonment. 2. A second class of joint stock companies are those established under the Statute 1 Vict. c. 73 or the preceding Act 6 Geo. Roman 4. c. 91, which have been already referred to. Very few companies of this class exist, the powers which may be conferred under these statutes not having been found to meet the exigencies of public enterprise. But they may be registered under the Statute 25 and 26 Vict. c. 89, and in this manner place themselves in the same position as companies formed under that Act. 3. Banking companies formed since 1844 constitute a distinct class, which were, until its repeal, regulated by the Statutes 7 and 8 Vict. C. 113. They also may be registered under the Statute 25 and 26 Vict. C. 89, which is generally known as the Companies Act 1862, by which are now regulated 4. The last and most numerous class of our trading corporations, as no partnership, for carrying on the business of banking consisting of more than TRNI persons, and no partnership for any other business consisting of more than 20 persons, is recognized by law unless it be registered as a company under that Act *risk which enables any 7 or more persons associated for any lawful purpose, by subscribing a memorandum of association, and otherwise complying with the requisitions these bylaws must, however, not Great Western Railway Co. 10x. 15. Be repugnant to the provisions of the amended by the Companies Act, Acts affecting railways. See William v. 18G7. Joint Stock Company 483K of the statute in respect of registration, TSJBRM themselves into a company with or without limited liability. This registration is obtained by delivering to the Registrar of Joint Stock Companies a memorandum of association stating the name, place of business, objects, amount of capital and liability of the members of the company, and certain articles of association in a prescribed form. Upon registration being effected, the subscribers of the Memorandum of Association, together with such other persons as from time to time are admitted to be shareholders in the company, become a body corporate by the name prescribed in the Memorandum of Association, having a perpetual succession and a common seal, and power to hold lands to a certain extent, and with consent of the Board of Trade to any extent whatever. The company may hold itself forth to the public as one of which the members are liable either with or without limit, according as the founders of it choose to adopt the principle of limited liability or not. But when the liability of the shareholders is limited by the Memorandum of Association, the word limited must be the last in the registered title of the company and must be inseparably attached to its name. The liability of the directors or managers of such a company may by the Articles of Association be declared unlimited. * The statute requires, under penalties for disobedience, that a register of shareholders shall be kept, with particulars of their shares and the amount paid on them, and that this list be annually revised, and a copy furnished to the Registrar of Joint Stock Companies. This copy is open to public inspection, so that all the particulars of importance respecting the constitution of the company can be at any time ascertained by persons dealing with it. The statute prescribes minutely what contracts of the company shall be under its common seal, and in what contracts it may be bound by the acts of any person acting under its authority. Its local habitation is the registered office, to which it is required to fix its name conspicuously painted or engraven, and to this place all communications to the company must be addressed. The affairs of these registered companies are liable to examination by inspectors appointed by the Board of Trade, upon application of the S.H. holders, and the statutes which regulate them contain a complete code of procedure for winding up a company unable to meet its engagements, or which it is thought desirable to wind up for other reasons. Upon a company formed with limited liability being wound up, no contribution can be required from any shareholder beyond the amount, if any, remaining unpaid on the shares held by him. In the winding up of other joint stock companies, a person, who has ceased to be a holder of shares for 1 year or upwards prior to the commencement of the winding up proceedings, is not liable to contribute for payment of the debts and liabilities of the company, nor, in any case, in respect of any debt or liability contracted after he ceased to be a member. No past member can be called upon to contribute, unless the existing members are unable to satisfy the claims against the company, but every person concurring or carrying on the business of the company when the number of the partners is less than 7, is severally liable for its debts. This species of corporation may be dissolved by being wound up either voluntarily or compulsorily. A voluntary winding up may take place whenever the period, if any, fixed for the duration of the company expires, or the event, if any, occurs upon which it is to be dissolved, or whenever the company has passed a special resolution requiring its winding up. A company may be wound up compulsorily by virtue of a special resolution to that effect whenever it does not commence business within a year of its incorporation, or suspends business for a year, whenever the shareholders are less than 7 in number, whenever the company is unable to pay its debts, or when in the opinion of the court it is just and equitable that it should be wound up. And a company is to be deemed unable to pay its debts whenever a creditor for 501 has served a demand of payment, and the company has for 3 weeks neglected to pay the claim, or to secure or compound for it to the satisfaction of the creditor, or whenever an execution is returned unsatisfied, in whole or in part, or when it is proved to the satisfaction of the court that it is unable to pay its debts. The proceedings for winding up a company take place in the joint stock companies. 485 for Chancery Division of the High Court of Justice, but may be transferred to the Court of Bankruptcy of T&E district in which the registered office of the company is situated. In the case of mining companies, in the stannaries, where the principle of limited liability has long existed in partnerships carried on according to certain local customs, known as the cost-to-JC system, the tribunal is the court of the vice warden, unless the proceedings are transferred by him to the Chancery Division of the High Court. And thus much of corporations existing at the common law, of the municipal boroughs as regulated by the numerous statutes applicable to them, and of joint stock companies the 3 general heads under which corporations may most conveniently be ranked. This audiobook was created by the Mental Chemist for Personal Study and Education, copyright 2025.